represented New York's 12th congressional district. She was the first Black woman to be elected to Congress, the first Black woman to be named here to the House Rules Committee. And she even went on to become the first Black person ever to seek the nomination for president from one of the major two political parties. She said upon her election to Congress that I have no intention of just sitting quietly and observing. And she did anything but sit quietly. She fought against the war in Vietnam. She fought against out of control military spending. She fought for racial equality. She fought for our kids, for school lunches, for fairness. And I go on and on and on. And they didn't call her Fighting Shirley for nothing. She did what was right, even if it wasn't always popular. And I hope that this artwork inspires everyone who enters this hearing room to do what Shirley Chisholm did, fight to make our values and priorities right side up again. So anyway, having said that, I want to now get to our business here today. We're considering three measures. First is HR 4445. And as you know, we know that sexual harassment is all too common in the workplace. Roughly 60% of women say they've experienced things like unwanted sexual attention, crude conduct, sexist comments, or worse while on the job. Sad reality is that the true number is likely even higher, since these incidents often go unreported. And unfortunately, many women today don't have a choice on how to pursue accountability. Right now, survivors of sexual assault and harassment are forced into the secretive process of arbitration, a process that strips them of the rights available in a court of law. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act will change that. It is a bipartisan bill that will end these forced arbitration provisions for sexual assault and harassment claims so that survivors can pursue their cases in a court of law. Second is HR 3485. All around the world today, if you're not straight, you can face discrimination, violence, and even death just because of who you are and who you love. That's not an exaggeration. Same-sex relations are a crime in 68 countries, more than a third of the United Nations member states, and they are punishable for death in up to 9 countries. Truly horrifying statistics. The Global Respect Act will build on current sanction laws and the work of the Biden administration. It will advance the human rights of LGBTQ people around the world and deter future human rights violations. This bill is bipartisan, it is bicameral, and I hope that we get it to the president without delay. Third is HR 4521. This bill is the product of many hours of work across many committees. It's a bold bill, it's comprehensive, and it will strengthen America's competitiveness. This package will accelerate U.S. production of semiconductor chips, strengthen the supply chain to make more goods in America, supercharge our research capability, and advance our global competitiveness. I'm especially proud that it will do all of that while supporting strong labor standards and human rights. I want to highlight just a few of the priorities that are included here, including the reauthorization of the Global Magnitsky Human Rights Accountability Act. This is a bill that I co-authored to empower the president to deny U.S. visas and freeze U.S.-based assets of human rights abusers and corrupt foreign officials. Language I authored that bans the U.S. export of tear gas, pepper spray, grenades, and other crowd control equipment to the Hong Kong police. This will put our nation squarely on the side of the millions of people from all walks of life who are standing up to the most powerful authoritarian government in the world. Provisions that condemn the Chinese government's atrocities against the Uyghurs. And lastly, it legislates refugee protection programs for these two at-risk populations. As we're going to hear today, there's a lot to like not only about this bill, but each of the bills we are considering today. But before we hear from our witnesses, let me first turn to our distinguished ranking member for any comments that he wishes to make.
Thank you very much, Mr. Chairman. And let me begin on a note of bipartisanship by associating myself with your remarks about our former member of the House, Shirley Chisholm. We probably didn't agree on a lot of issues, but I liked her attitude. I remember watching her as a young person in Congress. I'm looking at her portrait now, a portrait I've passed many times from the Rules Minority Office as I come up here, and I just like the approach. I just like the no nonsense attitude, the courageous speaking of truth to power. And again, whether you agreed with her on every issue or not, I think you had to appreciate her as a human being and the manner in which she used the position which she was entrusted to hold by her constituents. And it was a model for all of us in terms of how we can and should represent the things that the people that voted for us sent us up here to do. So again, that's a disagreement perhaps on policy in many places, but not a disagreement on approach or attitude. But she was a figure to be admired. I appreciate you making the remarks that you made. I have a formal statement. I'm going to get to that in a minute, but I'm going to be a little less complimentary on the China bill. I want to just say for the record, this is the most egregious violation of process I have ever seen in my time here. There's not been a single hearing on that bill. It's going to spend hundreds of billions of dollars. It's got some things I like in it. It's got some things I don't like in it. But the fact that it's coming before the Rules Committee without ever a hearing, that it's cobbled together in the Speaker's office, not only have the Republicans been cut out of this process, frankly, your own chairman have been cut out of this process. We might as well disband as a body and just turn over our job to the Speaker. So I don't think there's going to be a lot of Republican support for this because of the manner in which it was done. Quite honestly, this is something that could have been and should have been bipartisan. The Speaker's chosen to make it partisan, and she's chosen to do it in the most, I think, disrespectful way of the institution she presides over. So, again, we'll have a lot more to say about that in the course of what I suspect will be a rather long hearing. But count me as a pretty firm no on that legislation. Let me, Mr. Speaker, excuse me, Mr. Chairman, I'd be delighted if you were the Speaker, but you are the Chairman, courtesy of the Speaker. And again, want to always extend you the courtesy that you deserve. Our hearing today covers three items, Mr. Chairman. The first I'll address is H.R. 3485, the Global Respect Act. This bill would allow the president to impose sanctions on individuals responsible for human rights abuses committed against LGBTQ individuals, including making such individuals ineligible for visas and admission to the United States. I understand that Republicans on the Foreign Affairs Committee have concerns about this legislation, including Democrats' failure to include religious freedom protections. The bill may also be duplicative of the Global Magnitsky Human Rights Accountability Act, which you mentioned, Mr. Chair, which already provides procedures for imposing visa restrictions and other sanctions on human rights abusers, regardless of their motivation for committing those abuses. In fact, it's my understanding the State Department already uses this authority, appropriately in my view, against those who target LGBT individuals. I look forward to hearing the testimony of our witnesses today, whom I hope will shed light on these and other concerns. Our second item is H.R. 4445, the Ending Forced Arbitration of Sexual Assaults and Sexual Harassment Act of 2021. This legislation makes pre-dispute arbitration agreements unenforceable when the case is related in some way to an allegation of sexual harassment or assault. I stand with the victims of sexual assault and sexual harassment. I think we all do. They deserve justice and the right to tell their story, or not, however they wish. Unfortunately, this legislation is written in such a fashion as to raise very real policy concerns and in a way that makes this legislation nothing more than a handout to trial lawyers. I hope these concerns would have been addressed in the committee process. Unfortunately, no Republican amendments were agreed to, even those offered by members who supported the legislation and were seeking to improve it in a targeted and meaningful way. It's unfortunate that we cannot spend a bit more time working on this legislation because I do believe there are changes that, if made, would improve the bill and garner much more bipartisan support. Additionally, I would note that this legislation only addresses arbitration, not confidentiality agreements. Under current law, arbitration is already only enforceable when it's entered into voluntarily. Agreeing to pre-dispute arbitration in contract negotiations in no way prevents victims from seeking justice from law enforcement and publicly telling their story. I know my colleagues on the Judiciary Committee have meaningful perspectives on this legislation, and I look forward to their testimony. Lastly, our third item is H.R. 4521, which has come to us as the America Competes Act of 2022. This bill is purportedly the companion bill of the United States Innovation and Competition Act, which passed the Senate in June. Unfortunately, today's legislation is a real missed opportunity, both for the House of Representatives and the nation. Communist China continues to pose significant challenges on the international stage. These challenges include, but are not limited to, China's ongoing genocide against its Uyghur Muslim minority, uh, China's threat to Taiwan, its democratic neighbor, China's ongoing adventurism in the South and East China Sea, China's unfair trade practices, including currency manipulation and the use of subsidies to undercut American businesses, and China's relentless quest for natural resources worldwide. These and other practices present clear challenges to the United States and the global community. As such, Democrats and Republicans and the Senate should have spoken together with one voice on a bipartisan bill with real teeth that repositions the United States to confront China's lust for hegemony. But instead of doing so, Democratic leadership has once again decided to put forward a partisan bill drafted behind closed doors in the Speaker's office. While portions of the package may have been marked up in the committees of jurisdiction and other forms, the entire package has not received a markup before it came to us today. Democratic leadership has also failed to even ask for any Republican input on putting it together. It's simply unacceptable. And it's an opportunity where we could have worked together, for frankly, there are common interests, but the manner in which the majority's chosen to proceed on this almost ensures total Republican opposition. And frankly, if your own members who were shut out of this process were allowed to vote their convictions, I think many of them would have serious concerns about the bill and the process by which it was put together. What's most disturbing is that the package before us consists of toothless policies that will do nothing to stem China's global lust for power. No new policy provisions to combat Chinese military ventures, no new economic policies to reposition America to better compete. Instead, we get a laundry list of requests for a quote strategy, unquote, and requirements to file quote reports, unquote, none of which will actually address the real problem. It's easy to see what Democratic leadership is up to. Knowing what could be coming in November, an electoral defeat caused entirely by the ongoing extreme partisanship of Democrats in Congress and the White House, majority is using today's bill as its last ditch effort to attach controversial progressive policies that could not pass Congress on their own to critical legislation, all in the guise of addressing the challenges posed by communist China. It's disappointing that this is so, and disappointing that the House will miss an important opportunity to take a real bipartisan stand on the threat to the global order posed by China. This is a real problem, Mr. Chairman. It calls for real solutions that both parties can work on and support together. Unfortunately, those real solutions are not in front of us today. And I hope the House will consider a different path. Because in the end of the day, we can come together on a lot of items that I think would make a material difference. But doing this at the last minute with no committee hearings, with no minority input, is simply the wrong way to do it. If the aim is to actually come together to confront a global menace, one that we all think is a danger not only to the future of our country, but to the danger of international order. The Senate managed to do that. It's too bad the House didn't. And again, I regret this missed opportunity, and I regret this hastily assembled legislation, which again spends hundreds of millions of dollars, goes outside the normal budget order. Has not gone through any remotely normal committee process, and is now presented to us as a multi-hundred-page bill at the last minute, again, without the proper procedure. So if we're going to proceed this way, we're going to end up divided on a topic where we can and should be united, where we could speak with one voice. but the manner in which you've chosen to advance this legislation ensures that will not happen. And I regret that quite sincerely. With that, Mr. Chair, I yield back.
The gentleman yields back. Thank you very much. And let me just remind members that we have 3 bills that we need to deal with today and lots of witnesses. So I would urge people to be concise and to the point in their questioning of our witnesses. And we're going to begin with our witnesses who will provide testimony in HR 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. Subcommittee Chairman Cicilline and Representative Fishbach, we're delighted that you are here. And Representative Fishbach, you can not only testify, you could ask yourself questions. So you could do, you'll have ample time to express yourself here today. But I would now like to recognize the gentleman from Rhode Island, Chairman Cicilline, for his opening remarks.
Thank you very much, Chairman McGovern, Ranking Member Cole, and members of the committee. I thank you for inviting me to testify before the committee in support of HR 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. This bipartisan legislation would restore access to justice for victims of sexual assault or harassment who are currently locked out of the court system and forced to settle their disputes against companies in a private system of arbitration that is often stacked against them. Arbitration was originally developed as an alternative to the court system for parties of relatively equal bargaining power to enter into voluntarily. In recent decades, however, forced arbitration clauses have become ubiquitous in our lives, largely in the form of a take it or leave it contracts between very large companies and individual consumers. These clauses have rendered our court system, in which plaintiffs have far stronger protections, inaccessible to far too many. This private system also does not have the same procedural safeguards of our justice system, is not subject to oversight, has no judge or jury, and is not bound by laws passed by Congress or the states. Nowhere are the harms of forced arbitration more apparent than in disputes involving sexual harassment and sexual assault. Time and time again, we have seen these clauses block survivors of sexual harassment and assault from making their stories known and having their day in court, preventing them from holding abusers accountable for their horrific crimes. And when forced arbitration is combined with non-disclosure agreements, as it is so often, it silences the survivors of sexual harassment and assault. Predators rely on this silence. As long as their actions are hidden, they're free to act with impunity. And forced arbitration, when weaponized by sexual predators in the workplace, creates a culture of silence. For example, according to a disturbing report by the Washington Post, hundreds of former female workers of Sterling Jewelers, the massive jewelry chain that owns Kay Jewelers and Jared, were, quote, routinely groped, demeaned, and urged to sexually cater to their bosses to stay employed, end quote. And although many of the women at Sterling Jewelers sought to hold the company accountable by banding together in a class action, Sterling covered up this abusive conduct for years by forcing its workers to waive their right to bring a lawsuit against the company in public. These arbitration proceedings were conducted in private, the outcome was sealed, and any settlements with the company were bound by confidentiality clauses. Not only did this massive cover-up shield the company for public accountability, it also blocked other victims of assault and harassment from coming forward until some of the stories finally became public years later. As Gretchen Carlson testified during my subcommittee's hearing on forced arbitration in February 2021, these are not isolated cases. Far from it. Thousands of women across the country have suffered through similar pain and humiliation. They were isolated and taken advantage of. They were silenced by forced arbitration clauses and non-disclosure agreements. They were unable to hold wrongdoers accountable by having their day in court. As Ms. Carlson testified, forced arbitration perpetuates the systemic problem of protecting predators. Last November, the Judiciary Committee heard directly from several survivors of this abuse. Our witnesses' testimony illustrated how this outrageous practice is routinely abused by predators to cover up their horrendous behavior. As one witness, Ms. Spottiswoode, made painfully clear in her testimony, her abuser, the founder of Invisalign and the CEO of Affinity, initiated an arbitration against her because he knew the secrecy of arbitration would protect him after beating and sexually abusing her. HR 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, will end this abusive practice once and for all. This bipartisan measure is strongly supported by a coalition of survivors of sexual harassment or assault and their allies, including the National Center on Domestic and Sexual Violence, the National Coalition Against Domestic Violence, the National Domestic Violence Hotline, the National Network to End Domestic Violence, RAIN, and the Sexual Violence Prevention Association, among others. It's also supported by numerous public interest and advocacy organizations, such as Public Citizen, Consumer Reports, and the American Association of Justice. I'd like to thank the Rules Committee for considering this bill today, as well as my colleagues, Representatives Bustos, Griffith, Jayapal, and Buck, for their leadership on this issue. Companion to this bipartisan legislation was passed out of the Senate Judiciary Committee several months ago by a unanimous voice vote, and it passed out of our Judiciary Committee with significant Republican support. I urge my colleagues on this committee to support this measure today and yield back to you, Mr. Chairman, with gratitude.
Sorry about that moment of silence there. Thank you, Mr. Cicilline. The chair now recognizes the gentlewoman from Minnesota, Representative Fishbach.
Thank you, Madam Chair. I testify today in opposition to H.R. 4445. Sexual harassment and sexual assault are despicable actions. Victims of sexual harassment and assault must have their claims heard, and they should not be silenced or intimidated into silence. The House Judiciary Committee heard important testimony from victims of sexual harassment and assault. It took real courage for those victims to share their stories. What those women and many more women around the country have had to face is terrible. The bill we are considering today, H.R. 4445, would not make victims better off. And no matter how well-intentioned this bill may be, it raises real policy concerns. The Judiciary Committee received testimony from experts explaining the bill's flaws. For example, this bill's supporters seem to assume that all arbitration is secret, that arbitration automatically keeps victims from going to the authorities or publicizing their experiences. But that is not accurate. Arbitration is not intrinsically secret or otherwise confidential. Put simply, agreeing to resolve a case outside of court is different than agreeing to silence. That distinction matters today because much of the push for this bill comes from concerns about secrecy rather than whether justice can be served in the arbitration context. And despite that emphasis, H.R. 4445 does not actually address confidentiality or non-disclosure agreements. For example, even if this bill is enacted, it's still possibly a separate contract provision could be used to try and impose a confidentiality or keep details about an employer under wraps. This bill may seem innocuous to some, but it looks like it empowers plaintiffs. But in all likelihood, this bill would effectively end most arbitration in these contexts, even when arbitration could benefit the victim. This is so because the bill fundamentally changes an arbitration clause from a mutual commitment to use an alternative dispute resolution method into a one-sided election for an injured party. If H.R. 4445 becomes law, contracts will be far less likely to include the option to arbitrate. If parties cannot agree in advance to arbitrate, the plaintiffs may never have access to arbitration. This unintended consequence will have real-world implications, especially for victims who lack deep pockets or do not have the possibility for high-dollar settlements that some high-profile cases do involve. As Americans know, lawsuits are often long and expensive, and big corporations have more resources to litigate than most victims. Litigation can also be very harrowing for the victims, who in traditional litigation must submit to rigorous discovery like depositions or perhaps even the challenges of a public trial. And it may be even harder for victims to tell their stories in litigation and get justice, given the rules of evidence that might apply. Democrats cast aside these concerns and they ignore how arbitration is generally a good way to resolve disputes. When this bill raises so many concerns, why are some in Congress so intent on taking this legislation forward today? If Democrats had their way, everyone from consumers to civil rights plaintiffs to those with antitrust claims to individuals using financial service products and others would not be able to contract in advance to resolve disputes through arbitration, given the series of bills that they have already offered. Instead, they would be forced into courts. Congress should stand ready to improve the legal system, but we must make sure that whatever we do to the court system is an actual improvement. And some of us are deeply concerned about how this legislation will work for victims, no matter how well-intentioned it is. And for these reasons, I urge my colleagues to carefully consider the ramifications of HR 4445 and oppose this legislation. Thank you, Mr. Chair, or Madam Chair, and I yield back.
Thank you, Ms. Fishbach. I will now recognize Mr. Cole for any questions that he may have.
Thank you very much, Madam Chair. Just a couple of quick ones to my colleague from Minnesota. Given the way it was written, could a trial lawyer actually use sexual harassment claim to qualify other claims and exempt all of them from the arbitration agreement?
Well, and Mr. Cole, as a matter of fact, yes, they could, because of the way that the definitions are set up. The definition of sexual harassment is set up in this bill. It's very expansive, and so they could include many of those in, and whatever claims they may have would then be included under that sexual harassment, that protection from arbitration.
And one additional question, do arbitration agreements in any way prevent victims from seeking justice in criminal court or telling their story to the public?
No, Mr. Cole, they are still allowed to sue if they choose to, and nothing is secret about. It is not inherently secret. An arbitration is not. If there are other provisions in the contract, it may be, but but it does not preclude them from filing a lawsuit, and that would then be public, even if it is dismissed. So no, there is not.
Thank you very much. Thank you, Madam Chair. I yield back.
Governor yields back. Mr. Cicilline, would you care to clarify the previous statement?
Yeah, I mean, yes, happily. The whole point of forced arbitration is that, in fact, the survivor of sexual assault or sexual harassment is prohibited from filing a lawsuit. That as a condition of their employment or as a condition of a service, they're denied the right to go to court, so they can't file a lawsuit. That's the whole point. They're prevented. They're forced to go into this private arbitration proceeding, which is often so expensive they can't afford to do it, and it doesn't have all of the procedural safeguards, presence of a judge or a jury. They're not even required to follow state or federal law. So this notion of, well, they can just go to court and sue anyway, even if it gets dismissed, they're looking for justice. They're looking for relief from a horrific experience. And so they are prevented from filing a lawsuit as a condition of employment very often. So it isn't like they just negotiated. It's a condition, a take it or leave it provision. And so the very point of this is to be sure that people are not re-victimized, that individuals who are the subject of sexual harassment or sexual assault have a right to have it to the day in court to have their grievances heard. They can always agree to arbitration after the incident. That's always an option. This is about giving away that right, being forced to give away that right, very often as a condition of employment. And in the end, this is about whether or not Congress is actually going to give individuals the ability to enforce the law. We pass laws, but if people don't have the ability to go to court and enforce them, they're meaningless. And that's exactly what this bill will ensure happens, that people will have the right to have their rights vindicated in a court of law.
Thank you, Chairman Cicilline. I will now call on Mr. Burgess. Dr. Burgess.
Thank you, Madam Chair. I would just ask the gentlelady from Minnesota if, as a result of the previous exchange, if there's anything that you'd like to add.
Well, and thank you, Mr. Burgess. I just would like to say that, they are not prohibited by law. Potentially, I suppose, if the contract prohibits them, but they still can file a suit in court, and then it would be public. So they can go ahead and file that. It would be, even if it's dismissed, it would be public, and that is one way that they are able to get their information out and their case out into public.
No relief.
Would you like for a response? I'll tell you what, I'll yield back in the interest of time.
Thank you, Mr. Burgess. Mr. Perlmutter.
Yeah, I'm not sure I understood Ms. Fishbach's answer just then, that you file a case, it gets dismissed, but now it's at least public. I mean, that's not the purpose of filing the case. The filing the case is to get justice, to have somebody who's independent, objective, not biased, make a decision. And that's the purpose of this. And Mr. Cicilline, you brought this bill or other bills like this before our committee in the past. Is there anything different than, with this one to avoid this mandatory arbitration clauses that we should be aware of?
No, only that, this enjoys significant bipartisan support. As I mentioned, it passed out of the Senate Judiciary Committee unanimously by voice vote. This is narrowly tailored to one set of actions relating to sexual harassment and sexual assault, which I think everyone recognizes are particularly egregious, and the forced arbitration system produces really horrific consequences. So it doesn't apply to a number of other kinds of claims. But the notion that and I believe me, if you sat through the testimony and listened to the survivors of these horrific assaults and attacks on them, the idea that they should be satisfied that they can file something in court that then is dismissed and somehow that should be sufficient accountability is really demeaning the survivors of sexual assault and sexual harassment. These are serious cases. Filing a claim that you are prevented from filing according to the conditions of your employment, only to have it dismissed, is a re-victimization of people who are victims or survivors of sexual harassment assault. And so that surely should not be enough for this committee to say they have enough, they can file a lawsuit that gets dismissed.
All right, thank you for answering that question. I yield back.
Thank you. Mr. Rushenthaler.
Thank you, Madam Chair. I appreciate it. And I would just see if my colleague, Ms. Fishbach, would have anything to add.
And Mr. Chair, or Madam Chair, excuse me, I appreciate the opportunity for Mr. Rushenthaler. I guess I would just like to say that it is an issue of transparency, that if they are able to file the lawsuit, and I did not say that would resolve it, but it is an issue where they would be able to reach out and make sure that their case is in the public eye. And but I think that what the concern would be there too is also if you eliminate their opportunity to arbitrate, then you are forcing them into court, and you are forcing them to go through that kind of harrowing experience that they may very well have in court. And so I think that you also need to remember that the difference is you have arbitration and you have the NDAs or the gag rules that they may be called. They are two separate contract provisions. And so we should not mix the two of them. Arbitration itself is something that is useful to in many, many, many cases. And so I want to make sure that we are not automatically saying that arbitration is always secret, because it is not.
Thanks, Ms. Fishbach. I would just like to take the opportunity to thank Mr. Cicilline, my good friend. We were on judiciary together. We actually worked on a bill to eliminate forced arbitration from USERA and I believe the SCRA to help service members in what I consider contracts of adhesion. So I just want to thank you for working with me on that. I hope that at some point we can get that done together. And Mr. Cicilline, you were talking about some of the pitfalls of arbitration. One thing I would add to that is that you also lack full discovery ability. So it's oftentimes very difficult to actually value a case if you're a plaintiff, simply because there's things that you just don't know because you don't get it through the normal course of discovery if it were true litigation. But I don't want to belabor the point. With that, Madam Chair, I yield back.
Thank you. I now recognize Mr. Raskin.
Thank you, Madam Chair. Mr. Cicilline, we had testimony in the Judiciary Committee about a number of workplaces that were essentially cesspools of sexual harassment and sexual assault, where it went on not just for months or years, but even for decades, where women employees were just constantly harassed at work and there was sexual assault. And those were workplaces that had forced arbitration. And I wonder if you would explain the role that forced arbitration plays in the creation of a perpetual sexual harassment workplace culture?
Thank you, Mr. Raskin, for your question. What we learned, and I think what your common sense will tell you, is that predators see forced arbitration as a license to continue to engage in that behavior because they're ultimately never held accountable. Survivors of sexual assault and sexual violence are prohibited from filing an action by the terms of their condition because this is a forced arbitration provision. They're forced to go into arbitration, often accompanied with a non-disclosure requirement, so nobody knows about it. So it goes on for years and years and years. And to the extent a survivor of sexual assault or harassment wants to avail him or herself of arbitration, nothing in the bill precludes that. In fact, the explicit language is upon the election of the person who has been wronged. So if after the event they decide arbitration is better than filing a lawsuit, that's their choice. But that's quite different from forcing them into a process that keeps it secret and that protects the predator.
So when one of our colleagues says that you want to force women to go to court, in other words, force them to be able to enjoy their rights under the 7th Amendment that the framers gave us, the right to a jury trial, in fact, you're giving people the freedom to choose. Because if they want to enter into arbitration, they have an absolute right to enter into arbitration. But if they don't, they've got the right that the framers gave us to go to court and sue. Is that right?
That's absolutely right. And Mr. Raskin, I would just underscore, I've been in Congress for almost 12 years now. I will say that the testimony of the survivors of sexual harassment and assault that we heard at that hearing was one of the most sobering and compelling set of witnesses I've ever seen in my life.
I mean, we were hearing testimony from women who were forced to go abroad and were sexually harassed, assaulted, or raped in foreign hotels. We had, reports of women who are being repeatedly sexually harassed by different members at the same firm. These policies of forced arbitration create a culture of impunity and arrogance and exploitation in a lot of workplaces. And we heard it from these women. And I would urge any member of this committee who's thinking of voting against HR 4445 to go back and to listen to the unanimous testimony of the women victims at this hearing, who explained exactly the way that forced arbitration created a regime of silence and exploitation at those companies. So I want to thank you for bringing this forward, and I yield back to you, Madam Chair.
Thank you. Ms. Scanlon.
Thank you very much. I mean, I have participated in the Judiciary Committee hearings on this, so we've reviewed the issues there at length. But Mr. Cicilline, one of the justifications we hear for having these forced arbitration clauses is that it's less expensive. Are corporations putting forced arbitration clauses in their contracts with employees in order to save the employees money?
No, quite the contrary. They're putting forced arbitration clauses in contracts to prevent the cost of defending against these really horrific practices. And now, obviously, if a person who is a survivor of sexual assault or harassment chooses to use an arbitration system because they somehow think that is less costly or will be responsive to their claim, they have an absolute right to make that choice, as Mr. Raskin said. But they put these clauses in to protect themselves from gigantic judgments that are likely to follow because of the egregious conduct of these predators. They're not doing it to save their employees money. So thank you for your question.
Well, and related to that, often the way that employees get relief in this kind of situation is that they band together. And I think you mentioned the jewelry company, that employees band together to share the costs of litigation because it's prohibitive for them to undertake it themselves. But these forced arbitration clauses also forbid employees from pursuing their claims together and sharing costs, don't they?
That's correct.
Okay. Thank you. I have no further questions.
Thank you. Ms. Fischbach, I recognize that you are the witness here, but you're also a dear member of the Rules Committee. Is there any questions that you have of yourself or the chairman?
I am so tempted just to ask myself a question, but I think I will yield back, Madam Chair.
Thank you. And the chairman's back, so I will yield back to Mr. McGovern.
Thank you very much. Mr. Morelli.
Thank you, Mr. Chairman. I don't have much to say. I have listened. I appreciate Mr. Cicilline being here and his leadership on this. As I've said before, I'm not an attorney. Don't play one on TV. This, to me, seems like a question of fundamental fairness. You should not have to give up one of your rights, which is to seek redress in the court system in order to get or keep a job. And so to me, this is pretty basic, pretty fair. And I'm happy to support the rule and the underlying legislation. Again, thank you, Mr. Cicilline, for being here and for your leadership. With that, I'll yield back.
Mr. DeSaulnier,
No, Mr. Chairman, I yield back.
Ms. Ross.
Thank you, Mr. Chairman. I would just echo the comments of Mr. Cicilline. I too was in the Judiciary Committee. Let's remember, this is forced arbitration, and it really is a contract of adhesion because you're telling women, take it or leave it. You can, if you don't want to have forced arbitration, you just can get a different job. And none of the provisions in this bill hurt good employers. They only hurt employers who abuse their power over their employees and do not want to be held accountable for sexual harassment, sexual assault, and creating the right kind of environment in their workplace. I support the bill and the underlying rule.
Mr. Neguse. All right. Anyone else have any questions? If not, the panel is dismissed.
Thank you, Mr. Chairman.
I want to ask unanimous consent to insert in the record the statement of administration policy in support of HR 4445. We will hear now from any amendment witnesses on HR 4445 at the end of the hearing portion of today's meeting. I would now like to welcome our witnesses to provide testimony in HR 3485, the Global Respect Act. Chairman Meeks and Representative Tenney, we are delighted that you are here. I now recognize the gentleman from New York, Chairman Meeks.
Thank you, Chairman McGovern and Ranking Member Cole and members of this committee. And thank you for the opportunity to speak in support of HR 3485, the Global Respect Act. We find ourselves in a precarious time. Human rights are under assault. Autocrats feel emboldened, and minority groups are being targeted simply for their existence. So I'm honored to serve as chairman of the House Foreign Affairs Committee, where we stand ready to meet these grave challenges. The United States must confront the rise of hate by leading the free world and ensuring the tenets of human rights rise higher. Today, millions of LGBTQI plus persons face threats to their safety because of their sexual orientation or gender identity. In a wide swath of countries, LGBTQI plus persons are subject to punishment that range from fines, arrest, assault, to even execution. And while many countries have made great strides in welcoming their LGBTQI plus neighbors, other countries sadly appear to be backsliding. According to the International Lesbian, Gay, Bisexual, Trans, and Intersex Association, 69 United Nations member states criminalize same-sex activity. Moreover, the Department of State's 2020 country reports on human rights practices make it abundantly clear that violence and discrimination against LGBTQI plus persons are persistent in every single region of the world. HR 3485, the Global Respect Act, was introduced to meet these challenges. And I want to thank our colleague, Representative Cicilline, for drafting this important legislation that requires the president to identify foreign individuals responsible for human rights violations against LGBTQI plus persons abroad and prevents those listed from entering the United States of America. The Global Respect Act also requires the State Department to designate at least one senior officer responsible for tracking violence, criminalization, and restrictions on the freedoms of LGBTQI plus persons abroad. And lastly, this legislation requires the Department of State to include information relating to violence or discrimination against LGBTQI plus communities in its annual human rights reports. Now, there are critics out there that say this bill infringes on religious beliefs. And I wholeheartedly reject that notion. Religious freedom is not inconsistent with the protection of LGBTQI plus rights. This bill has nothing to do with one's religious belief. The Global Respect Act is about holding accountable individuals responsible for committing human rights abuses against LGBTQI plus persons. We're talking about people who murder, who detain and disappear persons, abhorrent crimes, all targeting individuals simply because of their sexual orientation or gender identity. And Rep. Harder's amendment makes it even clearer that this bill does not authorize any action against any individual based solely upon religious belief. Critics also claim that there isn't a need for sanctions because Global Magnitsky covers these horrible crimes. Well, Mr. Chairman, I know you know this area very well as the author of the Global Magnitsky Act. Global Magnitsky, while a landmark tool used in human rights space, has rarely been used by administrations to sanction those who prosecute LGBTQI plus persons. This bill simply builds on existing human rights related authorities to ensure that human rights abuses are held accountable everywhere on this planet. So despite our differences on some of these issues, the members of the Foreign Affairs Committee were able to come together and vote in support of this legislation by voice vote. And human rights is not and should not be a partisan issue. We on the Foreign Affairs Committee recognize that we must be united when human rights are threatened, which is why this legislation was reported with strong support. Finally, I want to end by commending leaders like you, Mr. Chairman McGovern, and Representative Cicilline, for your deep commitment to human rights. I'd also like to recognize the courageous LGBTQI activists who dared to stand up and claim their basic human rights in the face of violence, discrimination, and persecution. We remember activists like David Kato in Uganda and Yelena Grigoryev of Russia and Julius Manan of Bangladesh. They had violent ends to their lives, and countless others around the globe fear the same fate, all because of whom they love. So I support this very important bill and respectfully ask that the committee do so as well and move this bill on the floor for consideration. Thank you for your time, and I yield back.
Thank you very much, Chairman Meeks. I now will yield to Representative Tenney.
Thank you, Mr. Chairman, and thank you, Ranking Member Cole, for providing me the opportunity to testify before the committee on H.R. 3485, the Global Respect Act. Republicans ardently believe that all people have inherent dignity and possess equal rights as specified in our nation's Declaration of Independence, our Constitution, our Bill of Rights, and is further defined by the Universal Declaration of Human Rights, which the U.S. voted to adopt at the United Nations in 1948. Republicans reject violence directed at anyone, and that includes individuals who are targeted on the basis of race, religion, ethnicity, biological sex, appearance, or sexual preferences. That is why Republicans overwhelmingly supported the global Magnitsky Human Rights Accountability Act of 2016 and have supported various other sanctions bills that punish human rights violations. The problem with Representative Cicilline's Global Respect Act, however, is that it borrows language from the Global Magnitsky Act and so-called Section 7031 sanctions and creates a separate parallel reporting mechanism that is focused not on human rights of all, but rather on the targeted human rights of particular groups. But by creating a public list only for LGBTQI human rights violations, the bill incentivizes state and NGOs to focus more on those violations than on others. I don't see why sanctions for this specific category should take precedence over or be superior to resources taken away from other human rights violations. Furthermore, the bill's broad language has the potential to sweep in nonviolent conduct and impose visa restrictions on individuals engaged in their conduct. For example, it speaks about complicity and cruel treatment. Is a parent overseas who rejects their minor child's wish for a sex change operation complicit in cruelty? Is the Pope engaged in, to quote the bill, degrading treatment when he expresses opposition to same-sex marriage based on the tenets of his religious faith? There are no safeguards in this bill that address these situations. When free speech, religious freedom, and parental rights protections were proposed to be added to the bill, vis-a-vis an amendment by Representative Scott Perry at markup, the Democrats balked and voted against them. They preach tolerance until they're asked to vote for it. We all know that these days, the most extreme elements of the Democratic Party use cancel culture to target and silence certain viewpoints. So it's not enough to take the bill's author's word that the legislation is not about speech. Regardless of the author's intent, there are people that will use this bill to target their political and ideological opponents in the culture wars. The bill's author will say that there should be no problem since this bill just uses the same language as other human rights statutes, including the Global Magnitsky Act and Section 7031C. But those existing provisions already express and punish the conduct that Representative Cicilline is targeting. The real question then is, why is this bill necessary since other statutes already impose visa restrictions and other sanctions on international human rights violators? Democrats acknowledge that this is the case in their committee report, but in search of some and any rationale, they claim not enough sanctions have been rolled out that cover crimes against identified LGBTQI individuals. That's just not true. We know, for example, that under the Trump administration, groups and individuals from Chechnya have been sanctioned under Global Magnitsky for human rights abuses, including extrajudicial killings and the torture of LGBT identifying individuals. And the former Gambian president was also sanctioned after having rounded up people based on sexual orientation and after making shocking statements against LGBT identifying individuals. These sanctions, as I said, were imposed under the Trump administration, but even more have been imposed under President Biden. We know, based on the recent State Department report that came out a few weeks ago, that individuals in Cuba, Uganda, Bangladesh have also been sanctioned, and all are associated with groups or conduct targeting LGBT individuals, identifying individuals. By the way, the bill's author does not, and indeed cannot, claim that his bill is needed because the Biden administration is also turning a blind eye to sexual minorities overseas. Indeed, in the committee report, Democrats praised Biden's appointment of Jessica Stern as the U.S. Special Envoy to advance the human rights of LGBTQI+ persons. Democrats further quote State Department human rights reports that already document human rights violations of minorities, including LGBT identifying individuals in foreign countries. The Biden administration flies the pride flag at the Vatican and the progress flag outside of federal agencies. It bestows passports marked with an X for gender nonconforming people and issued a presidential memorandum last February, quote, on advancing the human rights of lesbian, gay, bisexual, transgender, queer, and intersex persons around the world. And perhaps most relevant, it continues to use Global Magnitsky to sanction human rights violators. So this bill is clearly not necessary. It represents the administration's aggressive attempts to push the envelope regarding culture war issues at every possible juncture. not only domestically, but also abroad. That is distracting and requires diplomats to devote time and resources to culture wars at the expense of attention paid to China, Russia, Iran, the quagmire in Afghanistan, and the crisis at our southern border. And the State Department agrees. It has reviewed the Global Respect Act and recommended extensive changes, signaling it too sees this bill as superfluous and misguided. Although it's true that the administration issued a tepid statement in support of the bill, that doesn't change the fact that the career State Department officials who reviewed this bill text said, red light. This is not necessary. We're already doing this. It is astounding that as Ukraine is on the verge of being invaded by Russia, as North Korea continues to conduct ballistic missile tests, as illegal aliens stream across our southern border, the Democrats have decided now is the best time to bring this bill forward. I thank you for the opportunity to testify, and I yield back to the chairman for questions.
Well, thank you very much. I appreciate it. And I would like to ask unanimous consent to insert the statement of administration policy in support of HR 3485. I mean, yeah, into the record. And it doesn't appear to me to be a tepid statement. Actually, it's pretty strongly worded. And I just want to say, as someone who also co-chairs the Human Rights Commission here in Congress, there's a rise in violence against the LGBTQ community all over the world. And for too long, quite frankly, it has been put on the back burner. And I think that this bill will actually do a lot to try to send a message to those countries that want to abuse people because of who they love or who they are, that there will be consequences. We pass routinely bills that add sanctions because of violations of religious freedom. I favor that. We just recently passed another bill sanctioning China on their treatment of Uyghurs, and certainly there may be other mechanisms to be able to hold Chinese officials accountable for what is going on against the Uyghurs. And I just have a tough time believing we're having this discussion. That I would like to think that on this issue that we all could agree that LGBTQ rights are human rights and human rights are LGBTQ rights. But apparently, we're not going to have unanimity on this. So I yield to the gentleman from Oklahoma, Mr. Cole.
Thank you very much, Mr. Chairman, and I want to thank both our witnesses, two great New Yorkers, and I have great respect for each one. I've had the opportunity to work with each one, so wonderful witnesses. I have just a couple of quick questions for my friend, the gentlelady from New York. First, we know the State Department's already has the ability, you alluded to this in your remarks, to restrict visas to foreign individuals. Are you aware of any discussions with the State Department regarding the legislation? Do they see it as necessary, sound policy? Is it something that they're happy to have a new tool, or is this something that is redundant?
Yeah, thank you. Thank you for the kind remarks. And I can't speak for the Biden administration, but career diplomats at the State Department did weigh in, and they have serious problems with the bill. For example, the bill mandates that the department's annual human rights reports contain information on violence directed at and discrimination of LGBT individuals. In theory, it sounds like a great idea. It's a good concept. But the fact that it's already in current practice, so they're already doing that. So the department has said does not like the reporting provisions and needs discretion. It also said that the Secretary of State should have discretion in designating a senior official focused on these issues. The fact is, there is already a bureau devoted to human rights violations, the Bureau of Democracy, Human Rights, and Labor, the DRL Bureau. There are already sanctions imposed by the Global Magnitsky Act and Section 7031C on the anti-LGBT violence that the bill targets. And the president has already named a special envoy for LGBT human rights issues. So in essence, the bill is not reinventing the wheel. The bill is not reinventing the wheel in any way. It really seems more like just a messaging bill or a bill to try to highlight the issue, which is great, but we already have all of these in place. And as I cited in my initial remarks, we have numerous examples where Global Magnitsky is being used to sanction and to prosecute people who are in violation of crimes against people of the LGBT community.
Thank you. One more quick question, again to the gentlelady. Sometimes we have concerns about bills, not about what's in them, but what's not in them. I know Republicans in the committee raised concerns about the freedom of speech and religious protections absent in this bill. It's my understanding that committee Republicans attempted to remedy this situation in the markup, but that was rejected along party lines. Can you expand on the amendment and why it's not only important but necessary to add to this particular piece of legislation?
Yeah, well, Representative Perry introduced legislation, and it was, sometimes the Democrats like to preach tolerance, tolerance for me, but not for thee. But it would have ensured that the broad language of the bill is not used to target individuals. This is the Perry Amendment abroad who do not see social issues through the same lens as Democrats. The fact is that while we should deplore violence and unlawful detention of anyone, anywhere, including the LGBT community, foreign countries do not need the United States to lecture them on controversial issues. There are plenty of reasonable, good-natured people with religious objections to same-sex marriage, for example, and transgenderism, and they need to be able to debate these issues in foreign countries without fear of punishment by the United States. Again, alluding to the fact that the legislation is too broad, the Perry Amendment would have refined that. It's also telling that now the Representative Harder of California has introduced an amendment very, very similar to Mr. Perry's. And I guess the word got out that the Democrats had overreached on these issues yet again. We'll see how many Democrats vote in favor of the Harder Amendment, but in opposition to Mr. Perry's, which was unanimous. There's no principle basis for doing this. They're virtually the same. One thing I wanted to flag is that the original version of the bill contained references to, quote, homophobic statements and would have sanctioned people for not for committing violence or cruel treatment, but for inciting those acts. And I think the language reveals the Democrats' true colors here. It's given, it's very vague text. And as a lawyer, we don't want to see vague text in language because we know it can be challenged constitutionally. And there seems to be some sort of hostility toward free speech, religious freedom. And we can't assume that the bill won't be used for partisan political ends. And that's why we already have these safeguards in place with the original bill text and the original laws in place. And that why they rejected the Perry Amendment. And now introduce the Harder Amendment, which is really very similar, maybe like a watered down version of it. But that is a question to be posed, I guess, to the other side.
Well, thank you, Mr. Chairman. I'd be remiss not to give you an opportunity to weigh in if you care to. Mr. Meeks.
Yes. Well, I'll just simply say that I don't even think it's wise. I mean, we are debating a bill on human rights, something that we know that is taking place across the globe. And clearly, if you look at the bill, with those individuals that, I guess, like Ms. Tenney has indicated, that is unnecessary because of the Magnitsky Act, which in theory covers human rights violations against LGBTQI plus people. In practice, it is clear that there have been few attempts to sanction individuals for LGBTQI plus specific abuses. The one exception that I know of is the case in Chechnya, which they were sanctioned for extrajudicial imprisonments, torture, and murder of gay Chechens in 2017. But I think we all really know that Chechnya is not the only example where the administration should have pursued and perpetuated against, should have pursued sanctions. And all too often, we hear stories, too many stories, of violence perpetuated against LGBTQI people. Human Rights Watch, for example, documented one egregious example in Egypt in 2019, when LGBTQI plus man was wrongfully arrested by police. He was beaten senselessly and made to stand for 3 days in a dark and unventilated room with his hands and feet tied and with a rope. And he stated they didn't let me go into the bathroom and I had to wet my clothes and even shit in them, unquote. I still had no idea why I was arrested. So what we want to do here is to codify, make permanent current practice of sanctions and reporting requirements. That's what this does. Protecting human beings, human rights. This is something that we should really be doing unanimously. And I close with saying that I've heard before that the bill will unjustly target religious leaders who give sermons or refuse to conduct same-sex marriages consistent with their sincerely held beliefs. I've heard that before. I heard it with both the passage of the hate crimes bill and the repeal of Don't Ask, Don't Tell. You know, back then, opponents claimed that chaplains and other religious leaders would be found guilty of federal crimes for their sermons or put in jail. Guess what? Those were misguided fears that never came to fruition. So now I'm hearing again these narratives being peddled. The language of these provisions is clear. An individual will be sanctioned for actions. Be sanctioned for actions and not speech. And the actions would have to constitute gross human rights violations, torture, or cruel, inhuman, or degrading treatment or punishment, prolonged detention without charges, and trail disappearances, or clandestine detention, and other flagrant denial of the right to life, liberty, or the security of the person. This is consistent with the U.S. sanctions regime and will continue to be true with the passage of the Global Respect Act. And so I say that we should send one message of unity to all of those abusers around the world who would simply punish someone for who they love. We should be doing this together. It's the right thing to do.
Thank our witnesses, and Chairman McGovern, I yield back.
Thank you. And let me just thank Chairman Meeks. Look, there could be no justification whatsoever for imprisoning somebody because of who they are or who they love, or torturing somebody because of who they are or who they love, or killing somebody for who they are or who they love. And again, that is, I think, what Chairman Meeks is trying to emphasize here, is that this should be unanimous, quite frankly. Ms. Torres.
I have no comments. I support this bill, encourage my colleagues to move it forward, and I yield back.
Thank you. Dr. Burgess.
I just thank our witnesses, and in the interest of time, I'll yield back as well.
Thank you. Mr. Perlmutter.
No questions.
Mr. Reschenthaler.
Thank you, Mr. Chairman. I was pretty slow on the unmute button. Thanks for your patience. Thanks for you. I think it's ironic that we're considering a human rights bill literally on the same day we're considering what really is a tantamount to a giveaway bill to China, which everybody knows is the world's worst human rights abuser. So I would just suggest that we should join as the minority party with the majority to get a bill that's actually serious about stopping China, holding China accountable, and getting tough on China. So for example, just when we talk about LGBTQ issues, China is actually a horrific violator. China and the CCP, they censor LGBTQ content across social media platforms and all media for that matter. They shut down LGBTQ events, and they prevent Chinese LGBTQ couples from getting married and adopting. They also, let us not forget, have a horrible history of human rights violations, particularly on Turkic Muslims, including the Uyghurs. Arguably hundreds of thousands of Turkic Muslims are held without due process in the Western provinces. They're subjected to forced labor, deprived of food, deprived of other basic needs. They suffer from these like torture, organ harvesting, and the CCP attempt to eliminate minority peoples through forced abortion and even sterilization. Forced sterilization, I might add. Remember, in 2021, Biden's State Department even determined that the CCP is committing genocide and human rights abuses against Muslim Uyghurs and other ethnic minorities in the Xinjiang province. And let us not forget that the Chinese rolled into Hong Kong, totally violating their autonomy, is what I was considered part of the British Commonwealth. You can argue that, but it's indefensible that they rolled in violating an agreement they had with the British and deprived the Hong Kongers of their freedoms. Also, the CCP is engaged in severe repression in Tibet. When I was growing up, when I was younger, that was a cause célèbre of the left. I don't know where that was forgotten from the left, but the Free Tibet movement was very popular when I was in high school, and I think it was appropriate. We got to remember that the CCP and the Chinese are doing everything they can to erase the unique religious and cultural and linguistic heritage of the Tibetan people. There's gross human rights violations. We're talking about extrajudicial detentions, disappearances, and torture. And again, that's just in Tibet. But here we are working on what I would consider a messaging bill. So with that, Representative Kenny, looking at this bill, do you agree that this is in essence a messaging bill and that it's a distraction from what we should be doing, and that is to actually hold China accountable?
Yes, thank you, Mr. Reschenthaler. And I just want to quote Chairman Meeks, and with all due respect, he's a great New Yorker as well. But he just said we need to impose these, uphold these rights. And he said, consistent with U.S. sanctions regime. And that's exactly what we're doing. And in my original testimony, I set forth numerous examples of where the Global Magnitsky Act is being used to target and sanction people who are committing crimes and atrocities against the LGBT community. And now what we have is a bill that is, kind of against what we as lawyers don't like to see, a bill that's so specific, and we'd like to see something general because it means it's more free and it's more in standing up for our Constitution. Between the crimes in Uganda, we talked about this, U.S. sanctions were used there. Global Magnitsky, Bangladesh. We talked about Chechnya, Uganda, Cuba. We have been using these already. So this bill is a messaging bill. It's maybe a publicity stunt. I hate to say that. I have a lot of respect for the gentleman from Rhode Island, but at this point, we should be, exactly as you say, focusing on China, focusing on serious issues, focusing on real human rights, and we can continue through the State Department and through the specialized agencies there, which are focused on protecting LGBT community members around the world. And we already have these rules in place. So it is duplicative. And, I think we should be really focused on the real issues. I mean, these are serious issues, but we already have rules in place.
Yeah, let's just thank you, Representative. And let's just take the bill at face value and say it's not a messaging bill. There's still problems with this bill. For example, the language, I would argue, is overbroad. For example, complicity, incitement, from my understanding, there's no real definitions. Overly broad would make it hard to enforce. Do you have any thoughts on just the construction of the bill itself?
Yeah, well, that's exactly it. It is very overbroad, and it's also it's overbroad, and that's always, as you know, a constitutional red flag. And it's also specifically there's no safeguards where it could be used like to target someone, some group or individual politically under the guise of targeting under this particular provision, which concerns me. And I just want to. I know there was a discussion about the statement of the administrative policy. The administration's policy, and the State Department officials said what they said about the bill when it was first solicited, that the bill is duplicative and unnecessary. That's the official policy from the administration. And it also bizarrely expresses support for LGBT domestic issues, even though domestic law has nothing to do with Global Respect Act. So these are among the things that have been listed by our own State Department and the administration in their initial very tepid review of the, tepid support of this bill, in identifying and actually, needing to have the amendments that were proposed by Representative Perry that were unanimously voted down by the Democrats in committee. And now the Harder Amendment seems to resurrect the Perry Amendment, not quite as protective, but it's coming back. So that's where I see it. I mean, from a bill drafting standpoint, I think it's got a lot of problems.
Thanks, Representative Tenney. I really appreciate it. Without Mr. Chairman, thank you, and I yield back.
Thank you. Let me just say to the gentleman from Pennsylvania that I don't always do this, but I want to associate myself with much of what you just said in your description of China's atrocious human rights record. We've worked together on the Uyghur Forced Labor Prevention Act and other bills to, China's crackdown on Hong Kong, China's ethnic cleansing of the Tibetans. And the gentleman rightly points out that in China, attacks against the LGBT community are on the rise. And that should be of concern. And I just will make a request to the gentleman and to all my Republican friends here, is that I co-chair the China Commission. It's a bipartisan commission. We issue an annual report. Republicans are holding up the release of that report because they want to downgrade the section on attacks and discrimination against the LGBTQ community. So if we were all serious about our commitment to upholding the human rights of everybody, including the LGBTQ community, I would appreciate any help you can give me to convince your Republican colleagues to back off on that, and to allow the section on the LGBTQ human rights violations to not be downgraded. So but I agree with his assessment of what is happening in China, and it should shock the entire civilized world. I now yield to Mr. Raskin.
Mr. Chairman, thank you very much. You're 3 steps ahead of me because I wanted to also echo the gentleman from Pennsylvania in his recitation of the outrageous human rights violations taking place in China. But then he says, I thought he was about to explain why he was supporting HR 3485, but then he said, but we really should be paying attention to serious issues, not the rights of the LGBTQ community, which he just finished explaining were in serious danger in China, which of course they are. And so we need to be taking aggressive action against China when it's violating the rights of the LGBTQ population, as well as everybody else's rights, including in Tibet. This was one reason I was so disappointed in the last president who defended General Xi and the Chinese Communist Party, the Chinese government, on 19 different occasions, and spoke about his great relationship with General Xi and how wonderful they were, and another love affair with another dictator like the communist dictator of North Korea or the former head of the KGB, Vladimir Putin in Russia. But those are precisely critical culprits in the war against LGBTQ rights around the world. Russia, under Putin, which banned assemblies by LGBTQ people as intrinsically illegal, as well as other countries like Nigeria, Cameroon, Uganda, Iran, precisely the countries that the gentleman from Pennsylvania spoke of. These are the countries that are in the forefront of trampling the rights of the LGBTQ community. So I don't know why, and I'm happy to yield to my friend from Pennsylvania, why he would describe this as not a serious issue and why we should turn to serious issues when he talked about major culprits in violating the rights of the gay and lesbian community.
Well, thanks, Mr. Raskin. I appreciate it, Mr. Chairman. Thanks for your kind words. And, I do think that we should all agree on these issues because politics should stop at the water's edge, as we used to say in this country. And we should all be against these issues. I never said I was against this underlying bill. I'm still making the determination. Spoiler alert, I'm probably going to vote no on the rule. But in terms of the underlying bill, I haven't made up my mind. But I would say there's problems like I talked with Representative Tenney about regarding the construction of the bill. Also, is this duplicative? Is this superfluous? Probably. But I've worked with the chairman on more than one bill before. We've had success. I'd be more than willing to work on bills to counter China, especially hold them accountable, singularly focused on LGBTQ issues as well as others. I know we did pass a bill regarding the Uyghur population, but I still think we can do more. I had the honor of being on the China task force. I'm still on the China task force. We've got a slew of recommendations. Mr. Chairman, I can't speak to what you're referencing because I'm not on that committee regarding what was watered down, but if there's an issue that we can draft language to address that, I'm more than open. And likewise, Mr. Raskin, we've worked on other issues, and I think we should come together to make sure that we curb human rights abuses, specifically in China. And I can tell you what happened in Tibet is an absolute global travesty. Unfortunately, most of the damage has probably been redone. Forceful movements of Han Chinese into Tibet to actually dilute the ethnic population in Tibet. Same thing is going on with Hong Kong now. It unfortunately might be too late to reestablish what really was a part of the British Commonwealth city-state, but I digress. But it's not too late for Western China if the world acts and we act from Congress. So I will yield back to you, Mr. Raskin. Thank you.
Thank you, Mr. Rosenthal. Let me just say finally that, Ms. Tenney raises, I think, a reasonable point about, well, why isn't the Magnitsky Act sufficient to cover this? Well, the Global Respect Act, as I understand it, is requiring reports on the LGBTQ community because it's in such danger in all these communities, and then mandates action with respect to it. And of course, we've done that with respect to other minority groups that have been targeted and that are in serious danger. I take issue with Ms. Tenney, and I'd be happy to have her respond if she'd like, when she suggests that somehow the underlying legislation would affect people's free speech rights. HR 3485, as I understand it, imposes sanctions only for violation of other people's human rights. So we're talking about torture, cruel, and unusual punishment, violence, and so on. The Pope can oppose marriage equality. Anybody who wants can oppose marriage equality. You can take any position you want. You just can't violate other people's human rights. So I think that's a red herring that just confuses the issue, and it suggests that there is a dispute as to the underlying principle that we should be aggressively ferreting out human rights violations against the gay community. I don't know, Ms. Tenney, whether you want to
I'd be
respond.
happy to, yes, thank you very much for the questions. I'd be happy to comment. In case anyone hasn't seen it, this is the report to Congress on the global Magnitsky sanction and violation. It's filled with LGBTQ. It's just filled with violations there that have been sanctioned. It's a report that's already done by the State Department. What the Global Respect Act would require is that an additional report be done specifically for this. So it'd be more time and effort put in, which is fine. But I mean, it's just more work for our State Department when they're stressed with a lot of issues going on in the world, which, I think these are really important issues, as Mr. Reschenthaler and you cite. We need to crack down on this. And then to your point about President Trump, it was President Trump who used the Global Magnitsky Act to sanction the Chechen leader over a gay purge in 2017, using the Global Magnitsky Act. And also some of the terms used in the bill, and if you're a lawyer, which you are, some of those terms are vague and could be misinterpreted and would be, could be used in somewhat of a combative way or potentially used to target someone with vague language. And as you know, vague language very rarely meets a constitutional standard, but when it's being used on an international level, it costs time, effort, lawyers, our administration, and people having to defend themselves around the world, which is, I don't have a problem with that, especially if there's egregious violations. But we already have these in place. We already have the safeguards. We're doing this right now. So, this is just another bill that would just kind of layer on a bureaucracy that's already a little bit overstressed at this point. And I just feel, I completely support the underlying intent of the legislation. I think it's important that we continue to do what we're doing, especially in using the Global Magnitsky Act to prosecute people who are committing these specific crimes against the LGBT community. But it's being done. As I say, the reports are being done. We all have them as members of Congress. It just seems like an extra, I think we all agree on this. I think that's one place we all agree on this bill, on the concept of you doing this, not necessarily the bill.
Okay, just to reclaim my time, I'm glad that we do agree as to the underlying principle. I just want to restate that people would be sanctioned under this legislation only for their actions, not for speech, and only those actions that constitute gross human rights violations, torture, cruel, inhuman, or degrading treatment or punishment, prolonged detention without charges, disappearances, or clandestine detention. These kinds of things are going on and taking place all over the world, which I think underscores the importance of our acting. I know of one case my office got involved with in Saudi Arabia, a 27-year-old man in Saudi Arabia who was convicted of nothing more than sodomy and then was sentenced to 500 lashes and 5 years in prison for this crime. And this kind of thing is taking place all over the world right now. So I do think that there's a serious human rights violation. There should be a mandatory reporting regime. And I yield back to you, Mr. Chairman.
May I respond?
Oh, I yielded back to the chairman.
Right. Ms. Tenney, if you want to respond, you can.
Oh, sure. Thank you. I just want to say quickly, Mr. Raskin's a lawyer, and so terms like complicity, cruel treatment, and complicit in cruelty have been associated with, for example, a parent overseas who rejects her minor child's wish for a sex change operation is complicit in cruelty. Is the Pope engaging in degrading treatment when he expresses opposition to same-sex marriage, which is part of the tenets of his religious faith? These are questions that I think are vague, and I think that it's something that we should. That's what concerns me, is they could be weaponized to be used against people for religious reasons. And certainly, the examples you cited are completely cruel. But I don't think that's exactly, those are bright line violations. I'm talking about the ones that are on the edges and are kind of vague. But I appreciate, I think we all agree that we want to, stand up for human rights at any cost. But we have to be very careful in drafting legislation to ensure that legislation does not get abused by people, potentially in situations where it could be political or other, types of motivations that don't have to do with protecting human rights. Thank you, and I appreciate.
Thank you. Ms. Fishbach.
Thank you, Mr. Chair. I appreciate the opportunity. And I just, it'll be difficult to top Mr. Reschenthaler. He got the chair's stamp of approval. So, so I will keep my remarks brief because I don't want to mess that up. But I do have just a question for Representative Tenney, and forgive me if you've already talked about this a little bit because I had some technical difficulties and might have missed it, but I just wanted to know, did the State Department have thoughts or input on the bill? And if they did, what were those?
Yes, thank you, Ms. Fishbach. Initially, the State Department's view was that they thought this was duplicative. They thought it would be overly burdensome for them. They recommended amendments to it that were rejected. And let me clarify, because I don't know if I was totally clear on the administration policy. Their position on it was also somewhat tepid. But they didn't reject it. But I think that everyone agreed. I think you could fairly state that both the administration and the State Department would be suggesting amendments and generally and broadly accept. Obviously, we are all on the same team fighting human rights, particularly against targeted attacks against the LGBT community and some of the things we've seen. These are horrific. The things that were described by Chairman Meeks, also described by Mr. Raskin. The things that we've seen, it's just horrific if you see, and if you actually look at the Magnitsky report that we receive, and you can all look at it, it's, to the fact that we are using the Global Magnitsky Act already is critical. And I think the State Department has indicated that, sure, are they against the bill? They think it could be amended. We could protect, religious freedom a little better. But it was not a glowing, this is great, let's go through with it, because they're already doing this. And I think that would be a fair way to sum it up.
And so, Representative Tenney, the State Department did or ask or suggest some amendments that were not adopted?
Yeah, I think I read, here's some of the revisions recommended. Revisions needed to make the mandatory sanction permissible to include a waiver in the national interest, vice national security interest, as the latter is too high a threshold, to delete the flawed provision purporting to mandate that the president respond to a request to determine whether a person identified by a single member of Congress, even if on behalf of the committee, is sanctionable. We have long objected to such provisions in other sanctions legislation, and it should either be dropped or revised to be hortatory, underscoring that we would respond only as a public policy matter. And 4, to revise the waiver not only to be in the national interest, but also to place the headquarter agreements passage in an exception paragraph from sanctions, not quote parentheses, not requiring affirmative waiver, and also add to exceptions routinely in other sanctions legislation for authorized intelligence, law enforcement, and national security activities of the USG. Finally, these are recommendations, both the human rights and the IRF reports already report on such matters, and to preserve the integrity of these reports and the discretion to select the most egregious conduct deserving to be reported, we have long not supported further amendments to the underlying authorities for these reports, expanding or detailing areas to be reported on. Further, should the department designate a senior official, it should be at the discretion of the secretary to do so, and it should not restrict delegation to other appropriate officials. And that's what we received as a recommendation from them.
All right. Well, thank you very much, Representative Tenney. I appreciate that. And is there anything anything else you would want to add for the discussion?
No, I think that we've covered a lot of this, excellent questions, and I appreciate the opportunity to explain this bill and the amendments and where we're going with this. Thank you, everyone.
Thank you very much. And Mr. Chair, with that, I yield back.
All right, thank you. Ms. Scanlon. Mr. Morelli.
Thank you, Mr. Chair. I just want to thank 2 distinguished New Yorkers for coming and for their great work, and always great to see my friends. So I'll yield back.
Thank you, Majority Leader.
All right, so Mr. DeSaulnier, Ms. Ross. Did I lose her? Ms. Ross? I think we, Mr. Nagu, do you have any questions, Ms. Ross?
I yield back. Thank you.
Okay, Mr. Nagus? All right, no other, I see nobody else seeking recognition. I want to thank the distinguished chairman and representative.
In closing?
Right, Tenny, Mr. Meeks.
Yes. Let me just say, because I agree with you and what was said by Mr. Fishback. And I'm just going to say that I'm happy you brought that up, because in the next bill, when we deal with the competes bill, there are a number of human rights provisions in there focusing on China, Hong Kong, the Uyghurs, the Global Magnitsky Act reauthorization is in the bill. And we sanction all of those events, the perpetrators in China, which is really, really important. So that's coming up next. And let me also say this in closing. I believe it's always the case that we do added sanctions consistent with what is on the books, although its impact may be additive in scope. And to me, clearly, the LGBTQI plus community, because I heard some say that this was a stunt, they don't see this as a stunt. They're being harmed. There's no stunt here. This, to me, and I think to all of us, is a very serious matter. And what we're trying to do is to protect human beings. And so I don't want to leave this hearing without saying it's sad that we use the word stunt when we're trying to address hate. Addressing hate can never be a stunt. It's serious matter that we all as human beings, and for those of us in the United States, must lead and let everyone know that there will never be silence on our part when addressing hate. With that, Mr. Chairman, I yield back.
Thank you very much. Again, thank you both. You are free to go. Except Mr. Meeks, you have to stay for the next panel. Are there any other members who wish to testify in HR 3485? Seeing none, this closes the hearing on HR 3485. I'd now like to welcome our witnesses to provide testimony in HR 4521, the Competes Act.
Here you are.
Chairwoman Johnson, Subcommittee Ranking Member Weber, Subcommittee Chairman Blumenauer, Subcommittee Ranking Member Smith, Chairman Meeks, Subcommittee Ranking Member Chabot, Representative Case, Representative Westerman, Chairman Pallone, Ranking Member McMorris Rogers. We're delighted that you're here and appreciate anything you want to offer us. You can submit your full testimony, your written testimony for the record. We would appreciate conciseness to the extent possible. I'm now happy to yield to the gentlewoman from Texas, Chairwoman Johnson.
Thank you very much, Mr. Chairman. I appreciate your invitation. Also to Ranking Member Cole and members of the Rules Committee. While I am co-sponsor of the entire American Competes Act, I am particularly proud of the bipartisan research and innovation initiatives that are included in Division B of this act. It is abundantly clear that if America is to meet the challenges that it is facing, we're going to need to preserve and strengthen our national capacity for innovation. That is going to require investments in our federal research agencies, measures to prepare and diversify our scientific and technological workforce so that it can effectively compete in the 21st century, and measures to help all regions play a constructive role in both innovating and in manufacturing the products that will keep us world leaders. The provisions contained in Division B of the American Competes Act, taken collectively, provide a blueprint for revitalizing our competitiveness through research and innovation. First, the Act contains reauthorizations for more than 3 of the nation's major research agencies: the National Science Foundation, the National Institute of Standards and Technology, and the Department of Energy's Office of Science. The authorizations will help jumpstart R&D in a number of critical areas, ranging from the next generation of energy storage, fusion energy, artificial intelligence, quantum information systems, engineering biology, sustainable chemistry, support for advanced manufacturing, and many, many other areas. Critically important are those investments we cannot afford to neglect the STEM workforce that will be needed to carry out the research and development initiatives that this act will enable. Thus, the American Competes Act contains a set of provisions directly targeted to ensuring we will have the best and most diverse STEM workforce possible. A simple listing of the bipartisan bills that comprise those provisions will give you an idea of what I mean. The Rural STEM Education Research Act to increase STEM education opportunities in rural areas. The MSI STEM Achievement Act to improve the quality of undergraduate STEM education and increase the research capacity of our nation's HBCUs, Hispanic serving institutions, tribal colleges and universities, and minority serving institutions. The Combating Sexual Harassment in Science Act to address sexual and genital harassment in the STEM fields. The Supporting of Early Career Research Act to help recent PhD graduates cope with the disruption caused by their research and careers by the COVID pandemic. And the STEM Opportunities Act to identify and lower barriers facing women minorities, and other groups of underrepresented in STEM studies and research careers. In addition, Division B contains a number of other important measures to advance bioeconomy R&D, promote regional innovation, support technology transfer in energy sectors, and revitalize the microelectronic R&Ds. And I want to emphasize that all of the provisions I have mentioned passed out of the Science, Space, and Technology Committee, and in most cases also out of the House on a bipartisan basis. We looked for the best ways from both Republicans and Democratic members as we crafted these bills to make up this division. And the result is a very strong package that will do much to advance our competitiveness and our capacity for innovation. And finally, I also want to mention the CHIPS provision in Division A of the American Competes Act. These provisions, which are in large part also included in the Senate's competitiveness bill, and which were authorized in a prior National Defense Authorization Act, are directed at ensuring that America continues to lead in semiconductor research and fabrication, and that more semiconductors are produced back here in America. The CHIPS Act provisions are important and they are sorely needed. In closing, Mr. Chair, I believe that the science and technology provisions of the American Competes Act in 2022 are thoughtful, balanced, and critically important for continued American competitiveness and leadership in research and innovation. And I urge all members to support it. I thank you and yield back.
Thank you very much. Subcommittee Ranking Member Weber.
Thank you, Mr. Chairman, and I appreciate the opportunity to be here to speak to you today. Appreciate the Ranking Member Cole and the entire Rules Committee. Can you hear me okay, Mr. Chairman? Very good, thank you. I'm here on behalf of the Science Committee Republicans to express our frustration with the process that got us here today. At nearly 3,000 pages, HR 4521 is simply a partisan package tossed together by Democratic leadership behind closed doors with zero, and let me say zero, Republican input. This is a stark contrast to the process we undertook at the Science Committee. Chairwoman Johnson actually alluded to it, to develop thoughtful, bipartisan legislation to increase our investment in basic research, to spur private sector innovation, and to secure, yes, as she pointed out, to secure our nation's leadership in R&D. For example, as the ranking member of the Energy Subcommittee, we worked across the aisle to develop consensus legislation to authorize the important work of the Department of Energy Office of Science and our country's national labs. I would venture to say that the chairman of the subcommittee, Mr. Bowman, and I have very different views, political views on most policy issues. Yet, we were able to come together to prioritize the important basic research which is conducted at DOE. The result is the DOE Science for the Future Act, which passed on the House floor with 351 votes, Mr. Chairman. And that's just one example of the dozen bipartisan House Science Committee passed bills that are included in this package. Unfortunately, crammed alongside this bipartisan competitiveness legislation are billions of dollars in partisan spending on controversial international climate slush funds. Yes, you heard me correct, slush funds. Also anti-competitive pro-union mandates, as well as skewed trade provisions, just to name a few. The speaker also managed to contaminate badly needed legislation that we had to advance American competitiveness, ruining years of bipartisan work to develop and pass what would have been, what is and should be comprehensive legislation to advance our nation's innovation and its capabilities. Democrat leadership has allowed only 3 days to read, evaluate, and offer amendments to the nearly 3,000 pages of what we see as unorganized policy. Despite the short turnaround, as you well know, Mr. Chairman, over 550 amendments have been submitted. Over half by the Democrats, I'd point out. Frankly, the sheer number of amendments reflects what happens when rank and file members on both sides of the aisle are not given the opportunity to legislate. I don't know, how about in their committees they're assigned to for this particular task? Is also what happens when the Speaker's office twists around good legislation and contaminates it with messaging bills to appease the extreme leftists in her caucus. I have submitted an amendment in collaboration with Mr. McKinley from West Virginia to address one of these messaging issues. This bill gives all sorts of authorities for the United States to assist and guide other countries in the development of energy production, Mr. Chairman. Aside from its questionable relevance to China, the problem is that this bill is explicit that the assistance must exclude, that's right, exclude fossil fuels. And folks, I think we all know for a developing country to really develop, they need two things: clean water and a stable fuel supply. They need energy, and there's nothing more stable than fossil fuels. There's a whole host of problems with the sentiment that thinks we have to exclude fossil fuels from those other nations. First and foremost, we must remember fossil fuels account for 84% of the world's energy. Flipping that switch off, that's not going to help developing countries. It's only going to devastate them. Second, some of my Democratic friends can't seem to wrap their heads around the idea that fossil fuels can be clean. Fossil fuels are not the enemy. It's the methane and the gas that comes out of improper production of fossil fuels. That's the enemy. Carbon capture and sequestration can be retrofitted to existing power and industrial plants, allowing us to capture almost 17 years worth of annual emission. Mr. Chairman, I could go on and on and on, but I want to make the case that this is really not right what's happening, that we could do this a lot better if we worked in a bipartisan manner. There's ways we could help these countries. There are ways that we could actually focus on China and being sure that American is in the leader's seat and not all these other issues that the Speaker has tossed in at the last minute. And Mr. Chairman, thank you for your indulgence, and I yield back.
Thank you. It's always great to hear from you. I can tell you from Texas.
Thank you, sir.
Subcommittee Chairman Blumenauer.
Thank you very much, Mr. Chairman. I appreciate having this hearing. I appreciate the various views and perspectives. I think the subject of today's hearing is such that we can move together in a process that we haven't seen much lately, sort of like a conference committee where many of the issues can be resolved and progress made. But one point is clear. For too long, America has been too weak in our engagement with China. And this is something that both of us across the aisle can agree. The Chinese government has taken unprecedented actions to strengthen their country's economic power and aggressively exert its influence on the global stage. The Chinese government has doubled down on its persecution of Uyghur and other Muslim and religious minority populations, using forced labor and other means of subjugation, practices that are not only morally repugnant, but create unfair economic advantage. The government has openly taken steps to shut down democratic institutions, routinely bullies companies for speaking out against these practices. The United States simply cannot ignore these realities. We must confront China head on. The trade title before the House today does just that. We're advancing trade provisions that are pro-worker, level the playing field, are responsive to the challenges of the United States-Chinese trading relationships. It's a culmination of more than a year of work between business, labor, civil society, and members of Congress that realizes our mandate to support workers at home and abroad while we stand up to China. Workers, businesses, farmers, and communities adversely affected by trade will benefit from a renewed and dramatically improved Trade Adjustment Assistance Program. The TAA expired on June 30th and has reverted to a more restrictive set of eligibility provisions and lower benefits. Without our TAA legislation included in the American Completes Act, the TAA program will end completely this July. Nobody benefits from that. Modernizing and reauthorizing the generalized system of preference and miscellaneous trade bill will improve American competitiveness around the globe while strengthening labor standards abroad. Closing the de minimis loophole on cheap foreign goods from China and eliminating finished products from the miscellaneous tariff bill will restore the programs back to their original intent of supporting American workers and domestic manufacturing, not undercutting American business. No one who voted for the legislation in 2015 had any idea the de minimis loophole would be exploited by firms in China and put American manufacturers at an economic disadvantage. By the way, China doesn't give us reciprocity. Their de minimis threshold, not $800, it's less than $8. They're not about to give their companies duty-free, unregulated American competition. And it's not just China. No other country in the world has such low thresholds and so little oversight in what's involved. More than 2 million packages a day now come into the United States via de minimis, the plurality of which are from China. And customs officials acknowledge they do not have the manpower and the capability to track and inspect even a small percentage of this flood of shipments, which contain undoubtedly illicit imports, theft of intellectual property, dangerous products, and undoubtedly goods made with forced labor. Even the $800 threshold is illusory. It's well known some of these companies will just issue an invoice for a lower price if it exceeds $800. Hardly fair. The MTB is supposed to help American companies get items not available to their manufacturing process, not things already manufactured. But finished goods account for nearly half the MTB petitions this cycle. And of those finished goods, nearly 56% come from China. In contrast, the Senate USICA bill provides new duty-free access to 1,430 goods, including items like air conditioners and microwaves and suitcases. That doesn't help American manufacturing. It directly undermines Congress's goal of rebuilding domestic manufacturing capacity. And finally, the legislation strengthens U.S. trade remedy laws to combat China's unfair anti-free market trading practices and empowers the United States to holistically review the offshoring of critical capacities and supply chains. At its simplest, this legislation meets workers' needs and is a long overdue reset of our economic relationship with China. Thank you very much, Mr. Chairman, and I yield back.
Subcommittee Ranking Member Smith.
Thank you, Chairman McGovern and Ranking Member Cole, for having me today. My remarks will likely echo many of my Republican colleagues participating in the discussion. To be frank, this bill, if passed, would actually demonstrate that Congress is not serious about actually confronting China and holding them accountable for the predatory trade practices. Much of this legislation was actually developed behind closed doors, without public hearings or consultations, and with no committee process. How can we seriously stand up to China without a united bipartisan front in Congress? Instead of even attempting to assemble a bipartisan bill which demonstrates unity against Chinese aggression, House Democrats, under the direction and certainly under the guidance of Speaker Pelosi, have produced a highly partisan bill which expands Washington's control of our economy and creates new handouts for their political base. In contrast, the Senate undertook a serious bipartisan process that included hearings and public consultations to craft the United States Innovation and Competition Act. I'm disappointed that House Democrats haven't taken the same approach. The trade title of this legislation falls squarely within the jurisdiction of our committee, the Ways and Means Committee. This title was not put together or made public until last week. It was subject to 0 committee hearings or markups, and it's filled with unvetted concepts that could have a significant negative impact on our economy. Sound familiar? No, this is not the failed reconciliation package from last fall. Instead of this partisan rushed bill, our country needs a smart and bipartisan approach to trade in China that instructs the administration to get serious about crafting an ambitious trade negotiating agenda, especially in the Indo-Pacific. That agenda must be focused on setting high standards and opening new markets for American goods and services. We also need vigorous enforcement of the Phase 1 agreement that President Trump achieved with China, not vague commitments to enforce it, which is all we have heard so far from the Biden administration. The Biden administration's current plan for competing in the region consists of a single 51-word paragraph from last October. We need action, not just endless reviews and statements. Representatives LaHood and Miller have put forward substantive legislation with bipartisan support that addresses these priorities, but the bill was ignored by House Democrats in this context. Ways and Means Republicans also sent a letter to President Biden last April that discussed how a TRIPS waiver could cede American intellectual property to China. Yet Democrats also did not address this important concern in their package. I offered an amendment that would renew trade promotion authorities so the U.S. can have the tools we need to reestablish our leadership role in our role on trade. But I understand that amendment will be ruled out of order. Perhaps if the Ways and Means Committee had an opportunity to consider this legislation, we would have had the opportunity to shape it in a meaningful way. I'm confident that if given the opportunity by Democratic leadership, we could have come together on a bipartisan basis to author serious legislation to outcompete China while holding it accountable for its unfair trade practices. Instead, we are stuck with a progressive wish list that very seriously undermines our competitive position. For example, the inclusion of a partisan trade adjustment assistance renewal taken straight from the failed reconciliation bill. This will cost taxpayers over $22 billion and will further discourage recipients from returning to the workforce through decreased program accountability. I wish I could say this was surprising. Another example is a Democrats' partisan approach to renewing the Generalized System of Preferences, GSP, as you know. Members on both sides of the aisle want to see the GSP renewed in a way that strengthens our trade relationship with developing countries. However, because of the Speaker's partisan insistence that GSP include unreasonable environmental criteria, this important program has been expired for over a year now. This is unacceptable, especially when the Senate has put forward a common sense, bipartisan GSP approach that House Republicans actually strongly support as well. These are just a few examples of the partisan position on trade that the House majority has taken in this legislation. I would be happy to discuss others as well. But in closing, I urge my colleagues to oppose this very overly partisan bill and instead pursue a bipartisan approach to crafting China legislation. The country wants us to work together on issues, especially like this, so that we can strengthen supply chains, not undermine them. Thank you. I yield back.
Thank you very much. And I welcome back again Chairman Meeks.
Thank you, Mr. Chairman. And Ranking Member Cole, again, for the opportunity to speak in support of HR 4521, the America Competes Act. You know, today the United States faces a changing and challenging international environment. And as China has grown in wealth and power, it has become global in its orientation and started to bend international rules to meet its interests, to bully nations over maritime and border disputes, and chip away at the prevailing economic, political, and security order around the world, and in ways that undermine the United States' interests. Our collective task is to navigate this stark new reality. You know, as President Biden declared last year, we're in a competition with China and other countries to win the 21st century. And HR 4521 positions the United States to do just that, to win that competition. It powers the engine of the American economy through investments in science, innovation, and technology. And it raises the flag of American diplomacy and leadership to reassure the world that America is back and to counter China's efforts to manipulate the international system and strengthen our alliances and our partnerships. Centering on diplomacy and bolstering America's global leadership and engagement are the themes of my bill, the Eagle Act, which serves as the Foreign Affairs Division of America Competes. The Eagle Act bolsters our diplomacy bilaterally and regional and allies. Also organizations through groupings like the Quad to ensure that we bring our partners and allies with us to prevent China from changing global rules. It demonstrates that America is capable and willing to tackle the world's biggest problems and marshal a response to shared challenges like the current pandemic. In fact, I delayed markup of the Eagle Act not once, but twice. And yet, negotiations spanning multiple months, Ranking Member McCall never shared a red line or comments on the vast majority of my bill. And ahead of our markup, he asked that I strip out the Republican provisions that I had included in the bill when it was introduced. But nevertheless, I ran an open process to move the bill through committee, including a grueling 4-day markup that spanned 2 weeks. Now, during that markup, we considered nearly 80 amendments, most of which were offered by the minority. And we held roll call votes on dozens of amendments. 20 Republican
I think Mr. Meeks froze. See if we can unfreeze him.
Mr. Chairman, Burgess here.
Yes.
I'll just offer the observation that for those of us who are in the Rules Committee hearing room, it is freezing in here. We wish the rest of you would join us so that all of us together could perhaps collectively manufacture a little heat so it wouldn't be so cold on the members who are showing up at the dais.
Yeah. Well,
We
that's
didn't do that on
intentional to
purpose.
help you kind of speed up your questioning. But let me see if we can turn the heat on for you. All right, so I think, let's give Mr. Meeks one more minute, and then if we will go to Subcommittee Ranking Member Chad. But if Mr. Chapman, why don't we go to you right now, and we'll see whether Mr. Meeks goes back on. Okay.
Sounds good. Thank you. Chairman McGovern and Ranking Member Cole, during my 25 years on the Foreign Affairs Committee, we've always prided ourselves on bipartisanship, and no issue demands bipartisanship today more than the generational threat.
Key to navigate and
Let me be blunt. The CCP's ambition to achieve global preeminence is the most significant threat to U.S. national security, economic prosperity, and yes, American values. We need to confront this challenge together, not as Republicans or Democrats, but as Americans. Unfortunately, the Foreign Affairs section of the America Competes Act, the EAGLE Act, doesn't meet this standard. It was rammed through our committee last summer in a rushed partisan process that didn't offer any meaningful opportunity for Republican input. What's even more regrettable is that as the Speaker cobbled together this bill, the Competes Act, she excluded Republicans once again. Despite 3 months of ongoing bicameral negotiations to craft a bipartisan bill that would actually counter the CCP, the Speaker decided to pull the rug out from under the talks and go it alone. The problem with the bill is it's all talk and no action. 2/3 of its provisions are findings, senses of Congress, policy statements, and other non-binding filler. It mandates over 170 reports. Legislating more bureaucracy and paperwork at the State Department will accomplish little more than bringing a knife to a gunfight in the international arena. Furthermore, the legislation fails to take advantage of critical national security tools in the Foreign Affairs Committee's arsenal. For example, the CCP is using U.S. technology to build hypersonic weapons. Yet this legislation fails to meaningfully use export controls to keep U.S. technology from supporting the CCP's military modernization or from supporting genocide for that matter. Further, while the majority claims this bill emphasizes alliances and partnerships, the bill completely omits foreign military financing upon which our allies and partners rely to stand up to CCP aggression. The bottom line is, this bill is an attempt to look tough on China without taking any real action. Instead, the real substance of the EAGLE Act is climate policy, an area where the Biden administration wants to cooperate with China. Perhaps the speaker should have called it the America Cooperates Act, or maybe the America Concedes Act. The bill shovels $8 billion into the Green Climate Fund and unaccountable UN slush fund that has already provided at least $100 million to China. And committee Democrats rejected attempts to prohibit the CCP from accessing billions more, as the bill authorizes another $2 billion every year that never sunsets. These huge arbitrary numbers are 4 times what the administration requested in the first place and are more than double the actual national security and foreign policy programs authorized in the bill. This is all a sad display of what everyone already knows about the Competes Act. It's not a serious effort to counter the CCP threat. It's a desperate political ploy in anticipation of the midterms. In sharp contrast, House Republicans take strategic competition with the CCP seriously, as evidenced by the amendments before the committee today. I'd like to highlight just 2 of them now. First, Foreign Affairs Republican leader McCall has introduced an amendment to fix some of the major national security failures of this EAGLE Act. His proposal would add foreign military financing and export control provisions. It would help stop the CCP from preying on American technology and investment to fund its military development and hostile industrial policies. It would authorize the Countering CCP Malign Influences Fund at the State Department and a counter disinformation and propaganda initiative to better combat CCP attacks on our values. And I've also offered an amendment that packages together 13 proposals from Asia Pacific Subcommittee Republicans, ranging from countering the CCP's gray zone threats to levying sanctions for involuntary organ harvesting from the Falun Gong, to strengthening our partnership with Taiwan, to protecting our economy against the CCP. Mr. Chairman, I urge this committee to give honest and fair consideration to these amendments and others brought forward by Republicans both on and off the Foreign Affairs Committee. Tough policies like these ought to be included to make this bill a truly serious response to the threat posed by the Chinese Communist Party. I thank you and I yield back.
Thank you. And will you finish, Mr. Meeks, or did you have additional?
I'll wrap up very quickly.
Okay.
Because what I was saying when I lost contact was that after holding all of those 80 amendments, most of them were offered by the minority, roll call votes on dozens of amendments, 20 Republican amendments were accepted and incorporated into the final bill, including bills that Mr. Shabbat led or was a part of, like the measure on China's censorship, a report on national technology and industrial base, strategy on economic coercion, Taiwan Diplomatic Review Act, Taiwan Fellowship Act, Taiwan International Solidarity Act. Those bills were sponsored by or supported by Representative Shabbat. And in addition to those Republican amendments, the EAGLE Act also includes several bipartisan measures from the bipartisan state competition bill and USICA. Additionally, it includes 24 other bipartisan bills and measures. Now, I heard Mr. Shabbat and others criticize the Eagle Act that it does not go far enough to confront China, even though it goes further than the Senate bill in responding to China's human rights abuses. In addition to the sanctions related to China's genocide in Xinjiang, the Eagle Act contains refugee protections for the Uyghurs and calls for a special envoy for Xinjiang. And I can say with absolute confidence that when it comes to standing up for the Uyghurs, Congress has never seen a bill stronger than the Eagle Act. So finally, some will agree that the Eagle Act dares to tackle climate change in a bill about China. Well, let me tell you this. China is the biggest emitter of greenhouse gases in the world. Not addressing China's contribution to climate change in a bill about global competition with China would be, in my humble opinion, foreign policy malpractice. And this isn't about just the environment. It's about America's ability to compete. Americans simply cannot hope to win the economic competition of the 21st century if we don't invest in clean energy and finance to create sustainable jobs for American families and workers. So I close with the challenges that's posed by the PRC are vast and they are urgent. And if we are serious about competing with China, leading with our values, and positioning America to succeed globally, then we must vote for and pass America Competes. This bill will revitalize America's industrial base, create jobs for American workers and families, and force China to play by the rules on the world stage. So, Mr. Chairman, I support this historic bill and respectfully ask that the committee do so as well and move this bill onto the floor for consideration. Thank you for your time.
Thank you very much. Representative Case.
Mr. Chair, Ranking Member, members of this committee, thank you very much for the opportunity to present a very strong set of provisions in this measure offered by your Committee on Natural Resources. Let me start by clearly stating the connection between the overall goals of this measure and the provisions within the jurisdiction of natural resources. First, international trade and commerce includes a plethora of natural resources, and that trade and commerce should forward our overall goals, and it should be international rules-based. Number two, supply chains are just as critical in natural resources trade as any other good and service. Number three, the U.S. has led the world in environmental, labor, and human rights standards, and we cannot allow countries who violate those standards in the extraction, exploitation, and export of natural resources to benefit economically to the derogation of our standards. Number four, we need to lead in the protection and perpetuation of our natural resources and, through our own commercial and trade practices, incentivize similar protections on those who do not prioritize our international resources. And five, natural resources know no man-made boundaries. The oceans, the air, the flora and fauna, it's all one big world and interconnected. In this context, and with respect to this measure and China specifically, the State Department reports that China is one of the worst offenders of any country in the world in key natural resources protections: greenhouse gases, marine debris, illegal, unregulated, and unreported, or IUU fishing, wildlife trafficking, and of course, human rights and slave labor. In response, the Natural Resources Division of this bill contains important provisions, many of which are bipartisan, bicameral, that will improve U.S. competitiveness globally and with China, will help us hold bad actors accountable, will secure America's long-term economic security, and will contribute to international protections of our precious world resources. The Natural Resources Committee division includes legislation to protect our oceans, combat wildlife trafficking, and ensure that seafood imported into this country does not come from illegal or slave harvested fishing practices. Title I addresses illegal fishing, slavery, and other human rights abuses in the seafood supply chain. China is a significant producer of unlawful fish products and, of course, a major concern for human rights abuses. The U.S. is the largest seafood importer globally, and 11% of imported seafood in the U.S. in 2019 was the product of IUU fishing. This title will strengthen laws to address IUU fishing and slave labor. This will allow U.S. fishers with fair labor practices and sustainably caught seafood products to obtain a fair price for their products instead of being undercut by fish projects from China who do not comply with international standards. The Natural Resources Division also includes a phase out of drift gillnet fishing gear and a transition program to more sustainable equipment on the West Coast in Title II, and in Title VIII, provisions to promote U.S. caught fish products and encourage U.S. government agencies to purchase seafood caught in the USA. Finally, Title 13 addresses the shark fin trade, eliminating domestic sales. China is one of the largest markets for shark fins, rendering sharks some of the most endangered fish in the ocean and severely risking our international marine ecosystem. Titles 4 through 6 of the Natural Resources Division include the bipartisan, bicameral Restoring Resilient Reefs Act, led by Representative Soto in the House and Senator Rubio in the Senate. Coral reefs are some of the most threatened ecosystems in the world because of climate change and warming, disease, habitat destruction, and the coral trade. In the U.S., coral reefs help protect some of our most strategic assets in the U.S. territories, Florida, and Hawaii. We should be leading the world in coral conservation and restoration. Instead, other countries like the United Arab Emirates have actually donated millions to us to restore our corals. These titles reauthorize the Coral Reef Conservation Program and address the needs of state and territories to conserve and protect their vulnerable coral reef ecosystems. The Natural Resources Division also contains provisions to address wildlife trafficking and disease threats from wildlife. Scientists believe that the coronavirus that caused the COVID-19 pandemic originated from the wildlife trade in China. One provision will expand the fledgling Fish and Wildlife Service law enforcement attaché program to build up a U.S. presence in wildlife trafficking hotspots worldwide. Another provision, again based off of a Senator Rubio bill, addresses loopholes in the wildlife trade that could spread disease by amending the Lacey Act to allow for emergency bans on wildlife imports that threaten human health. The Natural Resources Division also addresses emerging geopolitical issues in the Arctic and the deep sea. China, Russia, and other countries are introducing icebreakers and new shipping lanes in the Arctic, threatening the fragile ecosystem in Arctic marine mammals. Title III directs further analysis and cooperation to address marine mammal stranding and rehabilitation in the Arctic specifically. Deep sea mining for rare earth elements is the next frontier, and China plans to exploit the deep sea for minerals. Given China's ever-expanding claims to the high seas, the U.S. must take proactive steps to address and understand the uncertainties and environmental impacts. Title X directs studies on deep sea mining and carbon storage in the deep sea environment. Several amendments on both sides of the aisle will further strengthen U.S. leadership and competitiveness, boost ocean science and conservation, address wildlife imports, and build domestic energy sources. These provisions collectively from your Natural Resources Committee, I believe, constitute a solid, firm, and widespread foundation for the direct and correct treatment of natural resources in this bill. And we thank you very much for your consideration. I yield back.
Thank you very much, Congressman Westerman.
Thank you, Chairman McGovern, Ranking Member Cole, and members of the committee. I'm not even sure where to start. When we look at this bill and look at everything we've been through in this Congress, you know, I thought finally the majority party was going to bring legislation out that we could work on and be bipartisan. I thought it was going to be something that addressed a real issue in dealing with China and becoming competitive with China. And then we get this 2,900 page bill, $325 billion worth of legislation. And we find out it is just a front. It's not dealing with China. It's pushing a climate agenda. It's providing payoffs to special interest groups. And it seems to be the repeating story that we're seeing in this Congress and with this administration, with failed policy after failed policy. This is something we need to work on. We need to have bipartisan hearings. We need to have bipartisan legislation, and we need to address this real threat from the CCP. But I can tell you the only people I can see cheering this legislation on would be the CCP, because it seems ridiculous to have to say this, but punishing American workers, destroying American jobs, sending money to the UN that benefits China, that doesn't help us compete with China. It has the opposite effect. I know that seems very obvious, but unfortunately, whoever wrote this bill, I don't think got that memo. Again, Democrats say this is about competing with China, but the policies in this bill kill all kinds of American projects that actually make us more competitive. You may say you don't believe me, but there are enough examples that we could talk about all day long. I want to give you just a few of the examples and something we've seen recently. Just last week, on Wednesday, the Department of Interior announced its decision to cancel federal leases by Twin Metals, Minnesota, one of the largest potential sources of copper in the country. The decision is at odds with President Biden as he continues to advocate for a build-out of renewable energy sources. Even worse, it increases our reliance on China to achieve Biden's goal of electrifying America. I heard somebody talk about earlier about child slave labor. That's happening in the Congo with mining cobalt. When Chinese mines with child slave labor, Twin Metals would produce cobalt and do it sustainably. It would do it with the best environmental standards in the world. Yet this administration canceled those leases again. What's that doing to make us more competitive to China? Let's look at the ongoing bans that this administration is putting in place. The Biden administration and Democrats continue to support bans on new energy leases on federal land and waters, handicapping energy development on U.S. soil. This has led to our nation's export of jobs overseas. It makes us more dependent on foreign adversaries like China for our energy and critical mineral needs. The fact that Democrats continue to support these types of policies and refusing our workforce here in America to expand energy production where it is cleaner and safer, it's ridiculous. They would never export jobs, increase our country's reliance on nations like China, and ensure that foreign adversaries who lack proper environmental safety precautions and use child slave labor are leaders in the world's energy production. When is the madness going to stop? When are we going to look at real policies instead of policies that are just, special payoffs to unions, policies that hurt manufacturing and production here in the United States? Do you really think China cares about climate? Last year they built 38 gigawatts of coal-powered plants. They're going to have to build more of those to produce all the goods that we're going to need them to produce if we keep going down this road. And it doesn't stop there. Like I said, it's 2,900 pages. This legislation makes several amendments to the Lacey Act, amendments that were snuck in without so much as a hearing in the Natural Resources Committee, likely because Democrats knew the provisions would not stand a chance if they were vetted through regular order and the legislative process. The provisions give blanket authority to the U.S. Fish and Wildlife Service to determine what is an injurious species without any requirement for public input, advance notice or comment, dramatically expands Fish and Wildlife Service's authority to regulate movement of injurious wildlife within the United States, and makes wildlife importers guilty until proven innocent by requiring imported species to appear on a Fish and Wildlife Service white list or have it treated as injurious by default. These provisions will be detrimental to American industries such as aquaculture, which are already highly regulated businesses. This act proves that Democrats don't plan on changing the narrative anytime soon. If you look through this bill, it mentions climate change twice as often as it mentions national security. It mentions coral 394 times more often than it mentions China 374 times. The bill includes much of the radical Blue New Deal that's a heavy-handed federal government knows best legislation that will impose further regulations on those who depend on our nation's offshore and onshore waters. The Blue New Deal makes us more dependent on imported products rather than utilizing and conserving America's abundance of natural resources. It authorizes $2 billion in climate programming every fiscal year with no sunsets. The bill gives $8 billion to a green climate slush fund through the United Nations, the same slush fund that has awarded $100 million to China already. If you're not worried about accountability, you should be, because the UN slush fund has no safeguard in place. Taxpayer funds can be used to subsidize the Chinese Communist Party or fund solar and battery factories abroad and utilize, again, slave labor. This bill is bad. We don't have enough time to go over exactly how bad it is, but of course it's another bill that's being pushed through by the speaker. And it's not about combating China. It actually, I think, helps China. The only thing I know to say as I conclude here is that I'm often reminded of a fable by Aesop, where he talked about an eagle that was flying high one day, and all of a sudden he was shot by an arrow. And as he lay on the ground dying, he looked at the arrow and he noticed that something odd about the arrow. He said, "Alas, I've been struck by an arrow that was feathered with my own plume." That's exactly what legislation like this does. It puts the plumes on the arrows that hurt America. Let's work together on something that actually makes the U.S. more competitive against China, not these bills like this that hopefully have no future going forward, but are there for, obviously, for some kind of messaging or to appease the left base is the only thing I can figure out. I yield back.
Thank you. Chairman Pallone.
Thank you, Chairman McGovern, and also Ranking Member Cole and members of the Rules Committee. I'm testifying again on the Competes Act, and I do think this is legislation that helps put us on course to lead the pack in creating the strongest and most advanced economy of the future. But I'm going to focus on the provisions within the jurisdiction of the Energy and Commerce Committee, Mr. Chairman. First of all, supply chains. The America Competes Act will strengthen our economy by improving our nation's supply chains. And this is critical to our economic future, considering that over the past 40 years, America's manufacturing sector has lost market share to economic competitors like China. This decline in manufacturing capacity, coupled with the COVID-19 pandemic, has led to severe supply chain disruptions. The America Competes Act will prevent shortages of critical goods and ensure that more of those goods are made right here in the U.S. The legislation does this by investing $45 billion in grants, loans, and loan guarantees to support supply chain resilience and manufacturing of critical goods, industrial equipment, and manufacturing technology. It also establishes a new office at the Department of Commerce that is charged with monitoring supply chains to identify vulnerabilities or gaps that may disrupt the availability of critical goods. And this new office will also support the availability of critical goods to prevent shortages. Now, next, I want to talk about chips. The legislation invests $52 billion for the Chips for America Act, incentivizing private sector investments in superconductor fabrication. Disruptions in the semiconductor supply chain have been detrimental to major American industries in recent years, including automakers, medical supply chain companies, and manufacturers of heavy machinery. And this bill will help us end our over-reliance on other countries for production of these critical chips. Let me talk about solar panels. The America Competes Act also invests in building a domestic solar manufacturing supply chain. Today, we rely too heavily on Chinese manufacturers for our supply of solar panels and related components. China's control of the solar chain jeopardizes American energy security interests and subsidizes a Chinese industry that relies on forced labor. So this bill incentivizes the domestic construction of solar manufacturing capacity. It authorized the Secretary of Energy to award $3 billion in grants and directs loans to entities for the construction of new facilities that manufacture components used in the solar supply chain and to retool, retrofit, or expand existing facilities. I want to talk about the electric grid. This bill keeps our electric grid secure and resilient in the face of evolving cybersecurity and physical security threats. The bill authorizes $375 million to reduce the vulnerability of the electric grid by establishing a strategic transformer reserve and for the development, testing, and monitoring of critical electricity grid equipment. It also reduces the risk posed by foreign-made equipment by facilitating the domestic manufacturing, testing, and monitoring of critical electric grid equipment. Medical supplies. The bill improves our medical supply product supply chain and strengthens our strategic national stockpile. During the early days of the COVID-19 pandemic, I think we all experienced widespread shortages of essential medicines, medical supplies, and some personal protective equipment. The bill increases our domestic drug manufacturing base by expanding the use of advanced and continuous manufacturing practices. It establishes a $1.5 billion supply chain manufacturing pilot program, and that will help enhance supply chain elasticity and maintain domestic reserves of critical medical supplies. The strategic stockpile is strengthened. It strengthens our national stockpile by requiring that the contents in the stockpile remain in good working order and improves transparency of the stockpile supplies. The bill establishes a $10.5 billion grant program that awards grants to states to expand or maintain a strategic stockpile of commercially available drugs, medical equipment, PPE, and other products essential in the event of a public health emergency. And finally, Mr. Chairman and members of the committee, the America Competes Act innovates our wireless supply chain and network security. As consumer demand drives an increasing number and diversity of wireless devices, our nation faces converging security, supply chain, and other policy issues related to wireless networks. The bill ensures that next generation mobile wireless networks and technologies are safe and secure from foreign adversaries. It does this by funding the deployment of cutting-edge technology and enhancing the competitiveness of trusted suppliers of information and communications technology. So overall, this is a comprehensive bill and ensures that America can outcompete China or any nation in the world now and in decades to come. It brings together many bills that have garnered strong bipartisan support in the past, and I'm hopeful it will pass with the same bipartisan spirit. I urge my colleagues to support it, and thank you for the time, Mr. Chairman and members of the committee. I yield back.
I now yield to Ranking Member McMorris Rogers.
Thank you, Chairman McGovern, Leader Cole, for inviting me to testify. I agree with many of the sentiments of my Republican colleagues. Unfortunately, this isn't just a missed opportunity to boost America's competitiveness. I see this as actively setting us back in our goal to beat China and win the future. The Chinese Communist Party tries to compete with the United States and other free market economies by cheating, stealing, and using their centrally controlled economy to pick winners and losers through massive government subsidies. Instead of embracing free markets and American innovation and ingenuity, this legislation tries to copy China's own dangerous path of centralized industrial policy and massive government handouts that benefit the ruling party's political allies. We cannot, and we should not even try to beat the Chinese Communist Party at their own game. This isn't the American way. We've done more to raise the standard of living, lift people out of poverty, cure diseases, and spur technological innovation than any other country in the history of the world. And we've done it by cherishing freedom, free markets, human rights, and respect for human dignity. Where success isn't contingent on the approval or the direction of the federal government. Where hardworking, creative thinking, and risk-taking are rewarded. Where an idea can become a million, billion, or trillion-dollar company. The approach of this bill ignores this recipe for success and instead attempts to cover up the many crises created by the Biden-Harris administration and this Democratic Congress through more wasteful spending. Virtually every piece of the Democrats' agenda from the last year under one-party rule hurts America's ability to compete globally. Their war on American energy has set back our energy independence and harmed our economic and national security. while making us more dependent upon China. Their record amount of government spending has created rampant inflation and made everything more expensive. A trip to the store means Americans are paying more for beef, eggs, chicken, and other groceries. That's if the stores are shelved and stocked. Their regulatory agenda have made doing business in America even harder. Speaker Pelosi's drug pricing control scheme will destroy American medical innovation. Their radical environmental agenda will make it impossible to have a domestic source for the critical minerals and chemicals needed for advanced manufacturing, and make it even harder to build in the USA. And their push over the last 2 years to keep our schools closed will set back an entire generation of Americans. If we were really focused on how we make America more competitive, we would abandon this bill and work together to reform our time-consuming and costly permitting, licensing, and regulatory regimes. These are the kind of reforms that we need to truly unleash a new era of American innovation. Sadly, Speaker Pelosi has chosen to double down on more reckless tax and spending that benefits political allies, but it's going to result in waste, fraud, and abuse and increase our dependence on China. While there's some bipartisan provisions from the Energy and Commerce Committee included in this bill, the main provisions in ENC's title are extremely problematic. Like many other parts of the bill, the Democrats have inserted labor requirements into what was a previously bipartisan program that would help spur development and deployment of advanced communications infrastructure. Instead of helping us beat China in 5G and close the digital divide, these new requirements will make it harder and more costly to deploy next generation communications, further ceding leadership to the CCP. A new grant and loan program, $3 billion for domestic solar manufacturing at the Department of Energy, an approach that forces people to do things the way the government wants them done. This approach ignores the mistakes of the past and instead doubles down on the failures that led to Solyndra. Only this time, there's less controls on waste, fraud, and abuse. It's really supercharged Solyndra. This bill also fails to promote American manufacturing by ensuring that taxpayer dollars do not fund the purchase of materials and parts from China, who remains dominant in critical minerals and materials needed for renewable technologies. Again, what we see is that the majority is picking winners and losers through their rush to so-called green, which is only playing into China's goals. Finally, there's this brand new $45 billion supply chain resiliency program. And unfortunately, it's just a slush fund. This expansive new program prioritizes labor unions, blue state mayors and governors, and other Democratic political allies over the businesses and the entities that can actually make our supply chains more resilient. It also allows these taxpayer funds to go to other countries, including an ambiguous category of key international partners. It's not defined. This ambiguity would give the administration tremendous leeway to direct funds to foreign countries that may not have America's best interest at heart. We've seen a disastrous withdrawal in Afghanistan, pacifying Putin by approving the Nord Stream 2 pipeline and working to appease the Ayatollah for the failed nuclear deal with Iran. I am very concerned, and I don't trust the administration to decide what constitutes a key international partner. This legislation is the wrong approach. I urge my colleagues to abandon this plan for more reckless spending, more command and control that surrenders America's competitive edge to China. Let's work on a real solution to make us more competitive, make new and better products more efficiently, less expensively, to win the future and offer a better life for all. I yield back.
Thank you very much. Thank you to everybody. I want to ask unanimous consent to insert in the record a list of the bills that are in the Competes Act that have actually, most of them are bipartisan, that have passed the House, that have been put together here. And also a list of all the hearings and markups that were conducted on these and other bills that are part of the Competes Act. Look, I mean, it's clear that people have different opinions here. There's nothing I'm going to say that's going to convince my Republican colleagues to support those who testified to support this. I appreciate everybody being here, and I will turn this over to my ranking member, Mr. Cole.
Thank you very much, Mr. Chairman. You know, heat in the hearing room might work. Thank you for your efforts, by the way. I know you're trying to do that for us, and want to thank my colleagues. I've had 2 hot cups of coffee sent to me by generous colleagues, so I appreciate.
I have a blanket that I offered to give you.
I know, which you did, and again, you look after your members on both sides of the aisle. We appreciate it. Absolutely. I'm going to be less kind about the bill. I think the fact, and this was alluded to by a couple of the folks that testified, that we have roughly 600 amendments, more than Democrat than Republican, kind of tells you this didn't go through any kind of normal process. Most of these matters would have been dealt with in committee. They shouldn't be dealt with by the Rules Committee in a 3,000-page bill. We don't even know what this bill costs because there's not a CBO score with it yet. They haven't had time to do that. And yet my friends are anxious to rush it onto the floor. Just to make that point, I'm going to sort of go around to all the Republican members and start with a pretty simple question. And I'll start, Mr. Weber, if I may, with you, that you testified first. Did anybody reach out on the Democratic side and consult with you at the staff level, their member level, on a bill of this size and magnitude, which contains many elements that you did deal with in separate items? But again, any effort to work across the aisle with you?
None whatsoever, Mr. Ranking Member. And it's really sad because exactly what I said earlier, the Science Committee is probably one of the most bipartisan committees here amongst us. And we did a lot of great work. We joined forces and we put out a lot of good bills. Unfortunately, and I appreciate you calling on me, Mr. Cole. Unfortunately, this is now the second time in the past month that the Speaker's office has actually hijacked what was a bipartisan Science Committee bill to pass a really partisan package that we all know is going nowhere in the Senate. Nowhere in the Senate. And just 2 weeks ago, a simple but important NASA bill, the Democrats used to hijack and pass to implement a federal takeover of state elections. You can't make this stuff up. And now, as I think most of us have been saying, and Republicans decrying the fact that the Speaker has taken another bipartisan science bill, committee bill, what we call the Bioeconomy R&D Act, and added over 3,000 pages filled with partisan poison pills from 11 different committees. What was a science committee, very bipartisan bill. So no, Mr. Cole, they have not reached out to us at all, and it's a travesty what they're doing. I appreciate the question.
Thank you. Mr. Smith, again, any effort on ways and means to reach across the aisle and work with you?
No, Mr. Cole. It's unfortunate, but in short, no, there has not been any opportunity to work together on this. Thank you.
Thank you. Mr. Shabbat, how about you? I mean, we want to speak with one voice overseas when we confront our most dangerous competitor. Any effort to reach across the aisle and form a bipartisan bill? Your committee?
Thank you for the question, Mr. Cole. There were four corners negotiations that went on for some time between the various parties, but then ultimately we were presented with a 600-page bill, mostly from leadership, and the input was relatively insignificant. I'm not to say there wasn't any input at all. They did accept a few amendments, including, one of my own. But overall, we were presented with a product with a few weeks to consider it. It was something like 600 pages long. And we wanted a bill that was essentially a bill that was going to be tough on China. It was actually going to deal with some of the abuses that American businesses are going to have to put up with, the human rights abuses that are taking place. And ultimately, this product is deficient in so many ways. We've heard testimony over and over again from the folks here today about how flawed it really is. So that would be my comment on it.
Okay, Ranking Member Westerman, any effort on natural resources to work in a bipartisan manner on this bill?
That would be another goose egg, Ranking Member Cole. No effort whatsoever. And obviously there's provisions in here that would have created some very heated discussions in the committee had we actually had hearings on it.
And finally, Ranking Member McMorris Rogers, any effort on your committee to work in a bipartisan manner on a bill of this magnitude and importance?
Unfortunately, there was not an opportunity to provide input as to the provisions that were included in this bill. There are some energy and commerce bills that we've worked on. There's other ones though that were changed, that were bipartisan, that were made partisan by attaching other provisions to the bills that had already been negotiated. And when you put them into a larger bill that includes so many other issues that are of concern, it is not negotiating in good faith.
That's amazing. We have legislation that when the Senate did it, passed almost unanimously. Over here, obviously a very different story on this side of the rotunda. Mr. Weber, let me go back to you. As you rightly point out, you have represent a very bipartisan committee, and you've worked together, Democrats and Republicans alike, which is a credit to your chairwoman, very, very well. I know how highly Ranking Member Lucas thinks of Chair Bernice. Just amazing working relationship. But you also alluded in your comments to some poison pills that have been added to bills that had previously been bipartisan. Could you enumerate some of those for us?
Oh my gosh, how much time do we have?
Well, in deference to the chair, let's try and just pick a few of the greatest hits. Don't run through the whole album.
I don't want to lower the thermostat anymore.
Man, he's cold-blooded, isn't he, Mr. Cole?
He must. He's a tough customer. He's from Massachusetts. He can handle it a little bit better than those of us from Texas and Oklahoma.
There's all kinds of things in it, quite frankly. The one that I did allude to, of course, was their intent to knock out fossil fuels in the developing countries that need it the most, because as I said, tried to be as brief as I could. I know that perhaps Mr. Chairman McGovern doesn't think so, but when you're trying to develop a country, there's two things you need. You need a clean water supply, and of course you need energy. You've got to get that water out. You've got to be able to build infrastructure and to be able to exist and have that ability. Fossil fuels are the only reliable way. And not only that, but as those, and I would offer this, Mr. Ranking Member, as those countries develop, guess what? There's going to be a market for American energy. We are, as I think one of you all pointed out earlier, that Mr. Biden has opened up the Russian gas, the pipeline, while killing the Keystone pipeline. We want Europe to buy American LNG and American gas, not Russian gas. And we're all watching what's going on with Ukraine. This is going to embolden this is the exact kind of bill where they put so many poison pills in instead of focusing on what we need to be focusing on, taking China to task and getting back our free market and all the things we need in supply chains, doing away with inflation and all the bad things that has happened under the Biden administration. Yeah, this bill is going to empower not just China, but Russia. And you can think of North Korea, and you can think of Iran, because we get so sidetracked. They're so focused on this Green New Deal that the things that really help these countries, their economy, and with their development, which somebody pointed out, America has led the way. We have done more to develop countries than anybody else. These are the kinds of poison pills, whether it's the fact they don't want fossil fuels, whether they want to sidetrack us on all kinds of things, especially at a time when they know it's not going anywhere in the Senate. These are the kind of things that make this $3,000 page bill, just unbelievably, I mean, it's rank with so much poison pills. I could spend all day here going through them. And that's why I say my colleagues ought to vote no. All of us really ought to vote no, but the Democrat leadership should, quite frankly, in my opinion, be ashamed of themselves for hijacking yet another science committee bill and using it to push something that really isn't in America's best interest and in some of the very developing nations we're trying to help in their best interest. It's just unbelievable. Thanks, Tom.
Thank you very much. To my friend from Ohio, Mr. Shabbat, you talked a good deal about some of the deficiencies of the bill in terms of just using the basic tools of national security that are available that you would normally think would be in a bill that's again aimed at our major competitor and antagonist on the globe right now. But a lot of this appears to be climate change as opposed to national security, although some people would maybe argue those are two things that are similar. But could you tell me some of the things you think ought to be in this bill that aren't there in terms of national security?
Yes, there's a number of things, Tom. And as you indicated, this is overall it's climate change. That's what this is about through and through. $8 billion slush fund, and then billions of dollars a year after that. That's not what it should have been. As the ranking member of the subcommittee that has jurisdiction over China, one of the biggest things that strikes me is that the CCP, they've been trying to claim territory of at least 7 of their neighbors, and it's backing up these claims with the largest peacetime military modernization in history. 2 of the most powerful authorities to address that are in the Foreign Affairs Committee's jurisdiction. The first is the security assistance. The Senate authorized a good bit to help our allies to push back on the CCP. There's 0 of that in the bill. The second is export controls. That's another thing that we actually could have had in the bill, which we could have done something about. We really scratched our heads when the CCP achieves technological breakthroughs like its recent hypersonic tests. That unfortunately caught a lot of people off guard. The answer to that type of thing is somewhat simple. It's currently there are weak export controls that let key technology flow from our country into the CCP. Even when we restrict companies like Huawei, the Department of Commerce gives licenses to sell them technology anyway. Export controls may sound a little wonky, but it's straightforward. Do we give the CCP technology for their next generation of weapons or even a surveillance state? In other words, they will use our technology to achieve their military dominance over us and our allies. You'd think that in a bill like this, where we're trying to counter China, that we would have gone big on export controls, but this bill, as I said, really isn't a China bill, it's a climate bill. And so maybe we shouldn't be surprised with what's been going on. So there's so many things that unfortunately could have been done in a bill like this where you're really countering China that were left undone. And that's most unfortunate because we had an opportunity here. It could have been bipartisan, but essentially the leadership came in and dropped this big mess in our lap and said, here, you pass it. And then they give us a couple of token amendments and we move forward. And then they'll say, well, we've done something about China now, when in actuality, we've done very little.
Thank you. Ranking Member McMorris Rogers, 2 areas I wanted to ask you about because I think they fall somewhat in your area. Number 1 is you mentioned there were some international slush funds. I'd like you to go through what you would define as a slush fund and what access the Chinese might have to those monies. And number 2 is the whole issue of supply chains, what this is supposed to be directed at. And if you have any concerns in those areas as to whether or not this will be helpful or harmful in terms of making our supply chains more resilient and frankly, making us less reliant on China.
Right. Well, those are really good questions. And those are the questions that I think are on the hearts of many Americans. when I refer to the slush fund, one of it is it's a $45 billion fund that's created in this bill. It's not in the Senate bill. I had the opportunity to talk with the Commerce Secretary last week. She couldn't really give me a lot of details on it. Now, the title of it says it's to make supply chains more secure, but we really don't know what those details are. And it refers to allowing for facilities located in key international partners, and that's not defined who these key international partners are that get to take advantage of this funding. So instead of it really focusing on how to create domestic supply chains or address what's going on with supply chains in our country, it leaves open this question as to these key international partners. And I think it just goes to this overall approach that I see coming out of the majority a lot, where it is, they just spend, they put out money, spend first, and then answer the questions later. And it's a top-down government knows best approach. I asked the Secretary of Commerce, what are we going to do about permitting? Amazon told me just recently that they have this goal of being renewable, 100% renewable by 2025 in the United States of America. Their biggest challenge is permitting, because it takes 3 years to permit a solar farm in the United States. And that's where this bill is failing to address some of the challenges here in America. It's failing to address permitting, regulations. It's failing to look at mining and access to raw materials in the United States. It's throwing a lot of money out there, potentially to key international partners too, but it's not addressing the underlying issues that we need to address to make sure that our supply chains are secure here in the United States of America.
Let me go next, if I may, to Mr. Smith. Since obviously one of the great areas of competition we have with the Chinese is trade. And we know there's an enormous trade imbalance. There has been for a long time. Are there any things in here that you think will improve and or hurt our ability to compete more effectively with the Chinese in the area of international trade?
Well, I think when you look at undermining the supply chain, that parts of this bill would actually do, that's what concerns me the most economically. I think, there are components to the bill that are unrelated to trade, or especially unrelated to China. Typically a trade adjustment assistance has been associated with, say, TPA, Trade Promotion Authority, or a trade agreement that brings both sides together. But this basically eliminates that opportunity moving forward. And I would say anything that harms trade is something that harms the supply chain right now. Right now, we are in such a crisis that I cannot imagine losing more ground than we've already lost. So those are my concerns, and I would think that working together could really alleviate those concerns.
And let me finally go, if I may, to Mr. Westerman, Ranking Member Westerman. I know how hard you've worked in your tenure on the whole issue of critical minerals. We all understand that that's one of the areas where China has enjoyed a great advantage over us. Its willingness to exploit the resources it has. Sometimes we're not as willing to use the resources we have. What in this bill, if anything, addresses the critical mineral issue, and what would you like to see that might help us in that regard?
Thank you, Leader Cole. That's a great question. And unfortunately, the answer is nothing. There's nothing in this bill that makes the U.S. more competitive with China on critical minerals. If you look at what China's been doing, they've been hoarding critical minerals and elements from around the world for quite some time now. And this bill actually makes us more dependent on China. And it's not just this bill, it's other actions that the majority and the administration are taking. If you remember back to the Build Back Better bill, there was a line item in there to pull a lease on a copper mine in Arizona that would supply 20% of the U.S. demands for copper over the next 50 years. $2 billion have been spent developing that. Fortunately, that bill failed, just like I think this bill will fail. But this administration is taking actions like they did last week to pull those leases from Twin Metals in Minnesota. That's just taking our resources off the table. If you look at the numbers, China controls 94% of the global supply of gallium that's used primarily in electronic circuits and semiconductors and light-emitting diodes. They own 80% of the global supply of rare earth elements and 60% of the global supply of lithium, as we all know, is used in rechargeable batteries. The list goes on and on. The thing is, we have those resources here. America's been blessed with abundant resources, with minerals and elements. Not only could we not be dependent on China, we should be focusing on legislation that allows us to develop those minerals and elements. As Ranking Member McMorris-Rodgers said, you can't permit a facility here in the U.S. Even if we could mine, which that seems to be off the table, permitting and building a new refinery and a further processing and manufacturing is extremely difficult on U.S. producers. It shouldn't be that way. We have amendments that we're going to offer. Representative Waltz and Representative Stauber have worked on a lot of amendments to address these issues, but the way this process is going, I have little, if any, expectation that these amendments will even be made in order. It's really a shame. It's a missed opportunity. We could be doing so much more to build our offense, if you will. If we're talking about competing with China and competing with others on the global stage, we need a stronger offense. We need to be the innovators. We need to be the ones building and making things, not just shipping our wealth overseas and thinking somehow that's sustainable. But no, this bill does nothing on the positive for our supply chain when it comes to critical minerals.
Thank you very much, Mr. Chairman. First of all, thank you for your generosity with the time. I appreciate that very much. And I think the members I questioned made an important point, which is they all felt in their areas of the bill that they were unconsulted and left out of the process. That's exactly the opposite of what happened in the United States Senate. And that measure has been sitting around here since June. I mean, to rush and throw this together at the last minute at the leadership level, the Speaker's office, breeds division, makes it impossible for things that had been bipartisan to move ahead, as the number of our members suggested. There are a number of items in here that they support and have worked on, but sadly, that did not make it through. Mr. Smith, did you have a concern or question?
Sorry, I didn't catch that.
Okay, I'm sorry. I thought you might have, I thought you were trying to get my attention. I regret that. I saw you and said you're getting some water that I'm sure you need. But anyway, again, as our members have said over and over, this is a missed opportunity. This is an area we could have cooperated. This is an area where the Senate actually did cooperate, and we've missed that opportunity here now by moving ahead willy-nilly. And I think, honestly, there's not been a single hearing on this bill as a bill. There have been hearings on component pieces, but as a bill, it hasn't gone in front of any committee for input. And again, that's why we've got 600 amendments to sort through, and those were thrown up, again, the majority of them on your side of the aisle. That should have been taken care of in committee amongst your own members. But again, I'm sorry we're proceeding in this manner over a bill that I think we could really have worked together on, and it is a tremendous missed opportunity. But again, thank you as always, Mr. Chairman, for your consideration, your professionalism, and I yield back.
You're on mute.
Go ahead. Yeah, let me just say for the record that we could have, and I speak for the Democrats, we could have the most perfect bill in the world. It would still have 600 amendments. As I look through, as I said in the beginning, many of these bills have already passed the House that are part of this bill. And, clearly the subject matter has been the subject of many hearings in the various committees here. So this will hopefully pass the House. We conference it with the Senate. We will have a finished product back here. But I do want to say that I think this represents a solid effort to address a whole range of issues in our dealings with China, including human rights, by the way. I recall the previous occupant of the White House dismissing much of the human rights concerns in China, even going so far, as reported in the New York Times and other newspapers, as turning a blind eye to the internment of Uyghurs because he didn't want to jeopardize our trade policy. So hopefully, we are moving in a direction that if we're not all together now, that at the end of the process, we will be. Ms. Torres.
Thank you, Mr. Chairman. The American Compete Act is a strong foundation for future economic growth that will help the American people create good jobs right here in the homeland. This work is crucial to expanding opportunities for Americans and to ensure the future innovations that will continue to drive our economy. I think Americans often forget the key role that the federal government plays in driving innovation and change. For instance, the graduate project that became Google sprang from a grant from the National Science Foundation. This bill will ensure that future innovators have the resources to succeed and help our economy grow in new ways, and that our businesses can thrive right here at home. I've offered a few amendments that I believe will improve this bill further, in which I hope they will be made in order. One of those amendments will help our manufacturers address future problems in the supply chain by creating a database for users of the Manufacturing Extension Partnership Program. I also want to thank the Biden administration for addressing the issue of the supply chain created by this horrible murderous pandemic. In my district, I represent an inland port, and we saw immediately with some very basic policy changes that they implemented within with less than a week, 40% of those ships had been unloaded and shipments moved on. As a result, no, the Grinch did not steal Christmas. One of the amendments would allow small manufacturers to collaborate and both find and address holes in our supply chain before they become a broader issue for our nation. Two of my amendments will help ensure that we work to remain global leaders in diplomacy, that we also are promoting our core values of strong democracies, independent judiciaries, and the rule of law. Additionally, I have offered an amendment that clarifies that our work in economic development in Latin America must include the most valuable groups like Indigenous and African descendant communities in Central America. This bill responds to our nation's most critical needs, and I'm proud to support it. Thank you, Mr. Chairman, and I yield back.
Thank you very much. Dr. Burgess.
Thank you, Mr. Chairman. I got a number of things I have to say about this, but before I get into that, I would like to point out to my colleagues on the Committee on Science, Space, and Technology. It was 19 years ago today. I was serving on my first congressional committee, and we received word that the Space Shuttle Columbia did not make it safely back to Earth. So just to acknowledge that sad 19-year anniversary, the work you do on the Space Science and Technology Committee is extremely important, and certainly want to never forget the sacrifices that are made by the men and women who serve at NASA on our behalf. Mr. Chairman, this is so frustrating to be back with this type of product in the Rules Committee, where we are at the Rules Committee level. We are now basically having to be, we're doing the entire hearing on a 3,000-page bill. I say 3,000 pages. I don't know if we know that the bill is entirely written at this point. the drafts that were available in the few days prior to this rules hearing didn't even seem complete. So I don't know if the staff in the speaker's office has finished writing this damn thing or not, but it is so frustrating that after all of the omnibus and reconciliation bills that have been forced through this Congress, here we are again with this bill at this late hour. And you know what, Mr. Chairman, I just spent the last 10 days in the district and no one was asking me about this bill. Now, yesterday, I went and visited the Dallas office of the FBI. They had just had a significant incident down in Colleyville, Texas, just outside my district at the Congregation Beth Israel Synagogue, where unfortunately a terrorist had taken some people hostage. The Colleyville Police Department, the Department of Public Safety of the state of Texas, and the FBI, they all worked in tandem together to get that situation resolved, where the only harm that occurred was to the perpetrator of the event, and all of the hostages got out safely. And I did want to thank the FBI for their efforts in that. I was proud of of how they conducted their operations. But the questions I got from them were not about the China bill. They were about, are you going to do an appropriations bill? Are we going to end up unfunded in an appropriations lapse in 2 weeks' time? That's their main concern. Are all of our investigations that we've got ongoing, are they going to suddenly have to hit pause because Congress hasn't funded us for this fiscal year? And are we going to face another continuing resolution where we can only spend money that was previously appropriated? Or are we going to go through a normal appropriations process where the federal agencies know that Congress, in fact, has an interest in how they conduct their business? But unfortunately, I couldn't answer their question because I don't know. We're going to work on a China bill instead. No one was asking for a China bill at home. I did meet with a group of doctors and nurses at the intensive care unit at one of the Texas health facilities in Frisco, Texas. They're working on a new approach, a new treatment for individuals in the ICU with coronavirus infections. As you know, there's very little to offer someone once they get to the ICU level of sickness. And fortunately, under some provisions in the Right to Try Act, which our Energy and Commerce Committee passed and signed into law in 2018, they are able to offer some therapy to patients that shows an extreme amount of promise. But they keep entering bureaucratic cul-de-sacs at the FDA. And our committee, which could be doing some work in this regard, unfortunately has not. We had a big reconciliation bill in February. We're going to crush the coronavirus. We're going to do the American Rescue Plan. We're going to be past the coronavirus by next February. Well, guess what? It is next February, and we're not past the coronavirus. And this dedicated group of doctors and nurses who are working their hearts out trying to take care of patients who are ill with the coronavirus infection, they would like to see an FDA that at least seems like it's on their side, that it's not going to continually deflect and delay new therapies that they believe hold a lot of promise. Look, I also spoke with a young woman who is facing a multiple organ transplant situation, and it's tough. Hard to know how all that's going to work out, but their question to me was, well, do the federal agencies understand how important the work that they do is? Are you talking to them about that when you do their big funding bills? And the answer I had to give was, well, we don't do their funding bills the old-fashioned way anymore. We just simply lump some money to them, and they do not feel that they owe us any type of response at the legislative level. And Chairman McGovern, you know, we've been through this before. This bill, though, that we find in front of us today, and Mr. Shabbat, I do so appreciate you talking about the hypersonic technology that should have been excluded from disclosure to the Chinese. This hypersonic weapon, has it occurred to anyone this is not a defensive weapon? This is a first strike weapon. that they are developing with our technology, and now we're going to give them more money. What's the main thing on the minds of our constituents today? It's inflation. It's empty grocery shelves, as Ranking Member Morris Rogers pointed out. Inflation is rampant because of all of the federal dollars that we've pushed out into the economy when the economy couldn't deal with it. And now here we are today pushing additional federal dollars out in this massive China bill. So I do need to ask the question of every chairman that is here today. I am the Republican leader's designee from the Rules Committee to the Budget Committee. As a Budget Committee member, I was anxious to look at the Congressional Budget Office assessment of this bill, but I'm told there is not one. Do any of our chairmen who are here today want to address the issue of moving a bill of this size and scope without any input from the Congressional Budget Office? I'm not seeing any takers on that. I just have to ask, what is the rush that we've got to get this thing through without even knowing the budgetary impact of a bill of this size? I've kind of coined the term China bus for this bill. It's like an omnibus China bill. Are we looking at any new reporting requirements so that we can keep a better tabs on the dollars that are going to be invested as a result of this bill? Are there reporting requirements that haven't been available to us before that this bill is going to now establish? Any of our Democratic chairs want to offer an opinion on that? Ranking Member Morris Rogers, did I see your hand go up on the screen? It's hard for me to deal with a Zoom meeting. I wish you all were here in the committee hearing with us. The room would be warmer if you all were here.
I agree. We do better when we're in the room together. This virtual only makes this harder, but I just wanted to confirm, Dr. Burgess, that I share your concerns that you're articulating about the amount of money in this bill and that we do not have the score. We don't have the Congressional Budget Office. It's being rushed through. We've worked on separate provisions, but this overall bill that's being brought forward today, this is not the way to legislate. And to your point, the American Rescue Plan that was passed in February, almost a year ago now, $1.9 trillion. We can't get answers as to how those dollars are being spent. And yet now we're talking about another massive bill that is not going through the regular order, the legislative process. It's very important that we are exercising that power of the purse. And as I mentioned earlier, inflation is absolutely hitting our country, the continued spending. And I know sometimes I feel like the Democrats think, well, put a lot of money and say, well, we're doing a China bill and we're putting a lot of money behind it, that solves it. And that there's so much more involved in making sure that America is competitive, that we're addressing supply chains. You were talking about some people you met with. I recently met with the Steelworkers Union in Spokane, Washington. These are the steelworkers that work at Kaiser Aluminum. And they were telling me they're concerned about losing their jobs to China. They're doing a lot of work around carbon intensity, around making sure that the water's clean. The water now that's discharged into the Spokane River meets the clean drinking water standards, but yet it's not clean enough. And they were just impressing upon me that they're proud. They're 75 years old. This union was established when we were trying to help, they were part of helping win World War II. And yet they're concerned about their jobs going to China because we can't compete. And they said, Kathy, one of the guys, he said, a real infrastructure package would have included mining in the United States of America. That's what we need to do. We need to address the real issues, and throwing money at it, and in this case, we don't even know how much money, doesn't solve the problem. And I think we got to go to the root issues here. That's permitting it's the regulatory environment, it is access to raw materials. There's a lot of issues that need to be addressed that I think most Americans realize it just doesn't make any sense that we're not addressing them.
Well, I appreciate your input on that. Honestly, there are numerous new reporting requirements that are going to be asked for in this bill, but I'm missing where the concrete ways that we actually counter the malign effects of the Chinese Communist Party. Chairman Pallone, can I just ask you, you got an idea off the top of your head how many new reporting requirements are in this bill?
I don't know about specifically about the reporting requirements, but there's a number of incidents where there's reports, IG reports, whatever, that have, that reports that have to get back to us, if that's what you're asking me about, in terms of the different sections of the bill. So yes, there is reporting requirements, particularly with regard to the Inspector General's reports.
166 new reports that we are now going to require, but we don't take any real action. And, in our committee, in the Committee on Energy and Commerce, I mean, this has been an ongoing issue. When Chairman Dingell was chairman of the committee, I remember all of the hearings he had on food safety, and it always came back to one issue, primarily one country. You remember the hearings that he had on the antibiotics that contaminated the honey that was being imported from China. There was a fish that had some type of dye in it. There was the infamous problem with the gluten meal that poisoned pets all over the United States of America. Veterinarians couldn't figure out why they're seeing so much end-stage renal disease in dogs and cats. It was because melamine was being crushed up and put in gluten that was sold for pet food. And I don't know that we ever did anything about that. We all remember in 2008, the heparin scandal, where China had contaminated the heparin supply. It affected a lot of dialysis centers around this country, where patients actually died from being injected not with heparin, but with hypersulfated chondroitin sulfate, which turned out to be a molecule that was patented in China, that was used to contaminate the heparin supplies. And we had multiple hearings in Energy and Commerce, but I don't think we ever came to a conclusion about it. And then, of course, the two big ones that I call the chemical and biological warfare against the United States, fentanyl, which has come into this country unabated, and now we're at historic levels, historically bad levels of overdose deaths in this country. And we're about to pass a historic milestone on the number of coronavirus deaths.
Well, Dr. Burgess, look, let me just say a couple things. First of all, as many as has been said,
Actually, Chairman, that in this committee, the time right now is mine. So let me finish my thought, and then I'm happy to yield to you.
I'm sorry.
But we've had no hearings. We've had no effort to hold China accountable or even look into the origins of the coronavirus. And yet every one of us would agree it's had a devastating effect, not just on our country, but on the world. And I don't understand why. I don't understand why we would not be more aggressive looking into that. Our committee is not one.
You tell me when I can speak.
It's a time. I do control the time. The Energy and Commerce Committee. It's painful to me to watch the Energy and Commerce Committee be so passive in the face of what is happening, what is currently ongoing.
Well, that's not fair, Dr. Burgess. I mean,
I will be happy to let you respond, but it is important that we assert our authority as one of the main authorizing committees in the United States Congress and exercise that authority over China and not give them new opportunities to exploit the situation. So I'll be happy to recognize you now for your response.
Well, first of all, I think that I believe, I mean, I can give you all the dates that we've had hearings on so many of these things with regard to the coronavirus. And as even the ranking member said, many, I would say most, in this case, most of the bills that are in this America Competes app that have come out of our committee have actually had a hearing, come out of committee. Many of them have even passed on the floor and sent to the Senate. So in terms of this particular bill, almost, I think with a couple of exceptions, almost everything in here has either come out of the committee or passed on the floor already. We've had many hearings on the coronavirus and what's happening. In fact, we have, I think we have a hearing tomorrow on the whole issue of price gouging during this period. But what I wanted to say, if I could, just briefly too, is, you know, I heard the ranking member say, and I respect her a great deal, as I do you, Dr. Burgess, that the problem with this bill is that, you know, from what I understand, what she's saying is that we should just have we should be in favor of a market economy and not try to help, have grants. She talked about the $45 billion loan package. My problem, the problem that I see with China is that they continue to subsidize, they continue to have this sort of command and control approach. And so many other countries are doing the same thing, which makes it very hard for us to compete. So I do think to some extent we do have to have programs that, give money, if you will, to a manufacturer who wants to relocate to the United States or wants to develop some new technology in the United States, as we do with this $45 billion package. If we don't do that and we just say, okay, we'll just have no barriers to trade, the other countries are going to continue to eat our lunch. I mean, the problem I see is we continue to say, okay, laissez-faire, let's do everything. Everybody can sell their goods here. We'll sell their goods there. But they don't buy our goods because they have all kinds of barriers, and they subsidize everything, not just China, but so many of the other countries. So I do think it is important for us to have some funding that says, look, if you want to move your manufacturing facility here from wherever, from China, we'll help you do that. If you want to develop a new technology here, we'll give you some help with grants or loans so you can do that. If we don't do those kinds of things, which is the heart of this Competes Act, to help companies that want to relocate or do things here or develop technology or do research here, then we're never going to be able to compete. So, I kind of disagree with some of the ideological things that are being said here on the Republican side, because we're trying to compete in some ways by, helping these businesses relocate and do things here. I don't think you can expect them to do that unless they get some help. But I don't want to keep talking. I thank you for the opportunity.
Well, since you brought up that issue, let me just ask you, what is the provision in the bill that we have before us that ensures that we're not just subsidizing a company moving out of China where that move was already in the works, that the business was perhaps going to move to Vietnam, and now we're going to be subsidizing that move with dollars provided in this bill?
Well, look, you have to have a certain level of flexibility. Like we talk about the $45 billion grants loan program to support, things like developing or acquiring new equipment or relocate a manufacturing facility. I mean, I don't think, the rules will be developed by the Commerce Department. I don't think that we can legislate everything about that. The idea is that we're trying to bring things back here, and we set up a program to do that. I don't think Congress can legislate, all the details of that. There has to be some flexibility on the part of the Department of Commerce to accomplish that. But, you guys, I appreciate the fact that the ranking member and you have talked about China so much over the last year or two. And I do think that people are worried about that. I mean, when I go home, people do talk about China in competition. I think you suggested that maybe they don't. I agree that the big issue still is COVID, certainly. But a lot of people, when I go home, talk to me about what are we going to do to bring things back and bring manufacturing back, and that China's eating our lunch. I mean, people do talk to me about that at home. So I disagree with you.
Just to go back to your previous point about the assistance of subsidizing a company leaving China, is there any restriction that would prevent that company from going right back to China after they consumed the subsidy that we generously provided in this China bill?
There is. I don't have the specific in front of me, but yes, there are some guidelines in that regard. But a lot of that's going to have to be worked out by the Commerce Department in terms of the details when they issue these grants.
So this language in this bill is different from where the Senate ended up on some of these same parameters. I can't speak to it because we didn't have a hearing in the Energy and Commerce Committee, but are you seeing something that the Senate didn't see in that regard?
We had hearing on most of the things that are in this bill from the E&C jurisdiction. We did have hearings on, and they did come out of the committee. Some passed the House, some did not, but most of them came out of committee.
The fact remains the Senate language is different. And I, for one, don't know how to reconcile the differences that we're seeing in the Senate language with what you're proposing. Ranking Member Morris Rogers, did you want to respond to that?
Well, I want to clarify, one of the biggest provisions that was added to this bill is the $45 billion for the supply chain resiliency. We had a hearing on supply chains, but we have not had we haven't had a markup on this provision. We haven't had a markup on this $45 billion and had the opportunity to really go through that as a committee to make sure that we're being as smart as possible with that $45 billion. And I would also just add, money isn't going to solve it alone. We have to address some of these underlying issues that continue to make it difficult to manufacture in the United States of America. Makes it difficult to permit, how long it takes, the cost involved. We have to look at the permitting processes, the regulatory processes, the access to raw materials, the minerals. That is part of doing manufacturing in the United States of America. And that has to be a part of really being, if we're going to be honest about what it's going to take for America to lead and be competitive.
Well, thank you. And while we're on the subject of money, there's also the small matter of $8 billion for the United Nations Green Climate Fund, which unfortunately does not hold some of the world's worst polluters accountable. So why should we be spending another $8 billion of taxpayer money on the UN green climate programs when some of the worst polluters will not be held accountable?
You're talking about the solar provisions, or you're talking about the greenhouse?
I'm talking about the
green
climate.
What was that, Doctor?
The United Nations Green Climate Fund.
You're talking about in Build Back Better, or for the
No, in this bill, $8 billion in the United Nations Green Climate Fund.
Oh,
I'm having trouble hearing you, Chairman.
Dr. Burgess, that didn't come out of our committee. I'm not. It's in there, but it's. I think Greg has to answer that.
Very well.
Yeah,
I'm happy to yield to the Chairman of Foreign Affairs.
Yeah, look, let me ask you this. I don't think that having 120 pages and a 3,000 page bill focused on safeguarding a sustainable future for American families and positioning America to win the green energy and green economy competition is inappropriate. We're talking about the future and being able to compete with China. So I don't understand what's disturbing colleagues.
So we've already made substantial investments in that regard. But I guess the question is, where do you hold other countries accountable for their contributions to
Well, we're focused
climate problems
on China, and China is the major cause of pollution. So if we're focusing and trying to hold China accountable, then we should also hold them accountable for polluting the air and as we try to preserve this planet.
Yeah, but the problem though is the dollars don't do that. They just simply go. There's no accountability tied back to them. In fact, I will make that. I will have an amendment in that regard as we get later into this process. Thank you, Member Shabbat. Can I just ask you a question about the W visa classification that is included in this bill?
Yeah, yeah, you may be talking about for Uyghurs potentially. I'm not absolutely sure if that's what that's in regard to.
So it's a granting of new visas to Chinese nationals.
Mr. Burgess, could I answer something else that was commented on relative to, I know Mr. Meeks talked about the $8 billion. That's what we're talking about here, this UN slush fund for climate. It's $8 billion. They already got $100 million from us. And we tried to get an amendment, Republicans did, which would basically say no more money, going to China, and they rejected that. So China would have access to additional dollars out of that slush fund. And in addition to that, they're putting another couple $1 billion into that in the future as well, that China will also be eligible for. And speaking of China, this bill was supposed to be, this is the Democrats' answer to how we counter China. We all agree that China is doing so many things which both we and much of the world considers to be completely inappropriate, whether it's their policies relative to the Uyghurs or the Tibetans or the Falun Gong or Hong Kong, all the things that they've done. They're stealing of our intellectual property for years and ultimately our jobs. So this is their answer to countering China. Well, the White House just put out their statement of administration policy. I've got it right here in front of me. This just came out today, February 1st. And essentially what this says is this is the administration talking about this bill and what it does, okay? This is the Democrats' big China bill. You know how many times China is mentioned in the White House's statement of administration policy? Exactly 0 times. The White House doesn't even mention China in what this bill is all about. And I think that says a lot about how serious an effort this is to actually counter China.
Well, I can say, and if Doc wouldn't mind,
Yeah,
that
please.
if you're talking about challenging China in the Eagle Act, for example, it goes right at human rights and holding China accountable for its human rights abuses in Xinjiang and Hong Kong and beyond. It's stronger than the Senate competition bill and any piece of legislation that I think Congress has seen in years. Moreover, there's several provisions in the Eagle Act that target the CCP's political influence around the world. For instance, the Eagle Act authorizes $100 million annually to support independent media and counter the CCP's propaganda and misinformation globally for the next 5 years. And it authorizes $75 million annually for 5 years for an infrastructure transaction and assistance network to reduce foreign governments' dependence on China's Belt and Road Initiative and develop financing tools that will help promote responsible development. So we do a number of things therein. The U.S. can veto any project. If you're talking about the Green Climate Fund, we can stop China getting dollars. The past administration, for example, gutted our climate commitments. We are trying to demonstrate U.S. leadership to our partners and allies. And that's what they're looking for. They're looking for the United States to lead again. So we pulled out of all of the multilateral, the prior administration, we're getting back in there. We pulled out of all of the climate deals and cut out of our contributions to multilateral climate financing. So we're trying to catch up and regain the leadership in competing against China. And that's what this is, competition against China and creating American jobs.
Thank you.
Thank you. Mr. Shabbat, did you have something you wanted to say?
Very briefly, if I could, excuse me, respond, and I have the utmost respect for Chairman Meeks. However, relative to this being tougher than the Senate bill, is just, it's not accurate. The Senate bill, essentially they took the Senate bill, the Strategic Competition Act, and they systematically watered it down and made it less
less strong relative to dealing with China. And I think essentially what was happening here is the progressives amongst their base has been telling the Democrat leadership that they don't want to focus on China or being tough with China because it might jeopardize the most sacred thing of all, and that's climate change, which is essentially a religion to these folks. And so they can't do anything that's gonna in any way weaken John Kerry's hand in dealing with the PRC. So they don't want to focus at all on the generational struggle for really the future of this earth with respect to China. That's what we're up against right now. I think we all realize that, but their leftist base doesn't want to do anything that's going to jeopardize, dealing with China and trying to get them to go along. And essentially, what will happen is China will say what they'll do down the road. And all these agreements, we have to do it now, and it kills American jobs right now. And that's in exchange for promises from the PRC down the road, which, let's face it, are never going to happen. So unfortunately, that's where we're at. This is a bill that was supposed to be about countering China, and the White House today comes out with this and doesn't even mention China in their bill. I think that lack of saying anything, I think, says it all.
Well, Mr. Shabbat, can I just ask you, is there do you have
Councilor Burgess, you have this, we don't have a 5-minute rule in the rules. These are obvious. You've been going, this has been over half an hour. I would, I think.
It's important. This is the only hearing we're going to have on this damn bill.
You know what? I mean, we can revisit whether or not we maintain this tradition, but
Can I just ask Mr. Shabbat one follow-up question?
All right, yes.
So, Mr. Shabbat, let me just ask you this. You've looked at this for a long time. You've studied this for a long time. Do you have an opinion as to whether or not this House, we know the House bill will pass because they've got the votes. Will there then be a House Senate conference on this? Or is this then dead for the year after it passes in the House?
I'm afraid it's dead. Obviously, the Democrats control both the House and the Senate, so I can't predict with any certainty what's going to happen. And the Democrats have the vote just as they did in committee. We wanted to work with them on this, but this got 0 Republican votes in committee in the markup there. It was a long markup, and the chairman is absolutely right. They did afford us amendments, which they ultimately voted the vast majority of them down. But the Senate bill is so different. It's so much tougher than the House bill, and it was bipartisan. That's the irony of all this. Their bill, which was bipartisan, was tougher than this House bill. Again, the principal reason is their liberal base doesn't want to do anything that's going to in any way jeopardize getting some agreement with China on climate change.
Well, thank you for that answer, Mr. Chairman McGovern. I will yield back to you. I do feel obligated to point out when we have these massive bills and the only attempt to modify them is going to be at the Rules Committee, we've got to be expected to spend some time on it. That's what our job is here. So I thank you for your indulgence, and I'll yield back.
Yeah, and I appreciate that. You're also on the Energy and Commerce Committee. And the fact of the matter is, I think if we all, I think we need to be reasonable here. Let me ask unanimous consent to insert in the record a statement of administration policy in support of this bill. Representative Morris Rogers mentioned the steelworkers. I want to ask unanimous consent to insert in the record a letter from the on behalf of the Alliance for American Manufacturing, a partnership between some of America's leading manufacturers and the United Steelworkers in strong support of this bill. And I just feel compelled to correct the record, to state for the record, when we talk about getting tough on China, some of the toughest human rights legislation that has been passed in Congress on China has been passed by the democratically controlled House and the democratically controlled Senate. I will remind people that when the House in a previous Congress, when the Republicans controlled the Senate, passed the Uyghur Forced Labor Protection Act, the Senate did nothing, controlled by Republicans, and the president did nothing. In fact, we now know that the president said that, he had no problem with what was going on with the Uyghurs, as he told the Chinese leader, because he didn't want it to somehow interfere with our trade policy. So let's just be clear about who's actually getting things done to check China, because I think people are more interested in actions than just talk. At this point, I would like to yield to Mr. Perlmutter.
How long did Dr. Burgess take? Because that's how long I want to take. No, I'm kidding. I'm kidding. Just a couple things. I think one of the issues that we deal with as a House is the fact that the Senate bundles everything. That's how they do it. And we're almost put in a position where we have to do something similar. And one of the areas that's caused a delay, everybody says, well, the Senate was ready with their bill last June. Well, no, they weren't, or they certainly weren't ready when it's compared to us, because I want to compliment Mr. Weber and Ms. Johnson. I mean, one of the places that was so lacking in the Senate bill was in the whole science section, which we really did not like in any way, shape, or form. And as Mr. Weber said, and the chairwoman said, every section of the science section of this bill is bipartisan. Every single one of them. We've either passed them individually or they've been voice voted out of committee. And they're all things that make us more competitive, not only with China, but with the rest of the world, because they focus on imagination, they focus on innovation, and they focus on invention, so that we continue to lead the world in those things. And so I'm going to quickly run through the sections, and Madam Chairman, if you want to comment on any of them, just jump in anytime. But we start off with a section that just builds on STEM programs, dealing with critical materials, as Mr. Westerman was talking about, fusion energy, bioenergy, renewable energy, and lab infrastructure across our country. And that's HR 3593 passed the House 351 to 68, sitting in the Senate, going nowhere unless it's bundled. Second, it involves the National Institute of Standards and Technology by Representative Haley Stevens. Deals with the important programs and maintaining our manufacturing extension programs so that we can have manufacturing in America. Now, there are three things that I really appreciate about the overall bill. Is one, it brings manufacturing back to America. And Ms. McMorris Rogers, I disagree with you on wanting not to have union wages and not wanting to have good wages because China pays its people worse or Vietnam may pay its people worse. We want to bring things back to America. And even if a roll of toilet paper costs 3 cents more per roll than what it would have been from China, I want it made here so that we don't have any supply interruptions again. That's the whole purpose of this thing. And if we didn't learn anything from the pandemic, we should have sure learned that. So that's what Ms. Stevens is working on, the National Science Foundation for the Future Act by Chairwoman Johnson. Again, more STEM programs, making sure that our students are ready for the future. Again, passed with a huge majority out of the House to the Senate, where it's still sitting. I mean, that's a no-brainer, but the Senate can't act on it unless it's bundled up into some gigantic bill, which is a real problem for the institution overall. But that's not a problem we're going to solve today, Dr. Burgess. We have another one on bioeconomy. We have another one on combating sexual harassment in science. So we're dealing with a bigger problem because we don't want to have this problem in our institutions or in America, so that we can draw on the broadest group of the broadest intellect possible, male or female. And Ms. Johnson, you want to jump in and stop me from this at any time, you're more than welcome. But every single piece of legislation came from Representative Lucas as the ranking member. Ms. Ross, and she'll talk about it, has a big section of this bill on energizing. It's a technology transfer section. Again, so that America can compete with the rest of the country. It doesn't have to, Mr. Shabbat, have to specifically say China. We're competing with the rest of the world, not just China. So, you know, when the president's directive administration policy doesn't mention China, it's because we're dealing with the rest of the world, not just China. But let me jump over to another section, and Mr. Meeks and I apologize to all of you, but I happen to be on two of the committees that have big sections of this bill. Financial services and science being the biggest part, in my opinion. And every section in the financial services deals with China and cybersecurity and China types of cheating in terms of its trade. You know, so for instance, Jim Himes's section on using cryptocurrencies to kind of launder money that would be going to China ransomware companies. That's in here. So it deals with China, it deals with wages, it deals with a section out of the Science Committee that's my section is on fire prevention and mitigation. And somebody complained on the Republican side, well, it's a climate bill. Well, you damn right it is. It's that, and it's China, and it's supplies. And in Colorado, we just suffered the worst wildfire we've ever had because the climate has been so dry in Colorado, where we lost 1,000 houses in about 6 hours. So if you don't think we have to deal with that, you guys are, you know, sticking your head in the sand. So I have ranted long enough. Ms. Johnson, do you want to say anything, Mr. Weber, since I said something nice about you? If you want to say something, you're more than welcome, and you guys can respond to my rant.
Well, I'm glad to say something. Thanks for wrapping up, Ed.
I'll yield back then.
Thank you very much. Mr. Reschenthaler.
Thank you, Mr. Chairman. Once again, I'm a little slow on that unmute button. I should be used to it by now, but thank you for yielding. My first question is for Representative Smith. Representative Smith, you mentioned that the TRIPS waiver could actually cede American intellectual property to China. I absolutely couldn't agree more on that. Would you mind just elaborating on that and talk about whether or not this bill is tough enough on China vis-a-vis TRIPS waivers?
Well, you know, certainly the TRIPS waiver would definitely cede intellectual property to China. You know, China doesn't have the same respect for private property, whether it's intellectual property or real property. That, you know, the property rights issue is what sets our country apart from other countries. It's referenced in the Constitution. Or I should say, innovation and invention and things like that have been part of our governing for centuries. So, you know, to undermine that, I think, but especially when China would love to have our intellectual property, just keep in mind now is not the time to undermine that, especially when we want to encourage investment and thinking for the future so that we can provide a better life, and not just for Americans, but obviously folks all around the world can and would have access as well under with the understanding that intellectual property values have meaning and can actually leverage more innovation long term.
Thanks, Representative Smith. I appreciate it. And talking about innovation, I've got a question for Representative Weber. Representative Weber, you know, I was just in a meeting with Leader McCarthy a few days ago, and he is very adamant that the future is going to be really determined by who commands quantum and who commands IA. And I'm a big believer in that too. And I frankly think we've lost some of the edge on that to China. But we know that the CCP is the world's largest spender in research and development. And the CCP has also made it their explicit goal to overtake the United States in science and technology. Do you believe, Representative Weber, that this bill will be an effective tool in maintaining our global competitive edge on China? And also, what will happen if we fall behind China? And I yield to you, Mr. Weber.
Well, thank you, Guy, and I appreciate that. It's on Science, Space, and Technology Committee, ranking member of Subcommittee Energy. It's unbelievable how bad this bill is. It doesn't address exactly what you're talking about, artificial intelligence. Let me just do an example on chips. There's no question that we need to promote the domestic manufacturing of chips for computers. Here we need the best, fastest computer that we can ever get. China is stealing our they're stealing our intellectual property. They have no qualms about that, no scruples, no morals, go right down the list. We need to be manufacturing those chips here. We need to be building the computer as quickly as we can. It's important to know that there's 52 billion with a B dollars in this bill in mandatory money for chips that has had zero committee process, zero. This is a huge proposed investment of tax dollars. And as we all know, policies that pass without that vetting frequently have unintended consequences for taxpayers and industry. And although you didn't ask about this, let me also chime in here and say that this bill gives additional loan guarantee authority to the Secretary of Commerce. And let's face it, the federal government has a bad track record of administering loan guarantees. And this language has not been vetted by any committee. So chips, artificial intelligence, supercomputers, we need all that stuff here. And we don't need these are the things we should be focusing on. The Science, Space, and Technology Committee has focused on those. And there's no reason why this shouldn't have gone through the committee process. And I thank you, Mr. Reschenthaler, for yielding to me.
No, thanks, Representative Weber. I appreciate it. I've got some questions for Ranking Member Westerman. Ranking Member Westerman, you had mentioned that and I believe your opening statement, you mentioned that this bill mentions coral reefs and climate change more than actually mentions China. Would you like to elaborate on that and how you see this focus distracting us from actually competing with China moving forward?
Thank you for that question. You know, the irony that I see here is that, as Mr. Perlmutter said, this is a climate bill, but it's not going to do anything to make the climate better. It focuses a lot of money on climate, but it's focused in the wrong areas. Talking about coral reefs in China, I wonder if everybody realizes that China is responsible for 98% of the worldwide increase in CO2 emissions from 2005 to 2020. It's not just that China is the world's largest greenhouse gas emitter, they're the largest by far. And while we're working on that here in the US and doing a much better job, China continues and they don't care. I think there's this idea that China cares that they're emitting greenhouse gas emissions. You know, we talk about a competition, and I think my friends across the aisle see this as a wrestling match where you're going to force China into submission. You're going to impose your will on them. You know, you're talking about people that already violate human rights. You're talking about people that don't care about the environment, that have stated that they want a one belt, one road policy where China has world economic dominance. You're not going to force them into submission. This is a race, and we have to get out ahead of them. We have to develop the resources that we have. We have to use our innovation, our technology, and we have to come up with the technology that the rest of the world adapts because it's, when you're talking about energy, because it's the most reliable, it's the lowest cost, and it's the cleanest. Because I've said so many times, China built 38 gigawatts of coal-powered plants last year. If that's not handwriting on the wall to where their focus is, I don't know what else could be. This bill is the wrong approach, and it's focusing on the wrong things. And even though it uses competition as the facade, even the underlying idea of it being a climate bill is a failure as well.
Yeah, exactly. You were mentioning where China is relative to the rest of the world. I've got some actually hard figures here. China is responsible for 27% of the total global emissions. So by contrast, the United States is responsible for 11, but we're the ones that are actually reducing our CO2 emissions. And that 27%, just to put in another perspective, that is more than the United States, the entire European Union, and Japan together. It's astronomical. And what's scary is China, despite signing on to the Paris Accords, this has been a complete illusory promise, because even under those accords, they're not responsible for reducing their CO2 emissions until 2030. And by that time, China is banking on the fact that they'll be the world superpower and largest GDP, so they don't have to negotiate with anybody else, any other nation, so they can completely blow off CO2 emissions. But thanks, Ranking Member Westerman, for bringing that up. I did want to talk. Yeah, I'll yield back to you.
Well, I know it was talked earlier about all the provisions that had gone through committee. I've got a list, and I ask unanimous consent to enter into the record a list of nearly 30 sections of the bill that are of interest to our committee that we have not marked up. I ask that unanimous consent.
Without objection.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. And Ranking Member Westerman, I know that you and Ranking Member Cole talked extensively on rare earth elements, but as the co-chairman with Representative Swalwell on that caucus, I'd be remiss if I didn't ask you some follow-up on rare earth elements. So I just want to, again, talk about this. The bill, from my understanding, this bill includes $3 billion, and that's billion with a B, $3 billion of solar manufacturing, for solar manufacturing programs, which, let's be honest, that's just going to benefit China, because, again, China is the dominant player in rare earth elements. We depend on them for about 80% of our import of rare earth elements. So instead of focusing on that, we're now on the imbalance. We're creating these Solyndra-style programs that Ranking Member Kathy McMorris-Rogers was referencing. I think that we should unleash our free market economic powerhouse that we have in the United States, and that's why Representative Swalwell and I have a bill. This bill would actually create a tax incentive for domestic rare earth magnet production. So these magnets, in terms of the rare earth, they're used in everything from computers to cell phones. You need them for defense systems, and you need them for electronic vehicles. Unfortunately, because of the way this bill was brought to the floor, again, not going through the committee process, my friend and colleague, Representative Swalwell, and I did not have a chance to include this as an amendment form. Do you have any thoughts on that? Do you think that the bill that he and I, and by the way, this is bipartisan. I know everybody knows that Eric Swalwell is a Democrat from California, but do you think that this bill would make a difference if we were afforded the ability to offer this amendment?
Absolutely, and it's the kind of policy we should be looking at to grow our U.S. production, not to punish U.S. manufacturers and U.S. producers of minerals and elements. You mentioned earlier about the U.S. producing 11% of greenhouse gas emissions. And I think the whole premise of how we're addressing climate has got some flawed logic to it. The whole emphasis seems to be on transportation, which is about a quarter of that 11%. And it seems like there's this message being put out there that electric vehicles are going to solve the problem. Electric vehicles, I have nothing against them, but they have a whole lot of baggage that comes with them. You've got to mine a lot of elements and minerals to build those. You got to have a lot of microprocessors to build those. And it's going to be a huge cost on the U.S. economy, especially if we're buying all of that from nations like China. And at the end of the day, it's going to have a minimal impact on global emissions. So we should be looking at technologies like fusion and nuclear power and hydrogen, technologies we can develop here that's not going to make us more dependent upon a Chinese supply chain. That's the more innovative way to do this.
Yeah, I actually I had some stats on that. And look, I too have nothing against electronic vehicles. The market is moving that way because of consumer demand, but it's one that's not based in reality. So an electric car will generate just 23% fewer greenhouse gas emissions than a gasoline powered car. When you think about that, it's not because the electricity is coming from somewhere, and it's coming from coal plants that is then fueling the batteries. So if you were to take every car on Earth and change it over to an electronic car from a gasoline powered car, it would only decline emissions by 1.8%. 1.8%. Yet we're putting all this stock behind the EVs. Again, I've got nothing against EVs. It's just we've got to be realistic with the stats and what's it's actually going to do to the emissions. And the facts don't care about an agenda. They're the facts. It's a 1.8% emission. Further, some have compared the electronic vehicle to the Tesla to the new blood diamond. And you mentioned that the mining, I'll explain that. In the 80s and 90s, it was very young, upwardly mobile professional people were buying these huge diamonds coming from Africa, huge environmental costs, horrible human rights violations. And thankfully, the world cracked down upon it. We put an end, or presumably put an end to blood diamonds. Fast forward to now, we have a new blood diamond in that the batteries, because the cobalt and the rare earth elements needed for these batteries are going into these cars that are a status symbol by well-to-do individuals in affluent areas, but it's coming at a huge environmental cost in these mines in Africa, and huge losses to humanitarian efforts where you're seeing slave labor, child labor, etc. You mentioned that. Would you like to talk about that? Because this bill will actually create incentives to shift more into EVs and put more of a strain on the environment and in these mines and the human toll too. Ranking Member Westerman, would you like to comment on that?
Yeah, the way you might could sum that up is that there's not much juice for all the squeeze that you've got to do here. If you could convert every internal combustion engine car in the world to an electric vehicle, like you said, you've hardly affected global climate emissions. In the meantime, China is producing these massive energy plants and increasing their carbon emissions far more than what we can do to offset it through an electric vehicle program. And then there's this idea that as long as it's not happening in our backyard, it's not bad environmental stewardship. These minerals have to come from somewhere. It's almost this mindset that you get groceries at the grocery store and you get heat out of the furnace, not thinking the supply chain that it takes to produce all of that. And we can turn a blind eye and say, we're going to not touch our resources here in the US and pat ourselves on the back and do tremendous environmental damage around the world. And that's what legislation like this promotes.
Thanks, Ranking Member Westerman. I appreciate it. I just have two questions for Ranking Member McMorris-Rodgers. Ranking Member McMorris-Rodgers, I know that through this administration, we've seen what really is tantamount to a war in our nation's coal and oil and gas industries. How does the regulatory policy and some of the bills coming out of the House and Senate on oil and gas and coal affect our national security vis-a-vis China?
Well, I think that's a very good question, because just the conversation you were having with Mr. Westerman about our dangerous dependence upon China when it comes to the renewable energy, whether it's solar panels, 90% are manufactured, or the supply chains are controlled by China, or on the wind machines, again, supply chains controlled by China. At a time when we see this administration shutting down the oil, the gas, natural gas, mining, just blanket shut down. We saw it on day one where President Biden unilaterally on day one shut down the Keystone Pipeline. Now we've seen where he's unilaterally shutting down mines in the United States of America that would help produce these critical minerals that we need so that we can do manufacturing in the United States, whether it's the mine in Arizona or Minnesota. So that's where it's very concerning to me that the United States of America, we often talk about and celebrate that we have the highest environmental standards in the world. And yet when we're trying to site a mine and be able to do it in the most environmentally sensitive ways, this administration is taking a unilateral approach and just saying, no, we're going to shut that down. We've seen in the last year where the United States is where we were celebrating being American energy independent, we're losing that standing. We saw where this administration, President Biden, is calling OPEC, asking them to produce more oil. Massachusetts is importing oil from Russia, at the same time shutting down any pipelines into Massachusetts. It's like where there's just these big disconnects over what it's going to take for America to make sure that we can do manufacturing in the United States, that we can continue to lead the world in reducing our carbon emissions and leading the world in new technology. So I guess I just, all that to say, I have a lot of concerns about the administration by fiat just making a decision to shut down energy supplies here in the United States or mining operations in the United States, but then spending lots of money in this bill to somehow say this is how we're going to secure our supply chains, or we're going to manufacture here in the United States. It's like throwing money at it isn't going to work until we actually address some of these underlying issues.
Thanks, Ranking Member McMorris Rogers. And I know I'm going a little long. I just have one more question, a short statement, if you'd indulge me. Ranking Member McMorris Rogers, I just want to go back to touch upon the discussion I had regarding electronic vehicles with Ranking Member Westerman. I know it might be taken as some that I'm against EVs. I'm not. We're just missing the mark. We think that EVs are the key to clean emissions. They're not. Again, total reduction would be 1.8% globally if that were to happen. The real reason we need electronic vehicles is because if we're going to move to self-driving automated cars, which I personally think is on the horizon, if we're going to do that, we're going to need EVs so they can go without refueling for very long periods of time. That's actually why we need to make a move to EVs, not for the minimal environmental impact that they might bring. With that said, we have talked about autonomous vehicles before. I have said repeatedly that because we have a lack of congressional action on autonomous vehicles, we have no coherent policy on these vehicles. Because of that, we are losing our edge on autonomous vehicles to countries like China, where they are paving the way to allow autonomous vehicles. Does this bill do anything to advance U.S. leadership in developing and deploying autonomous vehicles at all?
Unfortunately not. And I share your position here that China is moving ahead. They're moving full speed ahead to test, to deploy autonomous vehicles. Now, 4 years ago, Republicans and Democrats in this House, in the House of Representatives, came together and we passed legislation to establish a national framework so that we could actually start testing and deploying autonomous vehicles here. I've been very, I don't know. It's like, I don't understand why the Democrats are refusing right now to move forward with autonomous vehicles. Because to your point, they go together, and autonomous vehicles, we want to lead the world in this next generation of cars. And we need to put that national framework together. And this is a way that we're going to gain a lot more efficiency in the movement of people and goods. Driverless cars are going to allow more mobility for people. Yeah, I think about seniors or individuals with disabilities, and it's going to be the car of the future. So while the administration, and I hear a lot from the Democrats going all in on electric vehicles, I don't understand why there's been no action on autonomous vehicles. And a real competitive bill would include a national framework for autonomous vehicles and that network being developed here in the United States.
Thank you, Ranking Member. And then finally, and I just want to end with this, I'm on the Appropriations Subcommittee on Energy and Water, so very important to me and my district. I know energy is very important to you. I find it increasingly alarming that this bill doesn't address China's nuclear energy ambitions. This will put us at a serious disadvantage because China is building nuclear to a very great extent. We in the United States clearly are not. China is currently developing thorium molten salt reactors, which will not only supply energy, but also power their defense capabilities. It goes to their civilian military fusion, of course. The Department of Defense has acknowledged that the very real threat posed by China's growing nuclear capabilities But meanwhile, our government is destroying our own supply of U-233, which could be used to build up our own TMSR program. In fact, for whatever reason, we treat this as waste. It's not waste. There's capabilities for it. The Chinese are using it. In fact, they're purchasing it. So despite strong congressional interest, the Department of Energy continues to stonewall and move forward with the U-233 disposition program. Again, treating this as waste. It's not waste. There's capabilities for it. I think that we can't hand the Chinese Communist Party an advantage in this. I think that the future will be powered largely by nuclear energy. And I think if we're serious, we've got to take a look at this. Ranking member, final question. Do you have any thoughts on this?
Well, I agree. I appreciate you raising this issue. I think that we also should be looking at this. If we're going to transition, in order to transition to a clean energy future, it must include nuclear. And I think the issues that you're raising around waste and what we're doing with that waste needs to be addressed. America, there is some exciting research, innovation taking place right now in the nuclear sector. Small nuclear reactors where the waste, you don't have the waste, it's recycled. And this is the kind of innovation and technology that we should be including and making sure that we're promoting here in the United States and so that we can develop that next generation of nuclear technology, both to meet our needs here and to export that around the world. Instead, again, it is very costly. It is very time intensive. The process to try to build a nuclear plant in the United States of America is extremely difficult, if not impossible. We just had the Regulatory Commission shut down a proposal just in the last couple of weeks. So this is another area where we need to be embracing our leadership in this way and making sure, and we can do it in a way that is safe, that is clean, and that is not going to be it's going to be secure and address the waste and even some of the waste that's already here, that we can use that in a way to help develop nuclear technology in the future is really exciting. And those are the kind of things that I would love to explore and think that that's a way that we win the future. So I appreciate you raising the issue. Thank you.
I appreciate it. I yield back, and I want to say thank you to my Democratic colleagues for the generosity of time. So thank you. I yield back.
Thank you. Mr. Raskin doesn't have any questions. Ms. Scanlon doesn't have any questions. Mr. Morelli.
Thank you, Mr. Chairman. I am grateful for your work and that of your entire staff to ensure this critical legislation arrived before the committee without delay. And I'd also like to extend a big thank you to all the committee chairs that are here and that have worked on this for their efforts over the past week to get America Competes ready for floor consideration. But for the committee, the committees and the committee chairs, their commitment over the past 2 years needs to be lauded for developing this comprehensive bipartisan bills that are the backbone of the legislation. And as many of my colleagues noted, what we have here today is an historic package of long overdue legislative actions that will do a number of important things: strengthen our supply chain, make bold investments to support manufacturing right here at home where it matters most, the reindustrialization of America, in my view, boldly invest in innovation and scientific research to advance America's competitiveness against China and others, and reestablish our nation as the global leader in innovation. And finally, reaffirm our leadership around the world by strengthening diplomacy, promoting human rights, and bolstering economic engagement, all critically important to our role in the world. So there's quite a bit in the legislative package that I'm proud of and that I think my constituents back home in Rochester are going to be really grateful for. But one item I did want to highlight is the provision of boost regional innovation. Since 2020, I've had the privilege of leading the Innovation Centers Acceleration Act, legislation that would dedicate serious federal investment into our nation's innovation efforts. And I've had the privilege of speaking with Chairwoman Eddie Bernice Johnson on this. But I've had the opportunity to work on the bill. I've spoken with colleagues in the House, the Senate, local and national stakeholders, and economists who frequently note how R&D investment has fallen to 0.61% of U.S. GDP, the lowest level since 1955, when compared to a high of over 2% of GDP in the latter part of the 20th century. It's the lowest level since 1955 and harms us both in terms of productivity and global competitiveness. So in addition to underinvesting in innovation, we've seen a deepening concentration of innovation jobs, which is restricting opportunity. No disrespect to my dear friend, Mr. Desaulniers, but only 5 cities in the United States have really attracted 90% of the new innovation jobs. That's Boston. Mr. McGovern's happy Massachusetts is doing well. I'm happy. Seattle, San Diego, and San Jose and Silicon Valley. So
I would have been happier if it was Worcester.
yeah, I'm sure. Well, I have a plan for that actually, which I'll mention, which is while 90% of the nation's innovation jobs have grown from 2005 to 2017 in those 5 areas. Meanwhile, 191 of the 382 U.S. metro areas, fully half, have lost innovation jobs in that same time frame. And those regions are losing out on productivity growth that plays a major and critical role in creating jobs and raising living standards in those regions. So an innovation surge is needed to drive economic recovery and build resiliency. And the America Competes Act puts us on the right track to do just that. That's why it's so important. I'm proud that language in HR 4521 will create regional technology and innovation hubs like those envisioned in the bill I referenced, the Innovation Centers Acceleration Act. And this initiative will incentivize collaborative partnerships between local governments, colleges, universities, private industry, not-for-profits, and community organizations to promote and support regional technology and innovation hubs. So I would be remiss if I did not again extend a heartfelt thank you to Chairwoman Johnson of the Science, Space, and Technology Committee for her leadership in this process and openness to working with my staff and my team on the regional innovation language. So I do have just a couple questions. First of all, Madam Chair, as the bill moves to the floor later this week and on to a conference with the Senate, can you comment on the importance of ensuring final federal innovation provisions prioritize regional opportunities through a competitive selection process?
Well, yes. I think I'm getting right now.
Yeah, and I'm sorry, I couldn't hear you, Madam Chair.
I couldn't hear myself at first, but yes, I agree with you, and I agree that this is the direction we should be going.
Terrific, thank you. And I'd be, would you be concerned that without intentional guidelines that the R&D dollars at the federal level will continue to go to the handful of regions that have experienced growth? That's what's happened for years, and without
yes, indeed.
Thank you. When I think about the Competes Act, the America Competes Act, I'm excited about the opportunities the bill creates for so many Americans if implemented correctly. It's not just a specific industry. It's not one single industry. It is the innovation hubs, and the innovation growth will be in many, many communities, and it will involve the entire community. So one last question for Chairwoman Johnson, if I might. You know, there have been a lot of people who've really been excluded from entrepreneurship and the innovation work cycle. Women, brown and Black Americans, communities of color. Can you just talk for a moment? 'Cause I know you and I had a conversation some time ago about the need to bring all people into this space so that everyone can compete. And if you could talk about the importance of that as we sort of move ahead with America Competes.
Well, that is exactly right. As a matter of fact, it's not so much that we ought to be just fair. It also means that that's the growing population, and we cannot afford to leave out anyone, actually, because that is also the direction of skills that we need. Many times businesses locate a certain place looking for skills. And one way to make sure that we diversify locations and make sure that there's some activity in all of our areas to make sure they're also talent that's available for these companies.
Well, and that's particularly important, it seems to me, when you look at labor shortages in critical industries. So you're absolutely right. We need more people to participate, and we need to make sure that we've got a real lens on racial equity and diversity as we move forward. So I appreciate your leadership in that space. I just conclude by saying, in my view, the America Competes Act is transformational legislation, will benefit communities like mine in Rochester, New York, for years to come. Passage of this long overdue investment can't come soon enough. I encourage my colleagues to join me in proudly supporting and advancing this, what I consider monumental historic legislation. I look forward to seeing it pass later this week. And with that, Mr. Chair, I yield back. Thank you.
Thank you. Ms. Fishbach.
Yes, thank you so much, Mr. Chair. And it is warming up a little bit in here, so we're surviving. But I just have a couple of things. First of all, I did want to just ask Mr. Smith, McMorris Rogers, Mr. Shabbat, Mr. Westerman, and Mr. Weber if they had anything that they've wanted to add that they haven't been able to, haven't had the opportunity to mention. And we can go one at a time, but I thought I'd say them also, I'd give warning, but Mr. I don't know if I'm trying to see if I see everybody, but Representative McMorris Rogers, I see you. So I'll start. If there's anything you wanted to add, I don't know if I do have a couple of questions, but I thought I'd give everybody that opportunity.
This is a huge bill, lots of pages, lots of money. I think I've highlighted a lot of my concerns about it. It is extremely important. I think we agree. We want America to innovate. We want America to compete. But we would get a better outcome if we could go back to committee and actually have this debate, have the amendments in committee, be able to talk about a whole host of these issues that we have raised. Unfortunately, as the Republicans, it just, we were, at least in energy and commerce, the chairman decided there's some bipartisan bills that are in the bill. There were other bipartisan bills that we'd agreed on that it got changed. And then there's other provisions that are new that we did not mark up in committee. And this is critically important. All of the issues around how we make sure that America leads, but we must address the permitting issues in the United States. How long it takes, how much time is involved. I mentioned earlier about it takes 3 years on average, or 3 years to site a solar farm. So here we have a $3 billion program that is going to go towards manufacturing in the United States, or trying to get solar manufacturing. 90% of the solar is the parts are coming from China. And then trying to cite something in the United States, the permitting absolutely has to be addressed. The access to raw materials. It doesn't make any sense that we're shutting down mining in your state, Minnesota, or in Arizona, or shutting down American energy. We have to have energy in order to produce. So there's a lot of issues that need to be addressed. And it just seems like the Democrats are fine throwing money at it, a lot of money, but not addressing these the fundamental issues that are a part of building that manufacturing, bringing back the manufacturing. We agree. Let's address it, and let's do the work necessary so that we can set, so that we can come together on this, and I think we'll get a better product.
Thank you very much. And I will just check if any of the other ranking members. I won't. Mr. Shabbat looks like he'd like to.
Thank you, Ms. Fishbach. Thank you for giving us this opportunity, and I'll be very brief. Again, I just want to reiterate that this is the Democrats' counter-China bill. And when the White House puts out its statement today on what this bill is all about, and what's important about it, not one word about China. I think that speaks volumes. Thank you. I yield back.
Representative Fishbach. Yeah, thank you for giving us this opportunity. One thing I would point out is that this is an issue that I think we're passionate about on both sides of the aisle. I mean, Republicans actually set up a China task force to look into these issues, and we've gained a lot of information. I think we could have brought a lot to the table had this been a serious bill that went through the committee process. But unfortunately, there's a lot of provisions in here that The Speaker's office is following the same path that she's done this whole Congress, and just writing these big bills and putting them on the floor. And I don't think we win this competition by regulating utopia. I think we make America stronger. We form alliances with our trading partners. I think we got tremendous opportunity with the North American, Central American, South American alliance with other countries around the world that don't necessarily want to be trading partners with China. But none of that's really included in this legislation. I think we're aiming at the wrong target here. And it's unfortunate that we didn't go through the process where we could have brought ideas to the table and worked on an issue that's not only important to Republicans and Democrats alike in Congress, but all across the country.
Thank you very much. I do have a question for Mr. Weber, and I don't know if he is still on. I see his name, but if he's there, might want to turn on his. Well, without Mr. Weber here, I will ask Representative Rogers.
If I could, I am going to sneak away for a little bit. I need to go over to another meeting, but Mr. Guthrie is going to log on very shortly on behalf of Energy and Commerce.
Okay, all right. Well, then maybe I will wait on that one and see. Because I did want to ask just a kind of a general question about, well, not a general question, a more specific question. And so we'll see if we'll wait for him. But maybe generally, and I can just ask the ranking members. There's a lot of language about a sense of Congress in here, and I'm just wondering if is that very typical, and does it have any force in effect in law, or does it do anything? It just because it just seems like there are pages and pages of this sense of Congress, and so I don't know if any of the ranking members have taken a look at that or have any comment on that. And maybe not, that's fine. I think it seems like a lot of pages spent on a sense of Congress. And also,
Ms. Fishbach?
Oh, I'm sorry. Yes.
Yeah, I think that also says a lot. That 2/3 were senses of Congress. There's something like 170 requests for reports, which means more money being spent for bureaucracy and talking about stuff rather than actually doing stuff. And that's the whole point about this. It's a lot of talk, very little action.
Thank you very much. I do have, and I'm waiting to see if I guess we're waiting for Mr. Guthrie. I do have a question about section 1023.5, but the other one that just kind of concerns me is there's $4 billion for distressed communities. And I was quickly trying to figure out exactly what was the distressed community and what this money was going to be used for. But obviously, when we're presented with this size of a bill, we don't have time to find exactly what the language is. But I'm wondering, and I think that might be Mr. Guthrie's area. That he is ranked, that he's going to be represented. So, but I am very, very concerned about the dependence that's really being created, and the dependence on, in particular, I think Representative McMorris Rogers mentioned that, in the state of Minnesota, that those mining leases were just removed or rescinded, and that we're creating this dependence on China as we take these bills. We're encouraging these electric vehicles, we're encouraging solar, and we keep doing that, but we're not addressing the fact that we will have critical mineral needs to fulfill all of that, and that then we turn around and shut down a mine that could provide that. And so I'm very concerned that we are doing the absolute opposite, and we are creating a dependence. We are creating a dependence on China that we do not need to do. And I know that Congressman Stauber will be here later, and I think he will probably talk about it too, but it does not, it defies common sense to think that we're doing this in this bill and then not trying to address our own needs. But I do not, oh, there we go. Congressman Guthrie, he's on, but I don't see, he hasn't turned on his video yet. Well, you know what? I won't delay any longer. I did have a question about what premise plumbing was and what the effect is, you know, what does it have to do with China? But why we're studying it in this bill and spending money to study it and go on and on. But I will, with that, I will yield back. Thank you.
Mr. Desaunier.
No, Madam Chair, I don't have any comments.
Ms. Ross.
Thank you, Madam Chair, and this has been a fascinating discussion. I jumped off for about 15 minutes to talk to some students at North Carolina State University, which is a land-grant university and a STEM university. And I told them I might have to jump back on to my committee meeting, and they said, this is one of the most important bills that we could work on for their future. And I want to thank Chairwoman Thompson for always emphasizing how important it is to work on the jobs of the future and the pipeline. And because I have a land-grant university, a community college, and 2 HBCUs in my district, there is no question that these students are going to benefit from the education and research and the jobs that are created for the future. You know, we have been a global leader in science and technology, and I think we cannot forget that. I see it every day in my district, particularly when I talk to young people like the ones who I talked to just a few minutes ago. But in order to maintain this critical position, it's essential that we provide significant investments across the government and the private sector. We must meet this moment and pass the America Competes Act. As a member of the Science, Space, and Technology Committee, I'm pleased with the introduction and prioritization of the landmark legislative package that will boost our capabilities as a nation in clean energy, technological research and innovation, and domestic production of semiconductors. Many people in my district, not just the students, are eager for this bill, and they are talking about it. My district includes much of the Research Triangle, our nation's largest research park, which is home to hundreds of companies breaking new ground in medicine, energy, telecommunications, and more. The investments in public-private partnerships afforded by the America Competes Act will provide these North Carolina-based companies with unprecedented funding and research support, solidifying the U.S. leadership in science and technology. Okay. Notably, this bill encourages federal government coordination with private firms to ensure our communications technology equipment and supply chains are trusted and secure. Companies in my district, particularly startups, have struggled as a result of the global semiconductor shortage. I was pleased to see the inclusion of the $52 billion CHIPS funding to mitigate current semiconductor supply chain concerns, incentivize domestic production, and turn the CHIPS crisis around. I'm also pleased that this package includes several bipartisan bills I led with members of the Science, Space, and Technology Committee, including the Energizing Technology Transfers Act, the NSF Technology Research Institute Act, and the National Science and Technology Strategy Act. These are forward-looking measures that will keep us competitive for generations to come. These bills will help facilitate commercial application of clean energy technologies by universities and private companies, the development of national science and technology strategy, and the creation of a grant program to fund technology research and trainee programs for graduate students. I've offered several amendments to the American Competes Act, and I encourage my colleagues to support them. Many of them are bipartisan. The amendments will advance North Carolina's offshore wind industry, encourage the responsible use of emerging technologies like artificial intelligence, and research how to improve our education technology. I've also offered and co-sponsored amendments to ensure our nation continues to attract top talent from all over the world. These amendments will hold certain individuals working in industries critical to our nation, from healthcare to national security to technology, exempt from numerical visa caps. This bill embodies the type of investments needed to empower innovators in North Carolina's 2nd Congressional District and across the United States. I fully support this legislation and its broader mission to reinforce our nation's leadership in science and technology, and I encourage my colleagues to do the same. Thank you, Madam Chair, and I yield back.
Thank you, Ms. Ross. I think we are just about the end. Does any other member of the committee wish to ask a question? And seeing none, I would like to thank our witnesses for their testimony. Please leave with our stenographer or submit electronically anything that you would like to be inserted into the record. You're now excused. Thank you for your comments and patience. Before I yield to our next witnesses, without objection, I like unanimous consent to insert into the record a statement of support of HR 4445 from Chairman Scott. I now want to welcome our next panel to testify on their amendments to HR 4445 and HR 4521. Honorable Ken Buck, Honorable Gonzalez Colon, Honorable Hank Johnson. Mr. Buck, you're on, sir.
Thank you, Madam Chair. I appreciate being recognized for this. I first want to just clarify one thing, a point that was made earlier. This bill does not require a rape victim to go to court. This bill allows a rape victim to go to court, or allows a rape victim to use the arbitration process to go either way. My amendment in this, I think, very important legislation is designed to clarify the definition of harassment. There was a misunderstanding, I believe a misunderstanding, but I am thankful that the amendment has bipartisan support. But the idea that language that was used for purposes of pleading jurisdiction was being confused with language that was necessary to prove or for proof purposes in the statute. So my language and I will be as brief as I can, my language for this amendment just clarifies that the definition of sexual harassment for purposes of this statute is the definition that is used in federal, tribal, or state law. So there is no expansion of the definition of sexual harassment. It is similar to the language that's used for sexual assault. It's very clear, it's very straightforward, and I think it will clarify and make this bill more bipartisan and hopefully yield more Republican support for this bill. I'm very excited about voting for the underlying bill. I would ask this committee to rule with this amendment in order and also ask for support on the amendment. With that, I yield back, Madam Chair.
Thank you, Mr. Buck. And I'd like to also add that anything that you brought in writing, please submit it or submit it to rules documents at mail.house.gov before the conclusion of this hearing. And anything that you brought will be entered into the record. I now like to recognize Ms. Gonzalez Colon.
Thank you, Madam Chair. I want to say thank you for having us here and for the opportunity to discuss some amendments to HR 4521, the American Competes Act. Almost 2 years after the COVID pandemic began, we're still experiencing shortages of ventilators, testing supplies and equipment, laboratory reagents, gloves, gowns, and sterile apparel. The Food and Drug Administration has also stated that 114 drugs are in short supply nationwide. According to the American Society of Health System Pharmacists, 3 of the top 5 shortages are drugs used for chemotherapy, heart conditions, and antibiotics. We do not know how long this shortage will last, but we do know this. First, that more than 80% of active pharmaceutical ingredients and 40% of finished medication manufactured overseas and 80% of the medicines in the U.S. Strategic National Stockpile have some component that comes from China. And we can no longer afford to rely on another country. And now more than ever before, we have seen that strengthening our U.S. medical supply chain is a matter of national security. And in order to protect our national security, we must strive to have more pharmaceutical products and medical devices manufacturing within our shores. And this can be done if we are willing to invest in creating the market conditions that will drive those manufacturers back to the United States. In that sense, and to accomplish this, I introduced HR 2653, which my amendment mirrors. It enjoys bipartisan and bicameral and stakeholder support. It proposed a dollar-for-dollar tax credit to drugs and medical device manufacturers who invest in jobs, property, and equipment in the states. And it puts our federal money to work by alleviating our medical supply problem and spurring economic activity in economically distressed areas throughout the United States and all the jurisdictions. My second bipartisan amendment, number 535, requires that at least one of the national centers of excellence in advanced and continuous pharmaceutical manufacturing be in a territory or a non-continuous contiguous state. This amendment ensures that geographic areas that are considered rural or remote but have high levels of density in the pharmaceutical and medical device manufacturing, such as my district of Puerto Rico, are still competitive in the selection process. Puerto Rico's pharmaceutical and medical devices manufacturing industry, for example, represents 48% of the island's gross domestic product, according to the Bureau of Economic Analysis within the Department of Commerce, and which enjoys a robust and skilled workforce, which capacity to grow even more. Institutions of higher education, such as the University of Puerto Rico, the Center for Pharmaceutical Engineer Development and Learning Program, are training the next generation of scientists and lab technicians that will revolutionize the pharmaceutical and medical devices industries and workforces. My next amendment recognized the contributions of the Arecibo Observatory, which is a multidisciplinary facility that has supported research and education in areas of radio astronomy, space, and atmospheric sciences and planetary sciences for close of 60 years. Most notably, it hosted a 305-meter radio telescope, which was at that time the largest radio telescope in the world until 2016, when China inaugurated the FAST telescope. Many of you may know that in December of 2020, following a series of cable failures, the 900-ton platform above the reflector dish, sustaining an uncontrolled collapse and destroyed the telescope. And this radio telescope was a remarkable instrument and an iconic figure on the island and true giant of science. Amendment 141 recognized some of those contributions made by the radio telescope during its lifespan, and it underscores the discoveries made by and encourage federal agencies, including the Natural Science Foundation and NASA, to continue strengthening and expanding the role of Arecibo Observatory through education, outreach, and the diversity of programs that may allow future capabilities and technologies at the site. I very much look forward to more amazing works and work and discoveries and contributions from the observatory and their wonderful staff who have stood by this facility for decades. I would like to thank Chairwoman Johnson and Ranking Member Lucas and their staff for their support and work on this issue. I will also support Amendment 533 submitted by Congressman Watts from Florida and I, which allocates $15 million to continue environmental cleanup efforts at this site and $554 million for expenses related to the next generation Arecibo telescope. This project will replace the former 305-meter radio telescope and with a new cutting-edge instrument that is much more powerful than the legacy telescope, and it's supported by the scientific community. The next generation proposal is supported by the academic and scientific communities in Puerto Rico and supports U.S. leadership in science. I want to thank Ranking Member Watts and his staff for any his leadership and supporting this issue. I will continue to work with my colleagues to secure the best path forward and enhance our competitiveness on the world stage against countries like China. Lastly, I wanted to express my support for Amendment 150 that was introduced by Congresswoman Bonamici of Oregon, and which I co-sponsor. This amendment will incorporate the text of H.R. 1447, the Coast Research Act, that will help communities across the nation to adapt and respond to the threats posed by ocean and coastal acidification. Changes in ocean chemistry impact coral reef and fisheries and other marine resources that are crucial to the livelihood of coastal and island communities like Puerto Rico. Among other provisions, this bill enhance ocean acidification research and monitoring activities performed by NOAA, by the National Science Foundation, and expands programs to include coastal acidification, ensuring we have a better understanding on how changes in water chemistry impact I may say, impact our estuaries and other marine environments along our coast. And it established also an ocean acidification board to increase coordination among all the stakeholders. I'm especially pleased that one of those entities represented in this new advisory board will be the Caribbean Regional Association for Coastal Ocean Observers, which is based out of the University of Puerto Rico. I think this bill will provide the necessary federal resources to expand our knowledge of ocean and coastal acidification and inform our adaptation and mitigation plans. I want to say thank you, all of you, for your time. I know you've been here almost the whole afternoon, and thank you for giving the time for me to speak on these important amendments. I yield back.
Thank you. Mr. Johnson.
Thank you, Madam Chair. And let me first say that I've been on for about an hour listening to the loquaciousness of my colleagues. It's very admirable, and I'm prompted to join. However, I know that the night is getting kind of late, and so I will limit my remarks. I'd like to thank you for inviting me to testify today in support of my amendment. And I want to thank the committee members overall for your hard work and your diligence and your dutifulness. I think we can all agree that America is better off when we are well prepared for the national security threats that come our way. And that's why I urge the committee.
Yeah, get rid of that one.
That's why I urge the committee to adopt my cybersecurity education amendment. This amendment would create the David Satcher Cybersecurity Grant Program to enhance cybersecurity education and training at colleges and universities that serve students from minority and low-income backgrounds. It would also help strengthen cybersecurity, improve American competitiveness, and contribute to a more diverse workplace by giving the Commerce Department's National Institute of Standards and Technology, also known as NIST, the authority to make grants to historically Black colleges and universities and minority serving institutions and schools that serve many Pell Grant receiving students to promote cybersecurity education and research. It appears that America will be perpetually under attack and engaged in cyber warfare, and we need all hands on deck. While the threats facing us in cybersecurity are abundant, the lack of diversity in our cybersecurity apparatus hampers America's ability to meet the challenges that we face. And so my amendment would kickstart the process of rectifying the problem of lack of diversity in cybersecurity education while positioning our country to maintain the edge that we need to meet the challenges ahead. And so I urge the committee to support my amendment. And with that, Madam Chair, I yield back.
Thank you. Mr. Calvert.
Hello, can you hear me?
I can hear you. I don't see you yet. Oh, there you are.
Yep, right here. Well, thank you, and I want to thank the chairman and the ranking member. I appreciate the opportunity to testify about my amendments to HR 4521, which tackle the bipartisan priority of protecting the rights of American innovators. Both forced tech transfers and intellectual property theft have become an integral part of China's research and development strategy at the cost, obviously, of hardworking Americans and our national security. The Chinese government regularly preys on academics and innovative American companies, large and small. Many of these small businesses seek capital to expand their businesses without understanding the risk of cyber theft from their so-called partner. In my district, this is all too familiar a tale. Saleen Automotive is an American manufacturer of high-performance sports cars and automotive parts, headquartered in my hometown of Corona. In 2016, Saleen entered into a joint venture with Rugao City government in the Jiangsu province to distribute Saleen's vehicles to the Chinese market. In 2020, Rugao government forcibly took over Saleen's factory, seized the intellectual property, and expelled the company's U.S. executives. Innovators ranging from Saleen Automotive to Lockheed Martin have fallen victim to China's intellectual property theft, and it's long overdue for more forceful U.S. response. My amendment will take an important step in bringing these practices to an end and holding China accountable. My first amendment, number 531, expresses a sense of Congress that the U.S. government should prioritize the equitable resolution of any forced transfers of U.S. intellectual property by government-owned entities in China. My second amendment, 580, is the text of Protecting IP Act of 2021 included in the Senate's bipartisan U.S. Innovation and Competition Act. The amendment encourages the U.S. Trade Representative to use all tools at their disposal to enforce the intellectual property provisions outlined in Phase 1 trade deal signed by the United States and China in January 15th, 2020. These amendments are not merely about protecting the intellectual property of commercial items, but strengthening our posture against predatory practices of China and safeguarding proprietary information vital to our national security. These amendments would indisputably strengthen the bill. It should be a bipartisan and non-controversial issue. I would ask the committee favorably consider my amendments. And with that, Madam Chairman, I yield back the remainder of my time.
Thank you, Mr. Calvert. And now I will turn to Mr. Cole for any questions that he may have.
Thank you very much, Madam Chair. And I'm not going to pose any questions to the panel. I would just urge our committee to make all of these amendments, quite frankly, in order, because we simply didn't have the normal deliberative process at the committee level that you would have. So I think the more of them that are made in order, I think the better people will feel about the legislation, their opportunity to have an input. So again, I thank all of our witnesses for their testimony and their ideas. And again, I hope they're all made in order so they have an opportunity to be debated and voted on the floor. Thank you, Madam Chair. I yield back.
Mr. Burgess.
I have no specific questions for our panel. I want to thank them for being here, and I want to underscore what my ranking member, Mr. Cole, said. All of these amendments, both Republican and Democrat, should be made in order so that we have an opportunity to hear them on the floor of the House, and the whole House has an opportunity to weigh in. Thank you. I yield back.
Mr. Perlmutter. Sorry, Ed.
It's all right, thank you. Just don't call me late to dinner.
I know.
I just have a question for Mr. Buck. Let's see, escaped. I see his name there. There he is. Just a quick question on what's the difference between your definition or the definition that currently exists in law on sexual harassment and that is in the proposed bill?
So in the proposed bill, I thank the gentleman for the question. In the proposed bill, there is a list of actions that would constitute sexual harassment. That list is similar to some state law, different than some state law. But this bill, the amendment, frankly, just says that whatever applicable jurisdiction law applies. So in the case of a case that occurred on federal property, it would be federal sexual harassment definition, tribal property, tribal definition, and in state, if it went to a state court, it would be the definition that's contained in that state law.
Okay, all right, thank you. I yield back.
Thank you. Mr. Reschenthaler.
Thank you, Madam Chair. I have no questions. I just want to thank all the witnesses for coming in tonight. I yield back.
Mr. Ruskin.
Given the lateness of the hour, I have no questions and yield back to you, Madam Chair.
Ms. Fishbach. Any other member of the committee wish to ask a question? Okay, seeing none. Once again, I want to thank the panel for being here, and please leave any notes that you might have brought with you. Turn them over to our stenographer. So seeing that there are no other questions, I would like to call the next panel. I want to welcome our next panel to testify on amendments to HR 4421, the Competes Act of 2022. We have Honorable Bill Foster, Honorable Al Green, Honorable French Hill, Honorable Earl Buddy Carter, and we are delighted that you are here with us. Anything that you brought in writing or submit to rules documents at mail.house.gov before the conclusion of this hearing will, without objection, be entered into the record. I now recognize Mr. Foster.
Thank you. Audible and visible here?
You are.
Well,
No, we can't hear or see you.
Stop that.
well, first off, I want to thank Chair McGovern, Ranking Member Cole, and all of you for allowing me to testify. I'm here to speak about my amendment number 214, which actually appropriates funds to the National Science Foundation, the Department of Energy Office of Science, and the National Institute of Standards and Technology in amounts that are comparable to what is appropriated to support the semiconductor industry. You know, I'm a proud co-sponsor of the America Competes Act and a strong supporter of the goals of this legislation. And I say that as someone who, as a 19-year-old kid, founded and ran a high-tech manufacturing firm that now provides over 1,300 manufacturing jobs with good pay and good benefits, and has kept all those jobs in the Midwest. And our company exports worldwide about a third of what we manufacture, despite having to compete with cloned Chinese products for decades. And I also say that as someone who's designed numerous integrated circuits, computer chips, and then watched heartbroken as that industry has moved offshore for reasons that are far more complex than we are discussing here. But the CHIPS Act is a good and useful start. Now, as has been mentioned here, important parts of the America Competes Act is made up of legislation that's come out of the House Science, Space, and Technology Committee. 2 years ago on the House Science Committee, we were faced with a remarkable prospect of having dueling partisan proposals to double the federal science budget. And since then, under the leadership of Chair Johnson and Ranking Member Lucas, and with participation of all members who wished, these have been merged into bipartisan proposals to authorize the same. But it is crucial that Congress actually appropriate those money for those expanded missions. My amendment simply directs appropriations to support the expanded missions authorized under this bill. You know, I spent 23 years in a federal science agency at a national lab run by the DOE Office of Science, and I know that one of the worst things that you can do to any technical organization is to give them an exciting new mission or missions, but without the money to carry them out. The America Competes Act provides a bright vision of hope for new federal science funding, and I'm excited to see it lead the way into the future, but we have to show them the money. Thank you. I urge members to support my amendment and yield back.
Thank you. Mr. Green.
Thank you very much, Madam Chair. And for the benefit of my friend, Mr. Perlmutter, I have a new microphone. I trust that you can hear me well. Okay, thank you. Friends, I'm honored to present amendment number 322. And I'm pleased to announce that I am very much supportive of what we're doing. So in addition to thanking the chair and the ranking member, I think I should also thank Mr. Pallone, Mr. Meeks, and Ms. Johnson for the work that they've done thus far. This is a very simple amendment. A strategic stockpile should be strategically located. It may be the case that there will be a need to purchase some land, to purchase some facilities or maintain facilities. If this is the case, this amendment provides that option. The amendment does not add to the cost of the legislation. The amendment does not require that land and buildings be constructed. It merely gives us the additional option if this happens to be a need that should manifest itself at some point. I welcome any questions, and I trust that being terse and laconic has made a difference.
Thank you. Mr. Hill. Mr. Hill. Mr. Stauber. Mr. Moore. Mr. Cole, where are your members here?
I have no idea, Madam Chair.
Okay, well, seeing
see
that
Mr.
there
Carter.
are no other members.
Buddy's here, Buddy's here.
Okay, I didn't have him. Oh, sorry, Mr. Carter, you are on my list.
And now Mr. Stauber has popped on
Stauber's
the
here,
screen,
right.
Madam Chair.
Okay, let me recognize Mr. Carter.
Okay, thank you, Madam Chair. I appreciate the opportunity to testify on my amendments for the so-called America Competes Act. I must start by saying my reservations about the underlying bill and the process that led to it coming to the fore are many. In these divided times, it seems that a few things can unite us. However, I would argue that if there was one thing that unites every single American, it would be keeping Americans' competitiveness and greatness, especially in the face of undemocratic and oppressive adversaries like China. Unfortunately, that was not the spirit in which this bill was created. It was crafted behind closed doors with zero input from Republicans and is now being rushed to the floor for the sake of a quick political victory.
Okay.
As we see rampant inflation, the bill proposes billions in new spending on unaccountable programs, including those that would actually benefit the Chinese Communist Party. It fails to mention the current genocide the CCP is committing against the Uyghurs in China, but mentions climate change over 150 times. I'm all for holding China accountable for its emissions and contributions to climate change, but we seriously need to rethink our priorities if we refuse to acknowledge the atrocities that are being allowed to continue in China. That's why I've submitted amendment number 119. This amendment would amend the two energy sections to prohibit taxpayer funds going to the Chinese Communist Party or for materials produced with forced labor. At least 1.8 million Uyghurs are held in political re-education camps where they are subject to rape and sexual violence, re-education, and forced labor, among other horrors. Every dollar that goes to the Chinese Communist Party perpetuates these crimes, and my amendment will ensure that Americans do not contribute. My other amendment, number 158, would likewise ensure that we do not give money to the Chinese Health Ministry. The fact is clear. China is not our friend. They are an enemy of the United States. Yet we continue to give money to their health ministry to conduct dangerous, unsupervised, potentially weaponized research. We should never again send a single U.S. taxpayer penny to China's health ministry. During the first days of the pandemic, the Chinese health ministry refused to acknowledge to the world and their own citizens that a new virus was raging. They claimed it was a cold or seasonal pneumonia. By the time the rest of the world was able to access and study the virus's genome, it was too late. It had already spread worldwide. And now they refuse to comply with any international investigation into the coronavirus origin. Perhaps worse is the World Health Organization's role in covering up China's lies. The World Health Organization's connection to the Chinese Communist Party of China has been a cause of concern for many Americans, and my constituents are tired of footing the bill for such a corrupt organization. The World Health Organization has helped cover up China's lies during the pandemic, and they have failed to investigate COVID-19 origins properly and thoroughly in China. The World Health Organization also has a track record of covering up for China. For example, on January 14, 2020, the World Health Organization repeated China's claims there was no evidence of human-to-human transmission, despite the obvious evidence suggesting otherwise. Then, not even a month later, on February 3rd, 2020, the Director General of the World Health Organization praised the Chinese president, saying he was impressed by his leadership. This is the same man who covered up virus outbreaks in Africa, and he refused to respond to the Ebola outbreak. How can we sit here any longer and claim that we are doing our due diligence by leaving this man in charge of investigating COVID-19 origins, a man who practically appointed into the position by Beijing? The World Health Organization is an international disgrace, controlled by the highest levels of the Chinese Communist Party. The World Health Organization must make a concerted effort to increase transparency and ensure that they are not under the influence of Chinese communist officials if they have any intention of being a respected international organization again. My amendment number 355, introduced with Mr. Guthrie, the ranking member of the ENC Health Committee, would prohibit funding for the World Health Organization. This leads me to amendment number 157, which is also co-sponsored by Mr. Guthrie. This amendment would ban gain-of-function research. American taxpayers' dollars were being used by Chinese researchers in Wuhan to make viruses that originated in bats more transmissible. This is not misinformation. This is a fact. We know gain-of-function research occurred. Can you not admit that this research could have possibly resulted in a man-made virus that leaked from the lab, causing the pandemic? We in Congress have nothing to get to the bottom of this. We've done nothing to get to the bottom of it. Not a single hearing, no testimony, nothing. The National Institute of Health has many things to answer for, and it would be great to have Dr. Fauci testify to the Energy and Commerce Committee. I sit on more often. Maybe he has something to hide. Dr. Fauci has lied. Dr. Fauci has lied. He lied to you, he lied to me, and everyone else in this room. He claims NIH never conducted gain-of-function research or provided grants to support such research. Yet we were all made aware last summer by investigative journalists that the NIH was funding gain-of-function research through grants to the EcoHealth Alliance that were passed along to the Wuhan Institute of Virology. Political partisanship, scientific groupthink, and big tech shut down any and all mention of the possibility that the coronavirus was from the Wuhan Institute of Virology. We should prevent any money from going to the Wuhan Institute of Virology, any money. A lab that does bioweapons research for the Communist People's Republic Liberation Army. We should make sure every single U.S. university cuts their ties with the lab too. We have the opportunity to take this immediate action today. We can pass my amendment to stop taxpayer-funded gain-of-function research on potentially deadly transmissible pathogens right now. It mirrors almost identically the 5-year moratorium President Obama put in place in 2014 to stop gain-of-function research. And this language appears verbatim in Senator Schumer's United States Innovation and Competition Act. However, as it is in many areas, the American Competes Act is toothless when it comes to our ability to compete with China. Another example is the critical mineral space. The underlying bill calls for studies on critical mineral exploration and deep sea mining, but the reality is we all depend almost completely on China for these minerals today and will long into the future. My amendment number 410 would incorporate my bill, the Critical Minerals Access Act. This bill allows the U.S. International Development Finance Corporation to allow critical mineral projects in support of national security and interest in high-income economy countries where they would otherwise not be allowed. Congress did nearly the exact thing with the European Energy Security and Diversification Act that allowed for investments in Eastern Europe to counter the energy dominance of Russia. Congress should do similarly with this bill, especially in an area where we are so dependent on a single country, a country that is our competitor, a country that is our enemy. I will end on a bipartisan and hopeful note. The last amendment I want to speak in support of, number 397, that I introduced with Representative Fortenberry, Ming, and Quigley, and is an important bipartisan addition to the underlying bill. This amendment would reauthorize the Eliminate, Neutralize, and Disrupt Wildlife Trafficking Act with important additions. The END Act authorizes our country's work to counter wildlife poaching and trafficking, another crime that China plays a part in. In fact, China is the largest market for illegal wildlife protection products. This amendment would allow for the work of the Presidential Task Force on Wildlife Trafficking to continue, and with new priorities on addressing the role technology, digital platforms, and social media play in illegal wildlife trafficking. Again, I oppose this bill and hope we can truly come together to actually compete against China. I urge the adoption of my amendments, particularly the last one, the bipartisan one that deals with wildlife trafficking. And I spoke on these today. They would improve this bill, and I ask for your consideration, and I yield back.
Thank you very, very much. Let me just inform the committee. So we have one vote that's going on right now, and I want to keep this hearing going so that people can go vote when they want to. I know that Mr. Foster and Mr. Green and Mr. Carter have testified in this panel. Does anybody on this panel have any questions for them? Before we go on to Mr. Hill, I just want to let them go vote if there's no questions, or there are questions. Who speak now or forever hold your peace.
Yeah. Mr. Chairman, I just was going to, for my friend, Mr. Carter, I have a whole list of quotes from Donald Trump about how much he loves China and Xi Jinping and all that stuff, but in the interest of time, I won't go through all of them. But I just want you to know that I have them.
Yeah, no, and I was thinking of the same thing. I'm looking at an article here. Trump thought China's detention camp was exactly the right thing. There was that's a Business Insider, a Washington Post story, New York Times story. I just want to say, Mr. Carter brought up the Uyghurs. Let me just remind him that we did pass the Uyghur Forced Labor Prevention Act in this Congress, and President Biden signed it. We could have done it a lot earlier. We passed it in the previous Congress, in the House. We sent it over to the Senate that was controlled by the Republicans at the time. They chose not to bring it up. And the Trump administration was not urging that they move forward. That's a strong, real piece of legislation to go after the Uyghur atrocities and to make sure that we hold China accountable, and we hold the business community accountable to not source their products with forced labor. But in any event, I don't want to go there. But anyway, Mr. Raskin.
Mr. Chairman, thank you. I couldn't resist joining you and Mr. Perlmutter in just congratulating Mr. Carter on his comments, because I'd like to join in the same bottomless reservoir of outrage and indignation that you had about invertebrate capitulation to the Chinese Communist Party at the highest levels of the US government, I was going to invoke a dozen different things Donald Trump had said, but I'll reduce it to just two. And one, it was he wrote on January 22nd, one of the many great things about our just signed giant trade deal with China is that it will bring both the USA and China closer together in so many other ways. Terrific working with President Xi, a man who truly loves his country. Much, much more to come. And then on January 25th, then President Trump wrote, China has been working so very hard to contain the coronavirus. The United States greatly appreciates their efforts and transparency. It will all work out well. In particular, on behalf of the American people, I want to thank President Xi, exclamation point. So this was the standard set by the last president. I'm glad we've got a president and administration that's finally getting tough on China, that's going to allow us to compete and to stand up for human rights all around the world. But thank you for the outrage and indignation, because I share it with you.
Okay, so thank you.
Back to Mr. Chairman.
You guys can go.
Do I get a chance to respond, or I just?
If you want to respond, you can. Go ahead.
No, I just wanted to thank y'all for the piling on. I appreciate it. I just want to make sure you knew how much I appreciated it.
It was hard to resist, but anyway,
It's hard to resist the fact that this is ridiculous, that you're going to allow this to happen and then blame it on a previous administration and blame it on a previous president.
we were just pointing out the of what you guys said when you were in charge, and about some of the things that have been done. Actually,
well, I know that makes the Uyghurs feel so much better.
Yeah, thank you. Thank you very much. Okay.
Mr. Chair?
Yes, Mr.
Was
Foster.
I on this panel or not? This is Stauber. I thought I was on this panel.
Yeah. So those who have already spoke can go. Members of the committee can take their turn going to vote. We're now going to go to Mr. Hill. I'm sorry, the vote hasn't started yet. So it's 6:30. We have Mr. Hill, Mr. Stauber, Mr. Morelli, Mr. Moore. So we go to Mr. Hill now.
Well, thank you, Chairman. It's a pleasure to be with you, even virtually, and Mr. Cole. Appreciate the hard work of our committee, even the hard work of Ed Perlmutter. It's always appreciated by everybody in the Congress, the work of our Rules Committee. And I have to say off the top, with over 500 amendments proposed, clearly this bill is not ready for prime time. If we'd gone through our committees, if we'd worked hard, members on both sides of the aisle have many, many provisions related to Chinese competitiveness and a better competitive position for the United States. I think we would have had a better product. But with that said, let me turn and mention 3 amendments for the committee's consideration. First, Amendment 537. It's a bipartisan amendment with my friend from Connecticut, Jim Himes, that would direct the Treasury in consultation with the Federal Reserve to report to Congress on a strategy to maintain the United States dollar as the primary global reserve currency and complete an analysis of the Chinese RMB. The dollar has been the linchpin of the global economy since 1944 and the Bretton Woods Agreement. And its status as the world's reserve currency is one of the distinct advantages that the United States financial system has, certainly over the emerging system in China. With China seeking to internationalize its currency and push its own central bank digital currency, I believe it's critically important for the administration and Congress to have a thoughtful, actionable, and decisive strategy to protect the primacy of the US dollar as the reserve's reserve currency. My second amendment is Amendment 445. It too is a bipartisan amendment with my friend across the Mississippi River, Steve Cohen. And it looks to protect American business and security interests by requiring foreign business entities to assign and register as an agent with the Department of Commerce as a prerequisite for doing business in the United States. Foreign entities, especially those from China, are notorious for stealing trade secrets and intellectual property, those rights of our U.S. firms. This is an age-old practice as countries and businesses attempt to gain the upper hand over their international competitors. However, in recent years, certainly the past 3 decades, China has increasingly acted with impunity in this area, utilizing whatever means are necessary. However, this is not a practice undertaken solely by Chinese firms. The assigned agent, as required by this amendment, would be responsible and liable for service of process requests within U.S. jurisdiction. At present, foreign entities participating in the United States can effectively operate behind a firewall that keeps them largely immune from the jurisdiction of U.S. courts and regulatory agencies. If a U.S. plaintiff files a complaint against a firm based abroad, the typical first response and argument by these foreign entities is, hey, we're not subject to U.S. jurisdiction, as the firm does not typically keep a representative of their company in the United States. While firms from many countries don't typically adhere to such a practice, business entities from certain countries do behave in this manner. This amendment builds on past efforts to address this issue and requires all foreign entities that engage in economic activity to have a registered agent in the U.S. as a prerequisite for U.S. market access. This Amendment 445 is not meant in any way or method to punish or disadvantage firms that already operate in the U.S. in a lawful manner. I co-chair the Foreign Investment in the United States Caucus, and our country benefits from foreign direct investment engaged in our economy. To the contrary, this amendment is meant to ensure the U.S. remains a level playing field where businesses can operate knowing that they have a legal course of action if they become a victim of economic espionage or IP theft from a nefarious actor. Finally, Mr. Chairman, my third amendment, Amendment 81, simply clarifies that all registered apprenticeship programs are eligible for Title II grants under the National Apprenticeship Act of 2022, included H.R. 4521. The America Competes Act allows government to play favorites with this Title II funding for apprenticeships. The legislation includes an important caveat: to the extent practical, that the partners be part of an industry or sector partnership, and the legislation says, and partner with a labor or joint labor management organization. My amendment is simple. It simply says it changes the and to an or. The unintended consequence of saying and separates non-union and union entities for partnership emphasis. That's for both industry and based on many grassroots reports that I've read. I'm afraid the federal government will see this as a requirement that the entities requesting for funding under Title II must be partnered with a union. My amendment allows the America Competes Act not to have preference over one business model over another. And it's supported, Mr. Chairman, by Opportunity America, the Jobs and Career Caucus, and the Associated Building and Contractors. I request that the committee make all three of these amendments in order so that they can be considered by our colleagues on the House floor. Thanks for the opportunity to testify, and I yield back.
Thank you very, very much. Mr. Stauber.
Thank you, Chairman McGovern and Ranking Member Cole. Our communities are becoming more unsafe by every second as this administration continues to keep our southern border wide open to criminals, drug runners, and cartel members. The DEA revealed this past December that criminal drug networks in Mexico, using resources from China, are trafficking fentanyl over the southern border at a rate that could provide a lethal dose to every American. All this at a time when overdose deaths are claiming a new victim every 5 minutes. The hardest thing I ever had to do during my 23 years as a law enforcement officer was tell an unsuspecting mother that her child died because of a drug overdose, to hold her as she cried knowing that this death was preventable. We have a duty and a moral responsibility to do everything we can to prevent another heartbroken family. And that starts with enforcing our laws at the border. Amendment 80 is simple. It requires the report on bilateral effort to address the Chinese fentanyl trafficking to include an assessment on the intersection between illicit fentanyl trafficking originating in China and the illicit fentanyl trafficking over our southern border in the United States. Through this amendment, it is my hope that we can finally address the drug crisis plaguing our nation and avoid the loss of further innocent life. Chairman McGovern and Ranking Member Cole, I also have several amendments addressing our supply chain crises. The United States is import reliant on China for virtually all of our minerals. 70% of the world's cobalt reserves, for example, are in the Congo, where China owns a significant share of the mines, employing child slave labor and using terrible environmental practices. The raw product is then shipped back to China and manufactured. We then purchase it every day for our lithium-ion batteries going into electric vehicles and our everyday devices. So how do we rectify this issue? For starters, 95% of our own domestic cobalt reserves are in my district, and several mining companies are seeking to develop it. Because some of the cobalt is on federal land, the Twin Metals project holds 2 valid and existing leases. But because this administration cannot stomach the thought of crossing their activist friends, Joe Biden made the calculated political decision to side with the elite activists over a union workforce in my district. Therefore, Amendment 557 simply does the right thing. It requires the Interior Secretary to ensure supply chain woes are not made worse as a result of canceling the 2 federal leases for the Twin Metals project. And also, Amendment number 213 addresses the tangled web of permitting these projects. Again, we desperately need these minerals. In my district, we have 95% of America's cobalt, 88% of our nickel, and more than 1/3 of our copper. It's called the Duluth Complex. It's the largest copper nickel find in North America. We have the resources to move our dependency on China back to our own shores, our own manufacturers, and our own workers. However, with mines taking up to 19 years, in some cases, to permit, we need to streamline this process. Therefore, I introduced my legislation, Accessing America's Critical Minerals Act, to the so-called China Competes Act. My bill ensures timeliness, reasonableness, and transparency are part of the permitting process. For too long, we've seen activist groups with very well-connected members on their board use every tool in the toolbox to leverage the administration against permitting any project while giving political cover and dragging Americans along. It's delay after delay, study after study, consultation after consultation. Enough. Let's mine these minerals using an efficient process that respects science and common sense. As we analyze supply chain deficiencies, it's clear that China still dominates the manufacturing sector of critical minerals. And it's no secret, America has fallen behind on manufacturing. We need to bring our industrial sector back. Therefore, I'm introducing my Manufacturing America's Mineral Security Act as Amendment number 207. It creates a tax deduction for domestic manufacturers to purchase domestically processed critical minerals. It will jumpstart 2 of the broken cogs in our system, refining and manufacturing, working alongside my other amendments to boost domestic mining. Chairman McGovern and Ranking Member Cole, we are considering legislation that's stated intent is to compete with China. Yet the bill mentions coral reefs more times than China and virtually ignores our mineral security issues. Before I move on, I ask everyone to listen. I ask everyone listening to take a moment and look at the device you're using right now. Where was it made? How were the raw materials acquired to build it? And how was it made? The answer is China or Chinese-owned mines, many of which use child slave labor at different points in the supply chain. Therefore, I urge adoption of my amendments to mine, refine, and manufacture in America. Finally, my amendment number 188 will address our medical and pharmaceutical reliance on China. It should scare every member on this committee that China makes 93% of the ibuprofen produced worldwide. It should further raise concern that the factories producing those drugs were inspected via video chat through the pandemic. Further, those remote inspections should be even more concerning considering in 2008, 246 Americans were killed by a tainted batch of blood thinners produced in China. China repeatedly steals intellectual property, kills Americans through subpar manufacturing standards, and commits countless human rights abuses, and the world is still somehow complacent with allowing communist China to hold the keys to nearly all of the world's active pharmaceutical ingredient production. My amendment will ensure that the United States is incentivizing domestic drug manufacturing and address the glaring national security and health vulnerabilities that exist within the status quo. Thank you, and I urge my amendments to be made in order, and Mr. Chair, I yield back.
Thank you very much, Mr. Morelli.
Thank you, Mr. Chairman. As I previously mentioned, there's much in this bill I'm proud to support, but I do have one addition that I believe will make the bill even stronger. My amendment number 183 would expand the priorities for research and development regarding acceleration.
Morelli? Why is he speaking of that?
I'm sorry?
Somebody needs to mute.
Very good.
Yeah.
My amendment number 183 would expand the priorities for research and development regarding acceleration of the advancement and adoption of innovative microelectronics to include technologies based on organic and inorganic materials. So organic light emitting diodes, or OLED microdisplays, and direct view displays have been identified as a critical U.S. supplied technology area of interest due to its unique performance attributes required for a range of DoD programs. So the ability to deliver the most accurate representation of the so-called real world is critically important for night vision displays, helmet-based displays, diagnostic equipment, medical imaging, or heads-up display systems. Despite a demand for microdisplays, there is limited domestic manufacturing, and the production that does exist faces the same supply chain issues so many industries face at this time. So there is a clear opportunity for the United States to be the world leader in OLED microdisplay and direct view display technology, research, and production, and including language relating to organic materials will help promote robust, secure U.S. capability in organic semiconductors for years to come. So that's why I'd like to advance amendment number 183. Thank you. I yield back.
Mr. Moore.
Thank you, Mr. Chair, Mr. Ranking Member, and just jumping over, getting to everything. And other members of the committee, I sit before you on my Zoom, not stand, but I present to you to urge you to support Amendment 499 to HR 4521. Given the COVID pandemic, our supply chain crisis, increasing Chinese aggression towards key regional partners, the United States has a rare window and obligation to re-examine our relationship with the Chinese Communist Party. To counter growing Chinese threat, we must level the playing field against unfair trade practices, promote American workers, defend societal institutions, and protect our regional interests by standing with our allies. This bill plays a role in formalizing a necessary discussion on the effects of great power competition on the American economy. I believe it needs significant improvements. My amendment is a small but important language change that demands greater accountability from China and strengthens the Department of Defense's ability to deter any potential People's Liberation Army's aggression towards Taiwan. Chinese hostility in Hong Kong and the escalating belligerence towards Taiwan are calculated efforts by the CCP in their campaign for dominance in the Asia Pacific. We cannot pass up an opportunity to be proactive and reaffirm our military's commitment to denying hostilities against Taiwan. This amendment will help us get to that point with this push for this legislation, and I urge you again to support Amendment 499. Thank you, Chairman, and I yield back.
Mr. Wilson.
Thank you, Chairman Jim McGovern and Ranking Member Tom Cole. And I first want to join in with Congressman Moore and support 499. In the meantime, there are 4 amendments that I'm offering to this bill. The first is Amendment 236. This amendment increases penalties for non-compliance to Section 117 of the Higher Education Act and increases transparency for sections of the bill related to Confucius Institutes and the reporting of institutions that are subject to disclosure of foreign gifts and contracts. While I'm pleased to see some progress in addressing these issues, a penalty as low as $250 per university not complying with the foreign gift disclosures is hardly a reprimand. At Stanford University, a university known for receiving millions of dollars from China through their Confucius Institute, $250 is an award for a prize drawing for filling out a survey, and that is not even for the top prize. The issue is serious. When the United States had 107 Confucius Institutes, only 16 host universities reported Confucius Institute related gifts to the Department of Education since 2010. This is despite the fact that the Center for Language Education, in cooperation under the Ministry of Education of the Chinese Communist Party, typically offers host universities upwards of $100,000 in funding. It's very revealing. In 2009, Li Shangcheng, then the ideology czar for the CCP's United Front Work Department, called the Confucius Institute's, quote, an important part of China's overseas propaganda setup, end of quote. We must work to increase transparency for students, parents, concerned citizens. Flagrant violations must be met with accountability. Universities that receive taxpayer funding should be required to disclose foreign influence on their campus, and failure to do so should be credibly enforced. We must take this issue seriously and provide Americans full transparency when it comes to the sources of their education. I ask for your support of this amendment being made in order. The second amendment I'm offering for consideration is number 452, which prohibits funding to the United States Agency for Global Media to air and disseminate statements from the Chinese Communist Party and its officials unless the statements are fact-checked or context was provided. We have seen how the CCP weaponizes false information, and no U.S. agency should inadvertently help proliferate falsehoods from an authoritarian government such as the CCP. The third amendment for consideration is number 504. As amended, this requires the application of export restrictions to countries on the state sponsors of terrorism list if they purchase an array of military goods, services, or technologies from China. While state sponsors of terrorism are already subject to an array of export restrictions, this would provide an incentive for those that seek to change their behavior to not engage with the PRC for armament sales. Doing so only reinforces these restrictions. Lastly, I'm grateful to join with my Kleptocracy Caucus colleagues in offering bipartisan amendment number 359 to address one of the biggest modern threats to democracies around the globe, kleptocracy. The Foreign Corruption Accountability Act prevents individuals who have demanded bribes from Americans from entering the country, which is to me common sense. Justice for victims of kleptocracy promotes transparency for those countries have stolen from them by requiring a public listing of assets stolen by corrupt officials that have been frozen by the United States. People living under corrupt and authoritarian governments deserve to know where their hard-earned money ends up. I ask for full consideration of these common sense amendments to be made in order. And thank you, and I yield back.
Thank you very much. Any questions of the panel?
Okay. Mr. Chairman, Burgess here.
Dr. Burgess, go ahead.
Not really a question to Mr. Stauber. I want to thank you for highlighting the difficulties on our southern border, particularly the Texas southern border. It's unlike anything I've ever seen, and it certainly is contributing to the unconscionable number of fentanyl overdoses that we're seeing in this country. It needs to stop. It needs to be corrected. The state of Texas should not have to be spending the money that it is spending right now. This is a federal responsibility, and the federal government should step up and do the job. So thank you for bringing this to our attention.
Thank you.
Mr. Chairman?
Yeah, who's Mr. Cole?
Thank you very much, Mr. Chairman. Just quickly, I want to urge adoption of all the amendments. I appreciate all our witnesses here, or the adoption amendments be made in order. Some I would support, some I might not. But I think given the unusual manner of the consideration of this bill, all of them ought to be made in order so that the Congress have an opportunity. So again, thank you for bringing forward your various suggestions and ideas. And again, certainly hope they all have an opportunity to be heard on the floor and all our members can collectively come to a judgment. So with that, Mr. Chair, I yield back.
Mr. Chairman, this is Perlmutter. I have a question
Mr.
for
Perlmutter.
Mr. Morelli, but I see that he's gone. So I would disagree with Mr. Cole that all the amendments should be made in order, because I had a question for Mr. Morelli. His amendment, and I wanted to understand the chemistry here. Maybe Mr. Hill could help me. In paragraph 11 is so redesignated. This is an amendment to page 66. He says, by inserting but shall include inorganic semiconductors and organic light emitting diode semiconductors. And I just wanted him to explain the difference between the two and why that should be entered specifically in that section of the bill. But of course, he's left, so we won't ever have an answer to that critical question about this bill. With that, I yield back.
Would the gentleman yield?
I certainly would yield to my friend.
Well, my friend from Colorado is so persuasive, you might persuade me to vote against Mr. Morelli's amendment if that's what you want to do. Anything to help out my friend.
I thank the gentleman. I yield back.
Yeah, any other questions? Oh, all right. Any other members wishing to testify? Hearing none?
Mr. Chair, I do want to, and now I'll shut up, but I do want for the other members to know that I have an amendment, and my guess is you'll know what that amendment is, but I've offered an amendment to the Competes Act for safe banking, which everyone is becoming all too familiar with. But I am going to add that to every single bill I possibly can until it's passed. And with that, I yield back.
All right, so are there any other members who wish to testify or comment on Ed Perlmutter's amendment?
Just for the record, I support the amendment being made in order and look forward to supporting it on the floor.
This closes the hearing on HR 445 and HR 4521. And I guess we're gonna, without objection, the committee will recess so everyone can vote and then we'll come back. Okay. About 10 minutes. Yeah.
No. On the bill equally divided and controlled by the chair and the ranking minority member of the Committee on Foreign Affairs or their respective designees. The rule waives all points of order against consideration of the bill. The rule provides an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-30 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides that following debate, each further amendment printed in Part A of the Rules Committee report
not earlier considered as part of the amendments on block pursuant to Section 3, shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. Section 3 of the rule provides that any time after debate, the chair of the Committee on Foreign Affairs or his designee may offer amendments en bloc consisting of further amendments printed in Part A of the Rules Committee report, not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and the ranking minority member of the Committee on Foreign Affairs or their designee, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part A of the report and amendments en bloc described in Section 3 of the resolution. The rule provides for one motion to recommit. The rule further provides for consideration of H.R. 4445, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 under a structured rule. The rule provides for 1 hour of general debate on the bill, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides an amendment in the nature of a substitute consisting of the text of the Rules Committee print 117-29 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order the further amendment printed in Part B of the report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part B of the report. The rule provides for one motion to recommit. The rule further provides for consideration of H.R. 4521, the America Competes Act of 2022, under a structured rule. The rule provides for 2 hours of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Science, Space, and Technology or their designees. The rule waives all points of order against consideration of the bill. The rule provides an amendment in the nature of a substitute consisting of the text of Rule Committee print 117-31, modified by the amendment printed in Part C of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides for that following debate, each further amendment printed in Part D of the Rules Committee report, not earlier considered as part of the amendments en bloc pursuant to Section 8, shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. Section 8 of the rule provides that at any time after the debate, the chair of the Committee on Science, Space, and Technology or her designee may offer amendments en bloc consisting of further amendments printed in Part D of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on Science, Space, and Technology or their designees, shall not be subject to amendment, and shall not be subject to demand for division of the question. The rule waives all points of order against the amendments printed in Part D of the report and amendments en bloc described in Section 8 of the resolution. The rule provides one motion to recommit. The rule provides that House Resolution 188 is amended by striking February 4th, 2022 and inserting April 1st, 2022. The rule provides that proceedings may be postponed through March 3rd, 2022 on measures that were the object of motions to suspend the rules on the legislative day of February 1st, 2022, and on which the yeas and nays were ordered.
I think you were on mute. You want to start again? No, just kidding. You've heard the motion from the gentleman from North Carolina. Are there any amendments or discussion? Mr. Cole?
Thank you very much, Mr. Chairman. First, I want to congratulate our colleague from North Carolina for just getting through it. That was a terrific performance. That's not an easy task. Mr. Chairman, I have an amendment to the rule. I move that the committee strike the language in the rule that would continue the tolling of days for resolutions of inquiry. This is not a new amendment. I think this is the 11th time we've submitted it, so I don't think it requires a great deal of explanation. This is an important tool for the minority, a tool of inquiry, a tool of accountability and transparency, where the administration can be held to account. And we understood early on during the throes of the pandemic why that was necessary to get rid of it. We don't understand it now, quite frankly, when we're operating, both remotely and in person. And there's, in my view, no excuse for this. And I urge my friends to think about this in terms of the precedent you're setting, because I do think these sorts of things can come back to haunt everybody concerned. I don't say that as a threat. I just say that as an observation. It's just it's something that I would hope if the tables were reversed, we would not do, or having done, would have by this point lifted this. And so I think it's an important matter to bring up. I think it's important for us institutionally to address, and I think it's better done now than later. So with that, I urge the adoption of the amendment.
Well, I thank the gentleman, and we've had this discussion, and we will continue to have this discussion. Hopefully, we'll get to a resolution. But as I've said in the past, it would be nice if the Republicans could meet us at least halfway. I mean, just today we recorded votes were called on 7 non-controversial Democratic suspension bills, including a bill to name a post office after our former colleague John Lewis. And there are members on your side who have made no secret of the fact that they want to weaponize every tool available to delay things. And to obstruct things. So I've said before, we're trying to make progress here, but and we're going to continue to have this conversation. I hope we can make some progress, but I think it would be easier if we can get some cooperation by some on your side. So you've heard the amendment from the gentleman from Oklahoma. Any discussion? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye. Aye.
Opposed, no. No.
No.
The chair, the noes have it.
On that, Mr. Chairman, I would request a recorded vote.
The vote has been requested. Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter.
No.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon.
No.
Ms. Scanlon, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler.
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman.
You didn't call my name? Could you, I don't think.
Did you call Mr. Morelli? How did Mr. Morelli vote?
Mr. Morelli is not recorded.
Yeah, Mr. Morelli is in the negative.
Mr. Morelli, no.
Clerk report the total.
4 yeas, 8 nays.
Members not agreed to. Further amendments. Mr. Cole.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order amendment number 190 of HR 4521 offered by Mr. Wahlberg. The amendment adds a section to prohibit the president from revoking presidential permits relating to cross-border energy facilities. Mr. Chairman, this amendment is simple. It ensures the promises made to the American people are promises kept by preventing the president from unilaterally backing out of a previous cross-border energy agreement. This amendment will protect American jobs, ensure certainty in American energy sector, and prevent foreign adversaries such as China from gaining unfair advantage in such an area. These cross-border facilities cost millions of dollars to construct and can take many years. The amendment would ensure that companies can rely on the promises of the United States government and make sure that it's not subject to the whims of changes in administration. So I urge adoption of my amendment and yield back.
You heard the gentleman's amendment. Any discussion? Hearing none, the voters on the Cole amendment. All those in favor say aye.
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 No, no.
No.
Any of the chair, the noes have it.
Mr. Chairman, on that, I would request a recorded vote.
Order vote has been requested. Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter.
No.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon.
No.
Ms. Scanlon, no. Mr. Desagne.
No.
Mr. Desagne, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler.
Aye.
Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
The clerk report the total.
Well, you haven't called my name the last two roll calls, so I'd like to be recorded.
Why is Morelli being left out here?
Am I not on the list anymore?
It was by a popular vote of the committee.
How did Mr. Morelli vote?
Mr. Morelli is negative.
Okay, he voted, okay. Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chairman,
Mr. Cole.
thank you very much. I have an amendment to the rule. I move that the committee make an order amendment number 10 to HR 3485 offered by Mr. Perry. The amendment precludes the sanctions prescribed in the legislation from being used against individuals exercising their freedom of speech, religion, and association. It just simply put the lack of protections of freedom of speech and potential targeting of individuals for their sincerely held religious beliefs. And that remains very concerning to members on our side. The amendment, again, rectifies that by simply being very specific and stating concerning oversight, and certainly, at the very least, afforded should be given a debate on the House floor. So I urge adoption of the amendment.
Heard the gentleman's amendment. Any discussion? If not, the voters on the Cole amendment. All those in favor say aye.
Aye.
Those opposed say no.
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 Clerk will call the roll.
Mrs. Torres.
Torres, no.
Mrs. Torres, no. Mr. Perlmutter.
Perlmutter is no.
Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon.
No.
Ms. Scanlon, no. Mr.
Mr. Morelli's no.
Okay.
Morelli, no. Mr. Desagne.
No.
Mr. Desagne, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler.
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Mr. Morelli, every time your name gets mentioned, it gets blocked out. I don't know why.
Yeah, was that my description of OLED versus LED? Was that what got me blacklisted now?
We can hear "ma," and then the rally gets blocked out. But anyway, further.
Just voted off the aisle.
Yeah. Further-
Aye.
Further amendments.
Yes, Mr. Chairman.
Dr. Burgess.
I have an amendment to the rule to make an order. Amendment number 287 to HR 4521 offered by Ms. Bice of Oklahoma. This amendment redirects $8 billion from the Green Climate Fund to the United States Indo-Pacific Command to deter the People's Republic of China. Look, we need to be working together to deal with the threats that China poses to the United States and to the U.S. Indo-Pacific Command rather than handing billions in green climate slush fund money over to the Chinese. I urge the committee to accept this motion and make Representative Bice's amendment in order.
Yeah, for what it's worth, I know she had two amendments on the same topic, and we made one of them in order. So in any event, I would urge a no vote since we're going to be having the debate that you say we should have. Any other discussion? If not, the vote is on the Burgess Amendment. All those in favor say aye.
Aye.
Opposed, no.
No.
And you, the chair, the noes have it.
Roll call, sir.
Clerk will call a roll.
Mrs. Torres,
No.
Mrs. Torres, no. Mr. Perlmutter,
Perlmutter, no.
Mr. Perlmutter, no. Mr. Raskin,
No.
Mr. Raskin, no. Miss Scanlon,
No.
Miss Scanlon, no. Mr. Morelli,
Mr. Morelli's no.
Mr. Morelli, no. Mr. DeSagne,
No.
Mr. DeSagne, no. Miss Ross,
No.
Miss Ross, no. Mr. Neguse, Mr. Cole.
No.
Oh,
Mr. Chairman, how am I recorded? I'm sorry.
Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Burgess,
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler,
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach,
Aye.
Mrs. Fishbach, aye. Mr. Chairman,
No.
Mr. Chairman, no.
And can I ask, how was Mr. Raskin recorded?
Mr. Raskin is recorded, no.
And was Mr. Neguse recorded?
Mr. Neguse is recorded, no.
Okay, clerk will report the total.
4 yeas, 9 nays.
Amendment is not agreed to. Further amendments?
Yes, Mr. Chairman, I have an amendment to the rule.
Yeah.
I move the committee make an order amendment number 465, offered by Dr. Winstrup of Ohio to HR 4521. This amendment prohibits funding for gain-of-function research on potential pandemic pathogens conducted in countries that are our enemies, adversarial countries. Mr. Chairman, gain-of-function research can be important for scientific advancement, but as we've all seen, it can wreak havoc on the biologic world. We're in the middle of just such a nightmare right now. Federal funding for this research should be limited only to countries such as the United States and close allies. Not once in this 3,000-page bill is there a prohibition on China or any other adversary conducting this research at United States taxpayer expense. This is an extremely important amendment, and I urge the committee to accept this motion. Let's make it in order. Let's have the debate on the floor and let members vote their will. And I yield back.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Burgess Amendment. All those in favor say aye.
Aye.
Opposed, no.
No.
Any of the chair, the noes have it.
Roll call, please.
Roll call has been requested. Clerk will call the roll.
Mrs. Torres,
No.
Mrs. Torres, no. Mr. Perlmutter,
Perlmutter votes no.
Perlmutter, no. Mr. Raskin,
No.
Mr. Raskin, no. Miss Scanlon,
No.
Miss Scanlon, no. Mr. Morelli,
Mr. Morelli is no.
Morelli, no. Mr. DeSagne,
No.
Mr. DeSagne, no. Miss Ross,
No.
Miss Ross, no. Mr. Neguse,
No.
Mr. Neguse, no. Mr. Cole,
Aye.
Mr. Cole, aye. Mr. Burgess, Mr. Burgess, aye. Mr. Rushenthaler,
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach,
Aye.
Mrs. Fishbach, aye. Mr. Chairman,
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 9 nays.
The amendment is not agreed to. And I'm just noticing Dr. Burgess has got 5 amendments on it. How the hell did that happen? Must be bad staff work.
I will have to credit Mr. Walter for helping me, or actually Mr. Morelli with the diode issue. I think that helped.
Further amendments. Further amendments?
Yes, Mr. Chairman.
Mr. Rushenthaler.
Thanks, Mr. Chairman. I have an amendment to the rule. I move the committee make an order my amendment number 18 to HR 5421. Mr. Chairman, this amendment prohibits funding under this legislation from flowing to EcoHealth Alliance. As many of you know, EcoHealth is a New York-based nonprofit organization led by Dr. Peter Daszak. EcoHealth has a troubling history of collaborating with the Wuhan Institute of Virology, which is likely the origin of the COVID-19 pandemic. They were conducting dangerous research experiments involving viruses manipulated to actually increase human transmission in humans, gain-of-function research. Additionally, EcoHealth Alliance and Dr. Daszak have a record of failing to report findings from federally funded research facilities and refusing to cooperate with congressional oversight. Despite these glaring red flags, America's hard-earned taxpayer dollars continue to flow to EcoHealth. Most recently, in October 2021, USAID awarded EcoHealth a grant of $4.7 million for overseas foreign assistance programs. Mr. Chairman, it is vital to our national security that we stop funding dangerous experiments, especially ones in foreign-owned labs. Given EcoHealth's history of collaboration with the Wuhan Institute of Virology, as well as their troubling record of lies and downright disinformation, they should not be eligible to receive funding under this legislation. Thank you, and I yield back.
You heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Rushenthaler amendment. All those in favor say aye.
Aye.
Opposed, no. No.
No.
Either chair, the noes have it.
Mr. Chairman, I ask for a recorded vote.
Roll call has been requested. Clerk will call the roll.
Mrs. Torres.
No.
Ms. Torres, no. Mr. Perlmutter.
No.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon.
No.
Ms. Scanlon, no. Mr. Morelli.
Mr. Morelli's no.
Mr. Morelli, no. Mr. DeSagne.
No.
Mr. DeSagne, no. Ms. Ross.
No.
Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Burgess, aye. Mr. Rushenthaler.
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chairman.
Mr. Rushenthaler.
Thank you, Mr. Chairman. I have an amendment to the roll. I move the committee make and order amendment number 158 to HR 4521, offered by Mr. Buddy Carter of Georgia. This amendment prohibits funds made available to carry out this act from being used to support the Ministry of Health of the People's Republic of China. Mr. Chairman, Republicans have consistently pointed out concerns that this bill, which is meant to be tough on China, is ironically filled with taxpayer-funded giveaways to the Chinese government. The lack of transparency from China throughout this entire pandemic should raise alarms on both sides of the aisle. And that is why it's so disconcerting to see taxpayer dollars used to support this foreign health ministry. Mr. Chairman, I urge the adoption of my motion. I yield back.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Rushenthaler amendment. All those in favor say aye.
Aye.
Opposed, no. No.
No.
The chair, the noes have it.
Mr. Chairman, on that, I'd request a recorded vote.
Recorded vote has been requested. Clerk will call the roll.
Mrs. Torres. Mr. Perlmutter.
Perlmutter votes no.
Mr. Raskin.
No.
Raskin votes no. Ms. Scanlon.
No.
Scanlon, no. Mr. Morelli.
Mr. Morelli is no.
Morelli, no. Mr. DeSagne.
No.
Mr. DeSagne, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler.
Aye.
Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Did you get Mrs. Torres?
Mrs. Torres is not recorded.
Mrs. Torres? you're-
Torres is no.
Okay, no. Okay.
Torres, no.
All right, clerk will report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chair, I have an amendment.
Ms. Fishbach.
Mr. Chair, I have an amendment to the rule. I move that the committee make an order amendment number 73 to HR 4521, offered by Mr. Allen of Georgia. This amendment restricts the National Science Foundation from awarding grants and other forms of assistance to Chinese communist military companies and their affiliates. Mr. Chair, once again, we bring forth an amendment that rather than giving away American taxpayer dollars to fund the ventures of an adversarial country, would prove to actually be tough on China. Certainly, this amendment at least deserves the opportunity to be debated on the floor, and I urge adoption of my motion, and I yield back.
You heard the gentlewoman's amendment. Any discussion? If not, the vote is.
Mr. Chairman, just to comment, this amendment, the one Mr. Reschenthaler offered, the one I offered, we really should be giving the House the opportunity to debate these on the floor and let the members vote their will. We're talking about funding adversarial countries with U.S. taxpayer dollars in these amendments. This amendment of Ms. Fishbach's is extremely important, and this committee should not slight it.
Well, I'm going to urge a no vote because on the face of it, this amendment seems to make sense, but in actuality, it's extreme. It can prevent any research cooperation or collaboration not only with China, but also with researchers who have ever worked with a Chinese entity of any kind, such as those who collaborated on an international research team. So rather than stoking U.S. competitiveness, this would have a chilling effect on essential international science collaboration that extends far beyond China. So I would urge a no vote. People can vote however they want to vote. So voters on the Fishbach amendment, all those in favor say aye.
Aye.
Opposed, no, no, no.
No.
Be the chair, the noes have it.
Mr. Chair, I request a recorded vote.
Recorded vote has been requested. Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter.
Perlmutter is no.
Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon.
No.
Ms. Scanlon, no. Mr. Morelli.
Mr. Morelli is no.
Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler.
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Ms. Fishbach.
Excuse me.
It must be the
Just
coldness.
decided to cough at the exact wrong moment. Mr. Chair, I have an amendment to the rule. I move that the committee make an order amendment 198 to HR 4521 offered by Mr. Curtis of Utah. This amendment requires a report on how U.S. taxpayer money has benefited China. Mr. Chairman, if the House is going to pass a bill chock full of American tax dollar giveaways to China, the least the American people can expect is a full understanding of how their hard-earned dollars have benefited China. This seems like common sense, good governance to our taxpayers, so that our taxpayers can know if their dollars have further contributed to China's abhorrent human rights abuses, continued IP theft that harms American innovation, or towards adversarial military advancement. I urge adoption of my motion and I yield back.
You heard the gentleman's amendment. Any discussion? Hearing none, the voters on the Fishbach amendment. All those in favor say aye.
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 No, no.
No.
Be the chair, the noes have it.
And Mr. Chair, I request a recorded vote.
The vote has been requested. Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter.
Perlmutter votes no.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon.
No.
Ms. Scanlon, no. Mr. Morelli.
Morelli's no.
Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler.
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman,
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chair, I have an amendment.
Ms. Fishbach.
Mr. Chair, I have an amendment to the rule. I move the committee make an order amendment 113 to HR 4521 offered by Ms. Stefanik of New York. This amendment prohibits institutions of higher education that maintain a contract with a Confucius Institute from receiving any federal funds. Mr. Chair, once again, it is extremely disconcerting. A bill aimed at being tough on China instead ensures they can continue to fund propaganda institutions within their nation's system of higher education. This amendment will ensure that these institutions that unduly favor China and set forth agendas favorable to the Chinese Communist Party are not funded by American taxpayer dollars. Ultimately, this amendment deserves a full debate on the floor. I urge adoption of my motion and I yield back.
You heard the gentleman's amendment. Any discussion? If not, the vote is on the Fishbach amendment. All those in favor say aye.
Aye.
Opposed, no, no.
No.
Being the chair, the noes have it.
Mr. Chair, I request a recorded vote.
Recorded vote has been requested.
Mrs. Torres.
No.
Torres, no. Mr. Perlmutter.
Perlmutter votes no.
Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Miss Scanlon.
No.
Miss Scanlon, no. Mr. Morelli.
Morelli's no.
Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Miss Ross.
No.
Miss Ross, no. Mr. Neguse. Mr. Cole.
Aye.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Rushenthaler.
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Members not agreed to. Are there any other amendments?
Mr. Chair, I have an amendment.
Okay, another amendment. Okay, Ms. Fishbach.
I've been waiting all day. Mr. Chair, I have an amendment to the rule to make an order amendment number 1 to HR 4445 offered by Mr. Fitzgerald of Wisconsin. This amendment requires any monetary relief from a court case involving sexual harassment or sexual assault to be paid to the plaintiff before the payment of costs or attorney's fees, and limits attorney's fees to a reasonable percentage of the recovery. Mr. Chairman, this amendment would help ensure that the plaintiffs in a sexual harassment or sexual assault case are the ones receiving the bulk of the financial compensation rather than favoring their attorneys. The amendment would also require that the amount of the recoverable attorney's fees not exceed a reasonable percentage of a victim's direct recovery, and that in no event could a lawyer receive more money than the plaintiff. If we want this legislation to truly help the victims of these horrible crimes, then we need to make sure that they are the ones receiving the compensation they deserve. Thank you, and I yield back.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Fishbach amendment. All those in favor say aye.
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 No, no.
No.
The noes have it.
No.
And you want a
And-
roll call vote?
Yes, I request a recorded vote.
Clerk will call the roll.
Mrs. Torres.
No.
Mrs. Torres, no. Mr. Perlmutter.
Perlmutter votes no.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Miss Scanlon.
No.
Miss Scanlon, no. Mr. Morelli.
Morelli is no.
Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Miss Ross.
No.
Miss Ross, no. Mr. Neguse. Mr. Cole.
Aye. Aye.
Mr. Cole, aye. Mr. Burgess. Mr. Rushenthaler.
Aye.
Mr. Rushenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 4 nays.
Members not agreed to. Any other amendments? Hearing none, the vote is on the motion from the gentlewoman from North Carolina. All those in favor say aye. Aye.
Aye.
Aye.
All those opposed say no.
No.
Being the chair, the ayes have it.
Chair, on that, request a recorded vote.
Recorded vote has been requested. Clerk will call the roll.
Mrs. Torres.
Aye.
Mrs. Torres, aye. Mr. Perlmutter.
Perlmutter votes aye.
Mr. Perlmutter, aye. Mr. Raskin.
Aye.
Mr. Raskin, aye. Miss Scanlon.
Aye.
Miss Scanlon, aye. Mr. Morelli.
Morelli votes aye.
Mr. Morelli, aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier, aye. Miss Ross.
Aye.
Miss Ross, aye. Mr. Neguse. Mr. Cole.
No.
Mr. Cole, no. Mr. Burgess.
Votes aye.
No, you don't.
Votes no. Votes no, sorry.
Mr. Burgess, no.
I'm
Mr.
correcting you.
Rushenthaler.
No.
Mr. Rushenthaler, no. Mrs. Fishbach.
No.
Mrs. Fishbach, no. Mr. Chairman.
Aye.
Chairman, aye.
Clerk report the total.
8 yeas, 4 nays.
And the motion is agreed to, and Ms. Ross will carry it for the Democrats.
And Ms. Fishbach will carry it for the Republicans, Mr. Chairman.
Thank you all very much. Thank you for your patience, especially with the delay, and I'm going to work on getting the room heated better for you. So, anyway, but thank you. And with that, without objection, the Rules Committee is adjourned. Okay. So should I get them? Is it better for me to get them on this computer or no?
Yeah,